Yes.
Your Lordship, may I permit it, Your Lordship?
2 days left. No inclusion. Come after.
Lordship, 9th January delivery position date fix holo. Extreme urgency, Your Lordship.
Move after the vacation.
Item number 158 of your lordship's list, my lord, of 41 matter that it takes up this side of vacation because, my lord, the order of injunction in a suit amongst the co-sharers has been vacated on the ground that the plaintiff has not disclosed the notice issued by
Item
KMC.
158.
158.
150 tomorrow specially fixed. Tab of the
58. 158.
yes.
May I be permitted to mention one matter in today's list? It is item number 151. Lordship, there's an injunction order passed against my execution decree in a fresh
is not
suit
an
by the
urgency.
opposite
Come back
party.
after the vacation. Sorry.
Lordship, the learned court below has
No,
passed
no,
the
no.
premise that the NSA is transferred.
Yes.
This current appeal is against a matrimonial decree dated 26th of August
Inclusion for inclusion in the list.
for admission in the list.
Not right now. Yes.
May I be permitted to mention a contempt application, Your Lordship?
After vacation.
Lordship.
My lord, with the leave of Honorable Justice Supratim Bhattacharya, I may be permitted to mention a review pertaining to the list and determination of Honorable Justice Shubhashachi Bhattacharya and Honorable Justice Uday Kumar. My lord, the
Mention after the vacation. Before vacation, it's not possible to sit for us.
my lord,
Please mention after the
My-
vacation. Yes.
May I be permitted to mention one matter, Your Lordship? The appellant is praying for extension of time. Second appeal was dismissed, and by
Extension of time for what?
for appellant supposed have to vacate the one tenanted room by an order dated the
Come back after the vacation.
Your Lordship, by on 31st December, the appellant has to vacate the vacate the one tenanted room. So, Your Lordship,
What are you mentioning? This is in the list.
no, this is not in the list. The
mention
made
earlier.
application to for extension of time, Your Lordship. Praying
Extension
for
of time or interim order.
no, the second appeal was dismissed, and
So pray for that before the executing order. Sorry, no.
Your Lordship.
No, not right. Call on the list.
May I be permitted to mention?
No further mention. Yes.
I have to respond.
Accordingly, MAT 137 of 2025 is allowed on contest, thereby setting aside the impugned judgment dated August 23, 2024, passed in WP such and such, and allowing the writ petition partially by passing the following directions. The collector under the LA Act, within bracket, if already rendered defunct by dint of repeal of the LA Act, the collector under the 2013 Act shall act as collector under the LA Act for the limited purpose of carrying out this order. Shall make an inquiry in terms of Section 11 of the LA Act with regard to the acquired plots of land of the writ petitioners, present respondents, and for such purpose shall give adequate opportunity of hearing to all persons interested, including the writ petitioners, present respondents. Thereafter, the collector shall declare an award in terms of Section 11 and 23 of the LA Act, read with proviso B of subsection 1 and subsection 2 of Section 8 of the LDP Act, upon determining compensation payable by applying the yardsticks as laid down therein. For such purpose, the market value referred to in clause 1st of Section 23(1) of the LA Act shall be deemed to be the market value of the land on the date of publication of the notification under Section 4(1) of the LDP Act for the notified area in which subject plots of land are included, that is May 19, 1950. If such market value exceeds by any amount the market value of the land on December 31, 1946, on the assumption that the land has been at that date in the state in which it is in fact was on the date of publication of this notification, the amount of such excess shall not be taken into consideration. When the amount of compensation has been so determined by taking into account all the components as provided in Section 23(1) of the LA Act, the collector shall make an award in accordance with the principles set out in Section 11 of the LA Act. In addition to the market value of the land as enumerated above, the collector shall award a sum of 15% on the market value so determined in consideration of the compulsory nature of the acquisition. Entire exercise as directed above shall be concluded at the earliest, preferably by April 30, 2026. The total amount of compensation so determined, including the amount stipulated in clause Roman 6 herein above, shall be disbursed in favor of the writ petitioners, present respondents, after deducting the 80% of estimated compensation already paid to Anukul Chandra Ghosh, the predecessor in interest of the writ petitioners respondents, on August 21, 1956, within a month of declaration of the award. Can 2 of 2025 is consequentially disposed of. Urgent certified copies.
ডিসমিস হয়েছে সুপ্রিম কোর্টে এক কপি নেই দিয়ে দিল।
কত নম্বর
এইটা
What number?
Yes.
I appear for not the appellant in some of the matters and respondent in the other matters, not appeals and not counter appeals. Covered by your lordship's judgment in another matter where your lordship fixed the quantum 5,52,000 per kata and remanded the matter for calculation of the interest for the period they have taken possession. So amount has been fixed. I am asking for the same order, my lord. Only your lordship adjourned on the last day because not two cross appeals were filed, numbers were furnished on the last day.
Yes.
Though
So,
the appeal-
have you got a copy of the previous judgment?
Yes, my lord.
You gave on the last
After
occasion,
gave,
right?
I still have.
Yes, that was Shuddhananda Basu, that case. Yes, it's already on record. Very good.
কপি
My lord, I supplied one chart with containing all the case numbers and what are the corresponding number.
দেখো তিন
And I'll file one more chart because students, the numbers have changed. So that chart will not be not the same today. I prepared the chart as per
Why
the
didn't you
serial-
prepare the chart as per the FA number?
serial
FAT number?
As per, I'll prepare as per the FN number.
Do it as per the FAT number, file it during the course of the day.
may I tell you?
Yes, Mr. Shen.
My lord, so far the earlier, my lord, the cross appeal or my lord, the appeal filed by them, my lord, those are because in 2022, my lord, those are not with my lord, line with the department's file. Now, my lord, so far my lord, the another cross appeal filed on Monday, my lord, the copy served up last Friday afternoon, my lord, that is coming, my lord, appearing serial number 3 and 4, my lord, cross appeal in my lord FAT 273 of our appeal and FAT 274. Now, my lord, in my lord, I want to file my lord objection, my lord, or my lord, the affidavit, my lord, because of the fact, my lord, these two cross appeal, my lord, it should have been filed, my lord, within my lord 1 month, as per my lord, order 41, rule 22, within 1 month from the service of notice. Now, my lord, here, lordship, kindly have a look, just a minute, please. Now, my lord, so far, my lord, item number 3, my lord, FAT 173 of my lord 2020, there, my lord, it appears that, my lord, an order was passed, my lord, on 11th of May 2023. Now, my lord, whereby, my lord, this court was kind enough to pass an order that respondent directed to prepare requisite number of informal paper printed otherwise, then, my lord, within 6 months. And, my lord, it appears that all formalities regarding preparation of paper book are dispensed with. And, my lord, the service of notice also, my lord, notice of appeal upon the respondent dispensed with. So when my humble submission is this, on 11th May 2023, notice of service dispensed with, they appear. That means, my lord, that was complied with. That from the date of my contention, from 11th May 2023, within 1 month from 11th May 2023, cross appeal should have been filed. As per my lord, order.
This is in regard to COT 178 of 2025
Well,
and
this is-
177.
This is my lord, just a minute. এক মিনিট কথা কেন বলো?
Give the COT
My lord,
numbers.
this is my lord with regard to
Give the COT numbers, Mr. Shen.
COT 178 of 2025.
And 177 also
My
similar.
lord, 177, here lordship order was, similar order was passed on 21st April 2025. Almost similar order.
Give us copies of both the orders. Those orders which you are
My-
referring to.
My lord, দাও তো এইগুলো কপি বার করো না একটু। এখান থেকে একটু খুলে দাও আস্তে আস্তে। এখান থেকে একটু খুলে দাও দুটো order। কেন আমি তো বলেছিলাম কপিগুলো সব রেডি রাখতে। তো দিন আমাকে। দিন, দিন। এটা 274। আরেকটা 274 দিন। সব সাজিয়ে রাখেন না কেন যখন বলি? My lord, this is my lord one copy in 274 and this is my lord another copy in 273. এটা কত?
273.
একটু ম্যাডাম এটা মিলিয়ে নিন 273।
274.
ওই অর্ডারটা দিচ্ছেন?
হ্যাঁ। $274.
273 and 274. Very well.
Almost the similar order, but the date was different.
Learned counsel appearing for the appearing for the land losers submits that since similar orders were passed in the other appeals in connection with the same land acquisition proceeding, comma, and the principles involved in both in all the appeals are the same, comma, let let the present appeals and cross objections be disposed of in terms of the said judgment dated May 8, 2025, passed in FAT 3 of 2019 and FAT 516 of 2019. Full stop. Next para. Copy of the said judgment is handed over in court today. Full stop. Next para. Learned counsel appearing for the state. Learned senior. Your AGP, Mr. Shen. AAG. Learned AAG appearing for the state submits that with regard to COT 178 of 2025, which arises out of FAT 273 of 2020, by an order dated May 11, 2023, passed in the appeal bearing FAT 273 of 2020, orders had been passed, which ought to be construed to be the date on which the respondent had notice of the appeal. Thus, it is submitted that the cross objection bearing COT 178 of 2025, having been filed beyond the statutory limitation period after the said notice, is time barred and ought not to be entertained. Next para. Similarly, with regard to COT 177 of 2025, the connected appeal bearing FAT 274 of 2020 had been taken up for hearing by this court, and in the presence of the respondent land loser, by an order dated April 21, 2025, necessary directions were passed. Thus, similarly, April 21, 2025 should be the date on which notice of the appeal should be deemed to have been served on the respondent. Thus, the connected cross objection bearing COT 177 of 2025 arising out of the said first appeal, also having been filed beyond the limitation period, is time barred and ought not to be entertained. Next para. In view of the above submissions, we reserve judgment. We conclude the hearing in all the appeals and the cross objections. Next para. The matter is reserved for judgment. It is made clear that the objection as to the cross objections bearing COT 177 of 2025 and COT 178 of 2025 is kept open for being decided along with the matters.
Only one thing, item number 16, my lord, we gave the number on the last day. It's appearing with the wrong number. We have given number FAT 265 of 2020.
Item number 16 is my matter.
336 has been listed. By mistake, it has come, my lord. It should be, my lord, FAT
16
আমাদের
265 আমরা কত দিয়েছি
15 অবধি।
16.
মানে we appear up to 50
State versus Sheila Mukherjee.
মানে we appear up to
State
50
FA 336 of 2025. What is the connected? This is FA number.
Item number 16 appearing in the list.
16 is FA 336.
Wrong looted. Probate proceeding.
16 wrong.
Number is,
Siddhartha Mukherjee.
it is not a connected matter, my lord. By mistake, it has come.
FAT 265 কি mentioned এই লিস্টের মধ্যে ছিল?
Yes, yes. FAT 265?
না না পাশ থেকে বলছে wrong matter এটা দেখো
FAT 265 is now FA 336. So FAT 265 of 2020 yes, FAT 265 is a different matter, Mr. Ali's matter.
The wrong number was given.
So next para. However, FA 336 of 2025, which arises in connection with a different matter, is hereby dissociated from the other matters and shall go out of the list. বাকি ম্যাটারগুলো পাঠিয়ে দেবেন। হ্যাঁ, it is
hearing concluded
Hearing is concluded because that's on the judgment. But regarding this COT, we have kept it open. We'll consider that. And please give that list. Acha, একটা line add করুন. Learned counsel for the land users in all the matters submits that he will file a chart of the matters indicating the interconnectivity between the matters. So let such chart be filed during the course of the day. ওটা দিলে ওটা ঢুকে যাবে। দিলে পাঠিয়ে দেবে।
In the other matter, your lordship permitted us not to withdraw the amount which was deposited already because the amount is now higher. In this other matter, Shraddhananda Basu, your lordship permitted us. I am praying for similar leave, my lord, to withdraw the amounts that they have deposited in those
Where
matters.
is that application?
The
Now the
application
appeal
is
is disposed of. While disposing of the appeal,
আচ্ছা একটা লাইন আরেকটা লাইন অ্যাড করে
permitted
দাও।
us.
Before parting with the matter, comma, the submission of learned counsel for the respondent land losers be noted to the effect that upon disposal of the appeal, comma, subject to the disposal of the same, comma, appeals, comma, the amount deposited you had they had
State has deposited.
the amount deposited by the state be permitted to be withdrawn by the land losers. Full stop. You have just recorded his submission, will consider open read.
Number 17, we have submitted our written note. Today was fixed for serving
we
a
are-
copy of the written notes, my lord.
No, we had to file our notes, my lord. It's ready, my lord. I'll file, my lord. Kindly give me, my lord, 15 minutes time.
Let the matter be listed tomorrow.
My lord, instead of tomorrow, my lord.
No, tomorrow.
Tomorrow.
On the
I'll
prayer
file.
of the state.
Fine.
Only filing written notes.
My lord, if they
No,
not
no,
supply us the advance copy, my lord.
Give a copy today.
Item number 18.
My lord, for the appellant, my lord.
When does it expire? The
30th November, my lord.
30th, it has expired. You mentioned before that.
No, my lord, I filed the application after that.
What is the nature of the
My lord, the writ court order for.
what
ordered us
sort of
to-
stay was passed?
My lord directed for mediation, my lord.
Failed.
That's why it failed, my lord.
The special officer was appointed by the judgment of the Honorable Single Judge, my lord, to take possession and hand it over to us, my lord. That was, my lord, in the background of that matter, your lordship directed that both of you go for mediation. Mediation has failed, my lord. This order was there till 30th of November, my lord.
This order restrains you from taking over possession.
Yes, my lord. This order restrains the.
Will extend for a limited period, Mr.
Only for limited.
Limited period. Limited period. The interim order granted earlier is extended till February 15, 2026 or until further order, whichever is earlier. Full stop. The matter be listed for hearing in the monthly list of January 2026.
Great.
Thank you.
Item number 19.
Sorry, my lord, I filed kind 3, my lord, for extension of interim order, my lord.
Item number 19.
My lord, item number 19, I am led by Mr. Chatterjee. He's
My lord,
appearing.
item number 19, my lord, I'm appealing for the respondent in this matter.
Yes.
My lord, at our behest, this has come up. My lord, what happened, my lord, this appeal, my lord, is not
appellant.
maintainable.
Who is
My
for
lord,
the
we have put them on notice, my lord.
Where is the notice?
My lord, on the last occasion, they appeared.
But there is a reason why they might not want to appear.
Mentioning out of turn, it has to be given a note. They have to.
No, my lord, they were there.
When the mentioning happened.
Absolutely, my lord, on the first occasion they were there.
No, there's a notice also, subsequent notice. Yes.
Yes, my lord, if your lordship sees, my lord, that the appeal itself is not maintainable.
Why do you say that, Mr. Chatterjee? What is the appeal
My
against?
lord, in a misappeal, an injunction order was passed, which was challenged, my lord, before your lordship. Our full bench says, my lord, that it's revisable and not appealable.
Yes.
And I don't need to even show your lordship that. Your lordship knows it better
No, the
than
order
me.
was passed in a misappeal.
In a misappeal. The injunction, my lord, was passed in a misappeal.
Misappeal.
In the misappeal, they filed an application for injunction. That application for injunction, my lord, an order was passed. And against that, they have preferred an appeal.
You have not yet admitted the appeal. We admit the.
Your lordship has admitted the appeal, passed an interim order. My lord, unfortunately, my lord, it probably skipped my lord's mind. And by the interim order, my lord, my business has been stopped.
Let us see the memorandum.
My lord. Kindly looks to my lord's order, my lord.
The miscellaneous appeal was against what? The miscellaneous appeal before the.
Against an order 39 rule 4, my lord, that we had filed because our things were, my lord, stopped by the interim order that we had got.
Yes. An affidavit of service filed today be kept on record. Full stop. Next para. Despite service, comma, none appears for the appellant at the time of call. Full stop. Learned senior counsel appearing for the respondent submits that the appeal is not maintainable, comma, since it has been preferred against an order passed itself in a miscellaneous appeal arising out of an order passed on an application under Order 39 Rule 4 of the Code of Civil Procedure. Push up. Next para. One second.
Caveat was there.
Yes.
That would have come out if merits were gone into, but taken.
Yes. Push up. There is substance in such contention. Push up. By a composite reading of the provisions of Order 43 of the Code of Civil Procedure, read with Section 104 thereof, comma, it is the clear position of law that no further appeal lies from an appeal preferred under Order 43 of the Code of Civil Procedure. Push up. Since the present appeal itself arises out of an order passed in an appeal under Order 43, Rule 1 of the Code of Civil Procedure, comma, the appeal itself is not maintainable. Full stop. Accordingly, comma, FMA 1569 of 2025 is dismissed as not maintainable without any order as to cost, comma, consequentially disposing of all the connected pending applications. Full stop. Next para. The interim orders, comma, if any, stand vacated. Full stop. Leave is granted to the appellant to prefer an appropriate challenge against the impugned order before the proper forum. Full stop. For such purpose, comma, liberty is granted to the learned advocate on record for the appellant to take back the certified copy of the impugned order from the memorandum of appeal from the department of this court upon furnishing a photocopy thereof. Thank you. Next.
Grateful to your lordship.
Grateful.
Thank you.
My lord, I am appearing for the appellant. My lord, there may
I am appearing on behalf of the private respondent number 11 and 12.
there may be some defect in the appeal, my lord. It is said that the classification is written on words, my lord.
We'll give you liberty to correct that. Let us see just. This is an appeal against what?
Appeal against the order of the single bench, my
Single.
lord. My lord,
Oh, you have stated in appeal from an order passed in its constitutional jurisdiction and all this. Please, we'll give you leave correct during the course of the day.
yes, my lord, it's a writ court's order, single bench's order.
Yes, an appeal from an original order.
Yes,
That should be there in the caption.
sure, my.
So any other, we'll just check up with
My
it.
lord,
Only.
the impugned order is
Very well. We'll please carry out the correction during the course of after the matter is over. Leave is granted to the learned advocate on record for the appellants to carry out the necessary correction in the caption of the memorandum of appeal by correct classification of the appeal, comma, during the course of the day. Yes, what is the appeal about?
My lord, it's at page 24, the order. My lord, it's a relevant page 30. My lord,
You can please refer to the internal pages of the order. We are following from the memo.
yes, my lord.
Internal pages of the order.
Yes, my lord. Just it's internal pages, my lord. It's my lord. I will read the relevant portion. It's paragraph number 11 and 12.
11, 12. Yes, 11, 12. Just give us a backdrop of
Yes,
the
my lord, what has happened? This is an appeal under section 10(4) of the West Bengal Highways Act. There was an appeal. My lord, the district magistrate, by passing an cryptic order, giving no reasons at all in the order, has dismissed our appeal, my lord, under section 10(4). Against that, we had preferred an writ petition in this court. However, the single bench, honorable single bench, has held no, there was sufficient reason. My lord, let me allow me.
Firstly, yes, as you are placing. 11, 12, and then we'll go to that order.
Yes, my lord. On careful perusal of the order under challenge dated 5th June 25, as passed by the respondent number 2 authority, it appears to this court that the respondent number 2 authority assigns sufficient reason for placing reliance upon the demarcation report as submitted by the jurisdictional BL and LRO. It further appears that the respondent number 2 authority duly found that the said report of the BL and LRO, the writ petitioners are found to be encroachers, and thus by assigning sufficient reason, he finds no reason to interfere with the order of eviction as passed by the respondent number 3 authority.
Very
As rightly pointed out, my lord, so therefore the honorable court holds that
Let us
there is
now see that
sufficient
order.
reason.
Now let us
So
see.
my lord, now kindly takes page 131, the DM's order. My lord, in a little background, my lord, I must say the encroacher's land is both into a private land as well as government land. So there was a demarcation, proper demarcation required is into which portion is actually in the government's lands, because whatever proceeding will be in 10-4, that will be in reference to government land. That cannot be in reference to the private land, my lord. Now, my lord, kindly takes, my lord,
Private land belonging to you or somebody else?
somebody else, my lord. Private
All right.
land belonging
Even
to
then,
somebody
even then,
else.
even then, yes.
My lord, this is the order, my lord. Here, may I read the order? It only records whatever submissions has been made by the BLLR.
Let us just see the order once.
Yes, my lord. May I read?
Please.
The appellants number 1, 2, 4, 5.
You can read from peruse the order.
Yes, peruse the order dated 6 January 2025, passed by Subdivisional Magistrate Tumlu in the proceeding, bearing number such and such of West Bengal Highways Act such and such. As per, now my lord, the next sentence. As per provisions of the said act, the assistant engineer Holdia Construction Subdivision number such and such issued notice under section 10(1) of the said act in compliance with the order dated. There was a High Court's order previously. High Court's order dated such and such, and after being satisfied with the report of BLLRO Nondigram 3 that there are encroachment on government land bearing plot number such and such, Chondipur in favor of Public Works Department, Government of Wizard. Now, my lord, here
So have you given notice to the authorities, the state authorities?
affidavit of service.
Just file that, please. You just check up whether it has been served on the state. Good service?
Yes, my lord, to the GP.
Yes. Just file that also.
Yeah.
The other. Yes, please continue where you stopped.
Now, my lord, kindly see that here the satisfaction of Assistant Engineer Holdia Construction for issuing of notice 10(1) has been recorded. This is not the reasoning of the district magistrate here. Here, my lord, kindly takes, and here the sentence is, as per provisions of the said act, the assistant engineer such and such issued notice under section 10(1) of the said act in compliance with order dated such and such, and after being satisfied with the report of BLL or Nondigram, they are there. So this is an satisfaction of the assistant engineer therein is recorded, my lord. It's not the DM satisfaction. My lord, it will be more clearer, because in the second paragraph, he keeps on stating the submissions of the parties. He did not deduce any conclusion, and after being satisfied of such and such, I am of the opinion.
Let's see. Yes.
So, my lord, it's like learned advocate on behalf of the appellant stated that they have filed their appeal petition being aggrieved and dissatisfied with the order dated such and such, passed by the subdivisional magistrate, Tumluk, proceeding such and such. Had also filed a writ petition such and such in the matter of Shahdeb Singh and others versus State of West Bengal, in which the Honorable High Court, in its order dated 22nd April 2025, directed the district magistrate to dispose the said office as preferred by the writ petitioner within 60 working days. Now, my lord, this is only the contention of the appellant hearing has nothing been recorded, only the appearance and whatever was the outcome in the.
But the district magistrate relied on a report given by the BLNL.
True, my lord.
Now, what else could be done?
My lord, it is not.
What was your challenge, ground of challenge?
It was the demarcation was not appropriately done. The BLLR report is on the maps, my lord. But my lord, whatever I have to demolish, there should be a clear demarcation done of that. So that was not
Did
there.
you
my
file
lord.
any alternative documents to rebut this presumption of the BLR report before the before the district magistrate?
No, my lord.
Then,
Nothing.
then this is one of the plausible views taken, and a BLR report was there. Nothing to rebut that. Relying on that, this is not a judicial order as such. It is a quasi-judicial. At best, quasi-judicial, because your consequences are severe against you. Understood. But still, then there was only one report of the BLR. Magistrate relied on that. And where is the? If you start interfering with these, then there wouldn't be any orders under section 10(4), and these are of summary nature also. We don't find any illegality, and this is now we are sitting in an intra-court appeal. Learned single judge took a plausible view that the district magistrate took a plausible view. And relying on the only document before it, which is a BLLA report, there is presumption of correctness. Unless rebutted, we don't find anything. Sorry.
My lord, absolutely nothing is there. My lord, it's
Nothing
after
else is
considered-
required. He relied on the report. That report is by the BLLA. There is nothing to rebut that.
My lord, he wants to say something. My
Even
lord.
he cannot rebut that now.
My lord, whatever my colleague has said, I accept that. Only one additional submission and then I leave it. to your
Yes.
lordship. My lord, kindly comes to page 107. I have understand what is playing through the mind of the court. Lordship is absolutely correct. If there is nothing, my lord, from my end, possibly this is correct. But I want to show from their, my lord, own document that this observation possibly could not have been made. Kindly comes to page 107, which is the, my lord, field verification report, which was relied upon by the, my lord, SDM, being the first authority. My lord, 107, first paragraph concerns, my lord, the appellants here. In consonance with subject noted above and compliance of your kind direction passed in the order dated so and so. 107, sir.
107, 107.
This is to inform you that Sheikh Zakir Hussain, my lord, the names I am not reading.
These are you.
These are the appellants, my lord, here. Encroached PWD land of plot 901 LR of Mouja, Kolikahali, jail number so and so, measuring area 155 square feet approximately. Nothing else is mentioned. My lord, kindly takes the next paragraph. During physical inquiry, it also appeared that Bapi Dondopat and 9 other persons occupied PWD land over the subject plot, unauthorized, which is reflected in color sketch map. In this regard, joint field verification report, LR, ROs and color sketch map are sent herewith for favor of your kind information and necessary action. Kindly comes to 109, my lord.
Yes.
My lord, right hand side at the foot of the page, lordship will find encroachment area 2660. This is relating, I relate this with the second paragraph of 107. Left hand side 154 square feet is mentioned. My lord, there is no demarcation, my lord, as such in this document. Now kindly sees the SDM's finding, my lord, which is at page 110.
Yes.
My lord, third para. Pursuant to the order dated 19 December 2024, BLRO Chondipur submitted detailed inquiry report with hand sketch map on government land. This is the document I just showed. Plot number so and so, dated so and so. From field inquiry report of BLRO Chondipur, it appears that Sheikh Zakir Hussain encroached 24 square feet. Now, this, my lord, finding of the SDM is not reflected, my lord, in the field verification report. Then I read on, my lord. Shamol Das, son of Monoranjan, encroached on 19 square feet. My lord, and this goes on, my lord, for all, each of the, my lord, persons. So my point here is...
Those are reflected in at page 108. 108, paragraph 2.
My lord is looking at page 108
of your document. The page after
the opponents, namely Zakir Hussain so and so, encroached on 19
areas
square
are given
on 24 square feet. Shamol so and so.
as per details of the survey. This is only a hand sketch map to support that. But on a detailed survey, he says that these have been found. The specific areas are given. This is not a reappreciation of fact finding here.
My lord, then the only other point which my colleague was, my lord, saying that it is, my lord, affirming the view without giving any reasons.
Reason has been given the report.
By not by the, my lord, appellate authority, because appellate authority's order was under challenge. Lordship sees the language of the appellate authority, my lord.
Appellate authority held that the first authority subdivisional magistrate was justified in relying on the report, and that's why did not interfere. That is a valid appellate authority. It's well
as
said.
Appellate authority, whether it was incumbent.
Appellate authority, no, it is not incumbent. You know that appellate authority need not repeat whatever was said by the first authority. Appellate authority need only to affirm, and sufficient reason has been given. This is not a judicial order. Sorry, sir.
Very well, my lord. Then I'll not.
My lord, only one prayer. My lord, maybe I first apologize. Both
No,
of us.
carry on. Yes.
My lord, only one prayer. My lord, as per the scope of the Highways Act, it is for the petitioner or the appellant to demolish which is part of the area constructed or encroached. Now, that's the scope of the act, my lord. First, the notice is given that you vacate the land and then demolish the thing. Now, my lord, that liberty is given here because, my lord, what I am saying, since a part of the shop is in the private area and the part of the shop is in the government area, what the petitioners are apprehending or the appellants are apprehending, that there might be a demolition of the entire shop rooms, or that protection may be given.
You are not bothered because that is also an encroachment on another person's land,
Well, that
not
that,
your land.
well, that
So they may be concerned.
they may,
Let them be concerned. Let them come up.
it's my shop. I am it's my
It's
livelihood.
encroached land, so no difficulty.
That
No.
by the due process of law, my lord.
Due process of law will say due process of law.
No,
It
my
may
lord.
be ensured that these orders are implemented in due process of law. We'll say that. We will not go further. How can we? Due process of that may help you somewhere. Whatever that means. Anyway, the present challenge has been preferred. It's a privilege to have advocates argue before you who know where to stop. It's becoming a privilege every day for us. This is a praise, I mean, for you. The present appeal has been preferred against an order passed by a learned single judge, whereby the learned single judge has affirmed an order passed by the district magistrate, Purvo Medinipur, thereby, in turn, affirming an order passed under section 10 within bracket 3 of the West Bengal Highway Act by the subdivisional magistrate, Tomluk, Purvo Medinipur, being the first forum under the said act. Which of next para, learned counsel appearing for the appellants argue that the learned single judge mechanically affirmed the order of the district magistrate. However, the district magistrate did not advert to any of the arguments of the appellants, nor gave an independent consideration to the materials on record and the findings of the subdivisional magistrate before affirming the order passed under section 10 within bracket 3 of the said act. Next para, it is contended that the learned single judge failed to appreciate the fact that as the appellate authority, the district magistrate was bound to return his her independent findings on that of the subdivisional magistrate upon an independent inquiry into the report of the BL and LRO instead of mechanically affirming the order of the first forum. Next para, learned counsel for the appellants takes the court through the report of the BL and LRO dated January 16, 2025, wherewith a hand sketch map was annexed. However, it is submitted that although the order of the subdivisional magistrate apparently refers to specific areas of land encroached by each of the appellants, such intra-appellant demarcation is absent from the hand sketch map furnished by the BL and LRO. Thus, the findings of both the authorities not being in consonance with the BLLRO report itself, it is argued that the learned single judge ought to have set aside the orders of both the authorities. Such contentions are controverted by learned counsel for the private respondent. Next para, on a thorough scrutiny of the report furnished by the BL and LRO, we find that after the cover page, the first page of the BLLRO, in paragraph number 2 thereof, categorically mentions the exact portions of PWD land encroached by each of the appellants. Next para, the hand sketch map on the next page, is a mere supporting document, in order to reflect the areas of encroachment roughly. Next para, it may be noted that the said report and the hand sketch map was an outcome of a survey conducted by the BL and LRO. Next para, we further take note of the fact that no rebuttal document was furnished by the appellants before any of the forums below. Full stop. Next para, in the absence of any such rebuttal, comma, the presumption of correctness attached to official acts ought to go in favor of the report of the BL and LRO. Full stop. Even otherwise, comma, we do not find any palpable infirmity in the said report and the hand sketch map. Full stop. Next para, while passing their orders, comma, both the subdivisional magistrate and the district magistrate clearly referred to the report of the BL and LRO and, comma, placing reliance on the same, comma, passed necessary orders, coming to the conclusion that the appellants are encroachers on PWD land. Full stop. Next para, although the appellants have sought to argue that a portion of the land encroached is not PWD land but private property of third parties, comma, in the absence of any reflection of the same, comma, we have to proceed on the premise that the BLLRO, having demarcated the exact portions of PWD land encroached by the appellants, comma, the order will operate in respect of such encroached PWD lands only. Full stop. Next para. Otherwise, comma, however, comma, we do not find any infirmity or illegality in the order of the district magistrate or the learned single judge, whereby the order of the subdivisional magistrate, comma, relying on the BL and LRO report, comma, was affirmed. Full stop. Next para, we also have to keep in mind that we are not looking at orders passed by courts of law, but quasi-judicial orders passed by authorities. Full stop. The reason assigned by the authorities, comma, in our opinion, comma, was sufficient for not being interfered with by the learned single judge. Full stop. Next para, also, comma, within the constraints of an intra-court appeal, comma, we do not find any palpable perversity or patent error of law or fact in the order of the learned single judge. Full stop. Next para, however, comma, we make it clear that while implementing the orders affirmed hereby, comma, the respondent authorities shall ensure that due process of law is followed and no property apart from the encroached PWD lands are in any manner adversely affected. Full stop. Next para. In the light of the above observations, comma, MAT 2099 of 2025 is dismissed without interfering with the impugned judgment dated October 31, 2025, passed in WPA 14262 of 2025. Full stop. Consequentially, can 1 of 2025 is also disposed of, no arrest to cost.
May I file this learned second judge's copy affidavit of service? Great,
Thank you. Appearances, please just
Deeply obliged.
আচ্ছা আগেরটা কিন্তু মেঘনাথ স্টেটের কোনো অ্যাপিয়ারেন্স নেই, সেটা রেকর্ড করেছি। হ্যাঁ, পরে এসে মুছে দিলে ঢুকিয়ে দেবে, অর্ডারে রেকর্ড করো। ইয়েস।
My lord, item number 21.
I am led by
My lord, for substitution during pendency of that intercourt appeal.
Why was it mentioned as specially fixed? I mean, urgency ground, what is the urgency?
Whole matter, senior. The matter is pending from 2014.
It's a normal application.
Normal.
Oh, but specially fixed will have. Sorry, this is normal application.
This is
So don't get so perturbed, listen.
No.
This is an application for substitution within time.
No, no. My lord, the application for whom you are appearing.
Union of India.
My lord, Union of India has been served. State government is also served. State government is represented by its lawyer. She has also been served, but no opposition has yet been filed. Thing is very simple, my lord. That my writ application, the writ petitioner was Syed Fateh Ali Mirza. He lost the writ application, preferred an appeal. In the appeal, my lord, it was held by the division bench that writ petitioner is not entitled to maintain this writ application. He preferred an appeal by way of SLT before the Honorable Supreme Court. Supreme Court, my lord, after his death, during pendency of the SLP, he died. Fateh Ali Mirza died on 3rd of January 1998. After his death, my lord, the Honorable Supreme Court was pleased to pass the final order on 13th August 2014. That 13th August 2014 order is entitling me to make the application for substitution in the place and state of the deceased writ petitioner. Kindly come to that order and kindly come to running page 33. It's a order of the Honorable Supreme Court, my lord. Running page 33.
Yes.
My lord, the second paragraph, fifth line, we hold that the appellant Syed Muhammad Abbas Ali Mirza is entitled to step into the shoes of the deceased petitioner Syed Fatehabad.
It's 33.
Running page 33, internal page 16, my lord.
Internal page 16 of the Supreme Court order. This is some, we are looking at some other application.
All right, this is can number 104.
10141. 10141 আছে Hey, 10141 does not have so many pages. 640 has up to page 33. In our copy, can 10141, which has now become can 7, that has only up to, I mean, the main body of the application has up to page 16, and thereafter it's not paginated actually. So you can refer to the internal pages of the Supreme Court. What is the internal page? Internal page is 16. 16, all right. Very, we'll go there. Yes, you have got it. Please continue.
Lordship.
So, in view of the fact that appellant is son,
My lord,
lineal descendant,
in view of the fact that
then
the
readily
appellant
stated.
Syed Muhammad Abbas Ali Mirza is the son of Syed Muhammad Siddiqui Ali Mirza, who is a lineal descendant from the second son of the original Nawab. We hold that the appellant Syed Muhammad Abbas Ali Mirza is entitled to step into the shoes of the deceased petitioner Syed Fatehab Ali Mirza. Fatehab Ali Mirza was the original writ petitioner and the appellant before your lordship. After his death, my lord, this question of succession of his estate arose. My lord, ultimately the Honorable Supreme Court has held that my client, the petitioner, is only entitled to represent the writ petitioner as successor. My lord, immediately thereafter, my lord, this application for substitution is taken out on 25th of September 2014.
The death occurred during pendency of the writ petition itself.
No, SLP.
Appeal.
Yes.
Death occurred during SLP pendency.
Yes.
All right.
My lord, the Honorable Supreme Court's order, my
So
lord.
virtually this order, you say that this order, this is in the nature of an application for, I mean, you are substituted.
Yes.
In the
I should be
SLP itself,
substituted.
and
I
permitted to proceed with the
with the writ application, with the writ appeal.
appeal.
With the appeal.
With the appeal. But the appeal is allowed.
Appeal is allowed.
We allow civil appeal. What about this? We allow civil appeal 8129 while dismissing 8136.
That is against the order of Samsuddin division bench.
That was not, these appeals were not by you.
No, that
There are
is
two appeals.
There were two appeals by
But
Two groups. Their appeal was, your father's appeal was allowed.
Yes. And my lord, in the order of the Honorable Supreme Court, we allow my lord, after that as is legal error, so as to pursue the proceedings presently pending before the High Court. Consequently, we allow civil appeal.
But nothing was pending at that point of time.
Yes. We allow civil appeal number 8129 of 2009 while dismissing the civil appeal number 8130 of 2009.
What was pending before the High Court at that point of time?
My lord, this appeal was
Pursue the proceedings presently
2051.
pending.
Only 2051 where I sought to be substituted. My lord, that appeal is allowed to be heard after substitution. And there I am the petitioner.
But Supreme Court says that presently pending, did you challenge an interlocutory order in the appeal?
No.
The final order.
Yes. in the final order, my lord, this is with regard to the Murshidabad estate.
So
Nawab's
nothing was presently pending before the High Court at that point of time. We don't understand this order actually.
No, no, appeal was pending.
Appeal, how could it be pending? You challenge the order passed in the appeal.
lordship is correct. My lord, the appeal which my deceased client filed, Honorable High Court Division Bench held that you cannot represent the estate. You cannot have any right to maintain the writ application.
So you read this order to be a remand to the trial this court for hearing the appeal now on merits.
Yes.
And the ground on which this appeal was dismissed was that you are not
I
entitled.
am not entitled
Locus
to
standi.
no locus
But it was
standi.
held that you are entitled, lawful, legal, and so.
Yes.
So now we have
That's
to
why
hear the appeal on
matter has
merits.
come on remand
So this is a formal application only
for substitute.
for substitution.
Lord, kindly see the Lord order, Lord, on 4th of December 2017. Passed by Lord,
So,
Honorable.
first, you have finished. This is
Lordship.
for the substitution. only.
This was in, sir, order 10141. This is
10141.
ওটা আমাদের
No, no, এটা তো
ওটা তো আলাদা
অন্য।
That is another can for addition of party.
That was, I have my
মানে they
administrative
are
record has inspected the records, my lord. We find that several it is a very old matter. Only 2 applications, 2 can numbers are pending for disposal.
What is the other can?
Other is, my lord, my contestant who tried to be substituted and lost. He made an application for addition of party.
Is it stranger?
He is a stranger to the.
What was his premise of being added? So he's on.
He is a legal descendant of the Nawab.
He was represented before the Supreme Court.
Yes.
No. No, no.
No, he was not
Could not have
represented
been.
before the Supreme Court, my lord, but here, when the matter is sent for remand, he made an application being can number 2640 of 2018 to intervene in the appeal proceedings.
Bulletin, his elder brother came, but he lost. Bulletin, his elder brother also came.
So state's appeal failed and you won. How is the union involved here?
My lord, we have challenged the
Virus of the act.
highly of the
Central statutes.
my lord,
No,
it
it's
is a-
Virus of Murshidabad.
Murshidabad Estate
Management of
Management
properties
of
and
Property.
miscellaneous
It is a state act.
State Act.
Then
But there is some confusion, my lord, regarding the declaration of the National Monument and Archaeological Survey of India may be involved, my lord, in this case. Is it relating to, my lord, higher Duari, estate relating to that
Imambara.
Imambara and all these things. So, my lord, the union is
everybody in Murshidabad is almost an owner of that. Like the Rani Rasmani estate.
Here, my lord, the Murshidabad Estate Management and Properties and Miscellaneous Provision Act 1980 is under challenge.
Very well. So, yes, what do you say to this? Because the Supreme Court conclusively observed.
for hearing. After
No, the substitution application should be
substitution
allowed.
application, my lord, so far as substitution application is
Because
concerned,
Supreme Court categorically observed,
Yes,
Honorable
yes.
Supreme Court, that
but
they are
page 16
entitled.
clear. Page
As the learned friend rightly pointed out. So state is not represented today.
My lord, I am led by Lord and Advocate General. He is out of station, my lord. Kindly fixed for
Let him be out of station. We'll just
Appeal to fix.
allow the substitution application.
Last order to পড়িয়ে দিন।
As a 640 will keep pending, although it should 640 petitioner is present
640
before us.
petition is not my application, my
No,
lord.
but
It is
it's
taken
your
out by-
it's a competing claim against you.
Yes, yes. My lord, kindly see the prayer. My lord, leave is sought for to intervene in the proceedings.
Or addition of party.
So we'll keep that pending, that application pending. Yes, yes. And we'll just allow the substitution application and place the appeal for hearing after this.
Lordship.
Yes. Can 7 of 2014 within bracket old number can 1041 of 2014 is an application for substitution of the petitioner Syed SYED Mohammed Abbas Ali Mirza MEERZA. Push up next para. In brief, comma, a writ petitioner at the instance of late Syed Fateyab FATEYAB Ali Mirza, comma, the deceased the father of the present petitioner within bracket since deceased bracket
Not father,
closed
my lord. My lord, not father.
grandfather.
No.
The
Is-
predecessor in interest of
Yes.
the present petitioner within bracket since deceased comma was disposed of by a learned single judge, full stop, against the same comma, an appeal was preferred by the said predecessor in interest, comma, namely Syed Fatehab Ali Mirza. Full stop. Next para, the appellate, a coordinate bench of this court dismissed the appeal on the ground that the writ petition was not maintainable at his behest. Full stop. Next para, against the same comma, an appeal was preferred by the state as well as another appeal was preferred by the predecessor in interest of the present petitioner, namely Syed Fatehab Ali Mirza. Full stop. During pendency of the said special leave petitions, comma, Syed Fatehab Ali Mirza met his demise, comma, upon which the present petitioner, comma, namely Syed Muhammad Abbas Ali Mirza, sought to be substituted in his place and state as the petitioner in the SLP of Syed Fatehab Ali Mirza. Full stop. Next para, learned counsel for the appellant places reliance on an order dated
13th August 2014, my lord.
Thank you. Dated August 13, 2014, passed in the said matter bearing civil appeal numbers 8129 of 2009, comma, whereby the Honorable Supreme Court allowed civil appeal number 8129 of 2009 while dismissing the state's appeal bearing civil appeal number 8130 of 2009. Full stop. Conspicuously, comma, while so allowing the appeal, comma, the Honorable Supreme Court observed that it held that the appellant Syed Muhammad Abbas Ali Mirza was entitled to step into the shoes of the deceased petitioner Syed Fatehab Ali Mirza as his lawful legal heir so as to pursue the proceedings pending before this court. Full stop. Next para, notably, comma, notably, comma, upon the appeal being allowed, comma, the present appeal has revived. Full stop. Read in conjunction with the said observation of the Honorable Supreme Court that the present petitioner has stepped into the shoes of the original appellant, comma, the present application for substitution is a mere formality. Full stop. Next para, accordingly, we allow can 7 of 2014 within bracket old number can 10141 of 2014, comma, thereby directing the present petitioner, namely Syed Muhammad Abbas Ali Mirza, comma, son of late Syed Muhammad Sadek, SADEQEV Ali Mirza, and Hashmatun Begum, comma, residing at Nizamat, Murshidabad, comma, post office and police station and district Murshidabad, and also at 85, comma, Park Street, comma, Kolkata 7,16,000, comma, to be substituted in place and stead of the deceased original appellant, namely Syed Fatehab Ali Mirza, in FMA 2051 of 2023. Full stop. The necessary correction, the necessary amendment to the cause title of the appeal and the connected applications, cause title of the memorandum of the appeal shall be carried out by the learned advocate on record for the petitioner during the course of the day in the memorandum of appeal.
Lordship,
By tomorrow. Very well. By tomorrow. Full stop. Next para. Can 640 of 2018 shall be listed under the appropriate heading in the monthly list of January 2025.
Lordship, 8130 criminal appeal was preferred by Afsan Mirza, not the state as recorded. Lordship.
8130
The other appeal that was rejected.
8130,
page 10 of the Supreme Court judgment, page 10.
Afsan Mirza and others, not the state of West Bengal.
Page 10, my lord, first 3 lines. Insofar as civil appeal number 8130 of 2009.
একটা জায়গায় থ্যাংক ইউ একটা জায়গায় বলেছি ডিসমিসড বলেছি সিভিল অ্যাপিল নাম্বার 8130
Filed by the state college.
While dismissing. না না 2009
Filed by the state বলেছে।
ফাইলড বাই দ্য স্টেট কোথাও একটা বলেছে 8130 দিয়ে দেখুন 8130 দিয়ে কোথাও একটা না না 8130 নাম্বারটা কোথায় আছে আপনার ওখানে অর্ডারে দেখুন
Why dismissing the allow করেছে 8129 allow
8130 হ্যাঁ তারপর
bearing 8130 of 2009 conspicuously while so allowing the appeal the
না না আর কোথায় 8130 আছে আমি সেটা দেখতে বলছি 8130 affidavit is filed to the
Hearing of the appeal, my lord.
let that application come up then while taking up that application we'll decide when it goes to that
নামগুলো দিয়ে দিন
My lord, I appear for the respondent KMDA 2210, led by the learned advocate.
he's out of station yes sir.
I can come back after vacation if
on the prayer of the state comma on the prayer of the state comma
KMD.
on the prayer of the KMDA comma let the matter stand adjourned till after the upcoming winter Christmas vacation and be listed in the monthly list of January 2026
5 তারিখে হবে ওটা that is fifth yes
division bench sits only on from Mondays
Fifth, grateful.
Give the appeal
দিয়ে দিছো
My lord, in this matter, I appear for the KMDA.
So I'm
Here-
appealing for the Kolkata Municipal Corporation.
Here, though paper book has been prepared, but they are incomplete. The relevant documents are not annexed, included in the paper book. Some documents have been included, which are yet to be considered by the division bench.
paper book has been filed
Paper book has been served. I think.
দিয়ে দাও পেপার বুকটা কোর্টের কোথায় কোর্টের পেপার বুক কোথায়
দাও দাও some papers have included which are not which are yet to be
Mr. Banerjee some of the papers are included some are not
yes
so you please point out which papers are not included and which are
Lord, he is saying about this, my lord, that so far the writ petition is concerned. Lord, writ petition has been disposed of. Lord, a case on the part of the KMDA is that I have my client has.
So he says some of the papers we are not going into the merits.
Yes,
Some
Lord,
of the
may I tell
papers
you
are
what
not
why
extra
did
papers.
they are saying?
So resolve that issue first and then come.
First of all, resolve that issue. That is why I'm submitting. my lord.
We'll permit them to
The
put it.
writ petition was disposed of without exchange any affidavits, and therefore that petition was there, and some documents, additional documents have been filed in appellate court. Therefore, if I succeed,
Who filed
on
the
the
additional?
appellant
You filed in the appellate court by way of an application.
by way of an application.
That application itself, along with the connected annexures, then has to be incorporated.
Yes, yes, that application is there.
Yes.
That copy was served on them.
Is that correct?
Otherwise,
here-
Lord, everything is quite.
There
so
were
far the
Banerjee is saying
writ
that some
petition is there.
applications were filed along with the annexures before the appellate court for the first time. Those applications and annexures have also been filed.
And those are
They are
not in the
included.
paper book.
They can include that because those are before the appeal.
Yes, they are yet to be considered, but some papers.
What papers? Kindly
Some
tell-
papers, my lord,
Like-
used before the honorable single judge, my lord, have not been included in the paper book,
Lord,
which are I
We'll permit you to prepare a supplementary paper book incorporating those papers.
came
And
our
copy to-
our report affidavit.
Let
by
it
way of
counsel for the
affidavit,
KMD
they are
at the
exception.
outset.
No, that is there. It is a wrong.
Which page?
Incorrect submission.
Court is
my lord.
not there. Resolve
Lordship,
this
I
issue,
have
Mr.
not-
Banerjee. Court is not here to resolve these issues.
No, no,
My
that
lord,
is
counsel
right.
for the KMDA submits that some of the papers which were placed before the writ court have not been incorporated in the paper book, comma, which is disputed by learned senior counsel appearing for the appellant. Full stop. Next para. In order to resolve the issue between themselves, comma, the parties are requested to sit with each other and ascertain as to what are the exact papers which are omitted, comma, if any, comma, from the paper book. Full stop. Next para. In the event it is found that some papers are omitted, comma, liberty is granted to the appellant to file a supplementary paper book incorporating such documents. Full stop. Next para. Let the matter be listed in the monthly list of January 2026. Full stop. In the meantime, comma, the above exercise shall be completed by learned counsel. Please immediately today
Yes,
itself
I have
point
noted,
out to his advocate on record so that.
Yes, I have
And my lord, out of
Mr.
this, my
Banerjee,
lord-
your advocate on record will also ascertain that whether those are in some pages and they are missing out. So
Lordship.
then he can point out also. This.
Lordship, as per your lordship's judgment, my lord, order, my lord, it will be done. Lord, only with regard to 23, 24 and 25, they are municipal matters.
23 and 24 are appearing together.
24 and 25 are the municipal matters.
no. Both
Connected, maybe
up to 26 are connected.
23 and 25 land matter, 26 land matter.
So 23, 24, 25, 26 will direct all to appear together.
All appear together because, my lord, there was
We'll
an
direct all
order.
to, because
Lord, there was an order.
No, because we'll direct 24 to 26 to appear together. Then we'll do that.
Yes. Because two writ petitions, one pertaining to group 1, one pertaining to group 5 were disposed of by a common order.
6 I appear to state, your lordship.
Right. Let these এটা 23-24 order টা হচ্ছে, let these appeals be listed along with MET 2132 of 2024 and MET 2134 of 2024
ঠিক আছে তো।
on the returnable date.
And
Here,
so
here
far,
two appeals, one against the interim order
We'll
and
consider.
one against the final order.
Final order will be taken up, but all have to be disposed of.
Lord, final one appeal has been preferred against an interim order. Now, my lord, once the final order is passed, Lord,
Yes, we know that.
what will the- what will the final order?
Let us call on the next one.
Yes.
27.
Your lordship, I appear for the in item number 26 for the state, your lordship.
MD.
Will be listed together on the returnable date. Tag করবে। এখানে 25, 26 এ কিছু order হবে না।
বলে দাও না, কোন কোনগুলো আছে।
অর্ডারই রেকর্ড করবো।
বলে দাও, বলে দাও, বলে দাও।
23, 24 এই অর্ডারটা রেকর্ড করে ওই জন্য ওই নাম্বার দুটো দিয়ে দেয়।
এগুলো তাহলে জমা করে দাও।
25, 26 not today।
একবারে দিয়ে দাও।
হ্যাঁ,
একবারে করে দাও।
বুঝে গেলেন তো? 25, 26 not today হলো ওই অর্ডারে যেহেতু ঢুকিয়ে দিচ্ছে ওগুলো একসঙ্গে দিয়ে দেবেন।
My lord, therefore, I shall file a supplementary affidavit.
No, first sit to your
Yes.
resolve the
আরে
issue.
এগুলো জমা
If any document is actually missing, file a supplementary affidavit with copy to them.
Lord,
I appear to state in item number 26, your lordship.
25, 26 not today.
Grateful.
It will appear along with the other matters. Yes.
Grateful, your
27.
So 27, I appear on behalf of the writ petitioner respondent.
Respondent.
Here,
State's appeal.
Is it the appeal is at all maintainable?
Why not?
For the order passed in a contemporary rule has been issued. Order was not carried, rule was issued.
Rule issued.
Yes.
No penal action taken.
No, nothing.
Not maintainable.
And not only that, when the
Contempt of court act আছে?
yes.
Do you have the appellate provision? Just find out the appellate provision.
But section 19 is there. If punishment is given, then only.
Yes, we also knew that.
Yes, Lord.
It's very clear. But as an intra-court appeal, is it not maintainable? As an intra-court appeal, it may be maintainable. Latest patent appeal.
Who can prefer an appeal? Here, lordships can find out the state prefer an appeal.
So along with that person.
Yes, he is.
When we delete the state, 2 remains. He is also one of the appeals. So let us just.
Kindly, then my lord, can you see who is affirming the appeal?
We'll just check. No, that we can transpose the state. No difficulty on that. Let us first ascertain.
But on third.
One.
Yes. What are the clause?
appeal file করেছে।
তিন তারিখের অর্ডারটা বার করে দাও।
তারপরে অর্ডারটা দুটো অর্ডার।
No, no, we'll dismiss it as not maintainable.
Now, my lord, on another things are there.
Yeah.
Kindly see the conduct.
What is the
Lord
conduct?
Member, Lord,
If we hold it is not maintainable, we won't enter into the conduct.
Lord, he says that we shall carry out the court's order.
Oh, acha.
Then, wait a minute.
No, that will be decided in the contempt. We won't prejudge the contempt application. We'll record your submission that you are submitting this, but we'll এটা দরকার নেই.
And another thing is this two memorandum has been issued saying that the NHI says that
We won't enter into the merits of the main matter.
Well,
contempt is not maintainable. Rule issued only.
Well,
Against issuance of rule.
No, my lord.
No, don't come back, go back to the contempt court.
My lord, may I indicate the two things, my lord?
Rule issued, how is appeal maintainable?
My lord, I have not challenged the issuance of rule, my lord.
What have you challenged?
My lord, the previous order by which, my lord, the Honorable Single Judge.
Order dated 27th of August.
That is not a that is not an order of rule, my lord.
Acha.
No, just, my lord, give me one day accommodation, my lord.
No accommodation.
No, I have not brought the, my lord, entire file, my lord.
Page 163 of the এটা তো চ্যালেঞ্জ দিতে পারবো এটা তো রুল ইস্যু করেছে $197 in the stay application.
No, where is the impinged order? That order dated 27th of August?
Yes, 197.
My lord,
so why haven't you annexed this order in the memorandum? You have annexed only the rule?
No, my lord, 163, my lord. 163.
LPA 2 of 2025.
My lord, kindly takes up the can 2.
Why can 2 in the memorandum? You have not annexed that order.
In memorandum?
এটা দিন মেমোরান্ডামটা এটা খুলে দড়ি ফড়ি খুলে ওকে দিন Yes, that is the order issuing the rule.
Yes.
You have not annexed that order itself. You have issued only a copy of the rule.
That's my mistake, my lord. I am before your lordship challenging the order dated 27th of August.
You have to annex the copy of that. We find from the memorandum that a rule has been annexed to the same. For sub next para, learned counsel for the respondent submits that the rule arose from an order dated August 27, 2025, which has been challenged before this court. However, under section 19 of the Contempt of Courts Act 1971, it is submitted that mere issuance of a rule in a contempt matter is not appellable. Only if penal action is taken for contempt, is the same appellable under the said provision. Next para, learned counsel for the appellants submits that learned counsel for the respondents further contends that the state, that is the appellant number 1, not itself being the alleged contemptor, does not have the locus standi to prefer the appeal at all. Next para, learned counsel for the respondents seeks to make further submissions on the merits of the matter, which we do not entertain, since it would be prejudging the merits of the main contempt application at this stage. Next para, learned counsel for the appellants seeks a day's accommodation. Even otherwise, we find that the copy of the substantive impugned order, by which the rule was directed to be issued, has not been annexed to the memorandum of appeal. Accordingly, the appeal is not in form. Leave is granted to the appellants to file the certified copy of the original order dated August 27, 2025, the observations of which has been challenged in the present appeal by January 2, 2026, Full stop. The appeal shall next be the matter shall next be listed under the same heading in the monthly list of January 2025.
My only difficulty, my lord, the contempt application running before his lordship, my lord, I cannot get the certified copy, my lord. So kindly grant me leave to.
আচ্ছা যেখানে বললাম ফাইল a certified copy stroke server copy
Grateful to lordship.
ফাইল সার্ভার এটা এই বইটা ফেরত দিয়ে দিন
My lord, I appeal to the KMDA. My lord, sorry that section 5, there is a section 5 application, a 37 days delay. But I understand, my lord, the copy has not been served.
server copy come back after that. Learned counsel for the appellants rightly fairly points out that no copy of the condonation application has yet been served on the respondents, because accordingly the appellants are directed to serve copies of Can 1 of 2025
Can 2.
as well as
Not Can 2.
Can 2 of 2025 on the respondents by December 24, 2025 and file a receipt in that regard on the returnable date. Full stop. The matter shall next be listed in the monthly list of January 2026. Thank you.
Lord, I am for the state respondent.
Yes.
I am for the private respondent, my lord.
What is the matter?
I mean, private respondent.
You are private respondent.
Appellant, I can.
None appears for the appellant at the time of call, although the state respondent as well as the private
May I submit the reports filed to be filed by
no, Mr. And private respondents are represented by counsel. Full stop next para. Was there any direction to file report?
No.
Then don't file it. Full stop next para. Accordingly, let the matter stand adjourned till after the upcoming Christmas vacation and be listed in the month of January 2026.
My lord, order of the SDO is postponed due to
We'll
this.
consider. Let the appellant come. Without the appellant, we cannot dispose of on merit. If we dismiss for default, again they'll file a recall application, restoration application. Better take up after it. Next.
Yes. My lord, I'm for the
Yes.
applicant.
How are you?
Well, to some extent.
What is the matter?
Item number 13, my lord. Today, my lord, it has come without notice.
No.
I have not served the notice.
All
Your
notice.
lordship kindly take it up after vacation. My lord, any date subject to your lordship's
What is the matter about? What have you challenged?
My lord, it's a very actually simple case. This petitioner filed a civil suit before Moonford, and thereafter the suit was withdrawn. Actually, was withdrawn with intention to file before honorable court because the Patta land cannot be dealt with by the municipal court. That was, and after withdrawal, they filed a writ application, and Learned Singh relying on the order of the civil judge junior division, which was in fact a wrong order, on the basis of which the writ was.
You sought to withdraw the writ petition.
Exactly.
No.
It's recorded in the order.
No, my lord, we have not.
Then you have to approach before that court and say that it was a wrong recording of fact.
Well, that was recorded only on the basis of civil court's order.
No.
No.
In view of the above, the petitioner seeks to withdraw the writ petition.
No, my lord.
What? No.
Withdraw the suit that
you are challenging the order dated 13th of December 2023.
Exactly.
Yes, ma'am.
Sorry, we will dismiss the appeal.
No,
with liberty to go to the learned single judge with an appropriate application for correcting the records then. The present appeal has been preferred against an order dated December 13, 2023. Post of Learned Counsel for the appellant submits that the learned single judge, on an erroneous premise, dismiss the writ petition for non-prosecution merely because the previous suit had been.
Kindly allow me to read.
Will impose costs. Will impose costs on you if we find that you are wrong. Yes, please read.
Not kindly. It appears from the copy of the order passed on February 28, 2023, the Learned Civil Judge Junior Division, Second Court, Ulubedia, entitled suit number 109 of 12, filed by the petitioner and others, and the petitioner herein withdrew the suit on the ground of amicable settlement. That is,
there are other sentences after that. Please continue.
Of the disputes between the petitioner and private respondents without seeking liberty to sue afresh.
Please read the next sentence loudly.
The writ petition being
Is dismissed.
You are missing out a sentence, the crucial sentence. Please read it.
Yes, the writ petition.
No, the sentence before that you are omitting deliberately.
In view of the above, the petitioner seeks to withdraw the writ petition. It is session.
No.
You are trying to mislead the court.
No.
No, my lord.
Will impose heavy costs on counsel personally.
My lord, actually, we did not want to withdraw this writ.
About this, the present appeal has been preferred against an order dated December 13, 2023, whereby the learned single judge recorded, while dismissing the writ petition of the present appellant for non-prosecution, that the petitioner sought to withdraw the writ petition in view of a previous withdrawal of a suit filed by the writ petitioner on the ground of amicable settlement of disputes between the petitioner and private respondents, without seeking liberty to sue afresh. Full stop. Next para. While moving the present appeal, the learned counsel for the appellant repeatedly reiterates that the appellant had not sought to withdraw the writ petition before the writ court, but merely on the premise of the previous withdrawal of a suit by the appellant, the writ petition was dismissed. Full stop. The court tried to point out repeatedly that the learned single judge has observed categorically that the petitioner within bracket present appellant bracket closed sought to withdraw the writ petition, on which premise the writ petition was dismissed for non-prosecution by the impugned order. Full stop. However, learned counsel for the appellant adamantly refutes such statement. Full stop. Next para. At this, the court requested learned counsel for the appellant to read out the impugned order. Full stop. Even while so reading out, learned counsel for the appellant deliberately omits to read out the sentence twice, where it was recorded that within double inverted, in view of the above, the petitioner seeks to withdraw the writ petition, double inverted close, full stop. Next para. While passing this order, learned counsel for the appellant takes shelter under the fact that his eyesight is somewhat, he is in some difficulty regarding his vision. Full stop. However, it is surprising to the court that the vision of the appellant's counsel and his myopia are extremely selective. Full stop. Learned counsel clearly read twice the first two paragraphs and jumped over the sentence in question to the next paragraph on two occasions. Full stop. Next para. We are sorry that we cannot accept such pretext of myopic vision of learned counsel for the appellant in view of the selective nature of the same. Full stop. Since the appellant seeks to mislead the court repeatedly, we are of the opinion that heavy costs should be imposed on the appellant. Full stop. In any event, on merits also, this court cannot enter into the same, in view of the specific factual observation by the learned single judge that the petitioner sought to withdraw the writ petition, only on which premise the writ petition was dismissed for non-prosecution. Full stop. Next para. It is well settled that if the facts which transpired before a court were erroneously recorded in an order, it is for the affected party to approach the self-same court, preferably the self-same learned judge, for correction of the same. Full stop. An appeal against such erroneous recording of factual circumstances is illusory, since the appellate court is not in a position to ascertain the true state of affairs which transpired on the relevant date. Full stop. Thus, WPA 1463, Thus, FMA 842 of 2025 is dismissed on contest, thereby affirming the order dated December 13, 2023, passed in WPA 14633 of 2023, with costs of rupees 20,000 to be paid by the appellant to the respondent within a week from date. Next para. However, nothing in this order shall preclude the appellant from approaching the writ court, preferably the learned single judge herself who delivered the impugned order, for praying for correction of perceived erroneous recording of fact, inasmuch as the appellant submits that the appellant did not seek to withdraw the writ petition on the relevant date. If such an application is filed, the same may be decided in accordance with law upon hearing both sides. Urgent certified copies.
Not only my request, I am physically, actually,
Next.
I have become physically handicapped, my lord. I am suffering seriously, having none to look after me. I have no family member, alone. My lord, only a cost may be exempted, my lord. That is the only prayer, my lord.
Appellant in the next matter.
My lord, kindly, my lord, kindly exempt.
Use the microphone.
My lord, kindly, I am.
Use the microphone. Put it on. Yes. So, on Banerjee,
Not only
hearing on behalf of the state respondent.
is for the appellant.
Mr. In item number 30, Lordship. In 31, I am appearing for the appellant, Lordship.
Appellant is Owen Banerjee's name was recorded.
Lordship. In 31, item number. In item number 30, Mr. Banerjee is for the state respondent. No, in previous matter.
30, my lord, only.
Yes, better somebody appeared. On
Yes.
Banerjee did not appear, so his name will not be recorded. 31, argue on 31. Please give him the microphone.
Yes. My lord,
Please give him the microphone.
Yes, yes.
Yes.
In item number 31, I am appearing on behalf of the appellant, Lordship. I am seeking for a day's accommodation, Lordship.
Why? You move the matter. It's a condonation
It's
application.
a condonation application. I'm led by Mr. Banerjee.
What is the
Lordship.
delay?
The delay is, Lordship, of 1433 days, Lordship. May I just.
My lord, I am also praying for accommodation.
Well, on the prayer of the parties, the matter is adjourned for the day.
I'm grateful.
Grateful, your worship.
I'm grateful.
Give your names, both of you.
Lordship.
Applicant. Now for the respondent.
Yes.
Well, I have made an application for addition of party, my lord.
I am appearing for the appellant.
My learned friend is the appellant.
Who are you? What is your request?
My lord, on the basis of my application, we are the villagers. We feel inconvenience in our passage. Then we made an application before the authorities. On our application, annulment proceedings was initiated, and the patta was annulled of the writ petitioners. In the writ petition, the order challenge, which was passed by the SDO, annulment order passed by the SDO, which is
Writ petition was allowed.
yes, no, allowed.
In your favor.
Lordship,
Yes, yes.
Lordship,
You have
during
preferred. You are the state.
Yes.
I am appearing for the appellant, state appellant.
Yes.
SDO Ryan. Lordship, during pendency of the appeal before the DLLRO, they have preferred the writ petition and it was allowed in his favor, Lordship. And we have challenged the order of the learned single
What
bench.
is your call on his being a necessary party? Because on his complaint, he's a villager. He was
Lordship,
interested.
on their complaint, on their
They should be added, Mr. Chatterjee. Bhai.
application,
So we are allowing
SDO has initiated the proceeding.
addition of party application. We are allowing.
Yes, your Lordship.
Then writ petition was not maintainable since the order.
That is the second stage.
Yes, yes, yes. Yes,
Can 2 of 2025 is an application for addition of parties. You are seeking to add yourself
as a respondent.
For the first time in the appeal, in the writ petition, you are not party.
Not.
So next para, learned counsel for the applicants submits that the applicants are villagers on whose complaint a proceeding was initiated by the state authorities. Challenging such proceeding, a writ petition was preferred at the behest of the present respondents. Upon the writ petition having succeeded, the state authorities have preferred the present appeal. Full stop. It is argued that since the present applicants have a direct stake, STAKE, in the outcome of the appeal as well as the writ petition, comma, the writ petition ought to have, in the writ petition, comma, the applicants ought to have been implemented. For sub next para, be that as it may, comma, upon hearing learned counsel for the state as well as the applicants and the private respondents, comma, this court is of the opinion that in view of the entire genesis of the dispute being the complaint of the applicants as well as the outcome of the appeal having a direct bearing on the fate of the applicants, comma, the applicants are necessary parties to the appeal. Full stop. Accordingly, can 2 of 2025 is allowed, thereby implementing the applicants as pro forma respondents in the present appeal. Full stop. Necessary consequential corrections shall be carried out by the learned advocate and record for the appellants during the course of the day in the memorandum of appeal.
Yes, Your Lordship.
So can 2 is allowed. The main appeal will take up after 10 minutes. Yes, Mr. Hodja.
Lordship, we have challenged here the order passed on 19th June 2025 by Honorable Justice Parthasarathi Sen,
Yes.
allowing thereby the writ petition of the respondents herein.
What is the nature of the? Yes.
My Lordship, we have challenged the judgment on several grounds, Your Lordship. Firstly, the single bench observed in paragraph 12 of the impugned judgment, we have annexed it, Your Lordship. Internal page 4 of the impugned judgment, that is annexed in the first of the memorandum of appeal, and also at page 66.
What? The order?
The impugned order of the
Impugned order we are following from the memo. You may refer to the internal pages.
internal page 4, paragraph
Yes, yes,
12.
para 12, we are there.
And Lordship, here the single bench observed that under section 49(2) of the Land Reforms Act 1955, it appears to this court the only revenue officer is empowered to pass an order in writing regarding annulment of patta. No explanation has been given on behalf of the state so to how and as to why the instead of a revenue officer, the jurisdictional SDO has passed the order. In this connection, Your Lordship, I want to refer, which I have annexed also in my application, page 73, that is the LR Land Reforms Manual. Lordship.
He was empowered as the.
Yes, Rule 209, Sub Rule 2 and 3, page 73 of my application, Your Lordship. That is the Land Reforms Manual. 73, Lordship.
Of Can 1.
Can 1, that is my application. 73 to 209, Rule 209,
Yes.
Sub Rule 2 and 3. The revenue officer may start an annulment of case suo motu or on application. The application has been received by the SDO and by the villagers. And secondly, Lordship, 3. The subdivisional officer has been appointed as revenue officer for the purposes of section 49(2).
Here it was started suo motu.
Yes, Your Lordship, on application from the villagers.
So you are relying on 3, 2093.
2 and 3 both.
2 may start suo motu.
Suo motu or on application?
Yes, obviously. You can.
Because the learned judge has observed that SDO cannot be appointed as revenue officer. That's why I'm relying on 2 and 3 of Rule 209.
Right.
And Your Lordship, now another point is that under West Bengal Land Reforms Tenancy Tribunal Act 1997,
yes,
Section 6 prescribes the jurisdiction. Here it is clearly stated the order.
Land Reforms Act. Specified Act.
Specified Act, Your Lordship. Number 2. Number 3 of the.
So here it was directly challenged before the.
Before the High Court. And Lordship, the third point is during pendency of appeal before the appellate authority of SDO's order, annulment of patta has been challenged before the appellate authority. During pendency of the appeal, instead of filing application before Land Reforms Tribunal, they have preferred writ petition before Honorable High Court.
What was the prayer made in the writ petition?
Yes. Prayer was, Lordship, I am coming. Prayer petition is annexed. That is, Lordship, page 36. A writ of and/or in the nature of mandamus to issue commanding the respondent authorities concerned, each one of them, main agents and servants, subordinates, such and such, to cancel and withdraw the annulment of patta of
that is virtually the relief sought before the SDO.
Yes. Is SDO has passed, Lordship, SDO has passed this order on 13th March 2024. That is the annulment of patta order. That has been challenged before the appellate authority, DLLRO. And during pendency of the appeal before the DLLRO, challenging that order, they have again, during pendency, they have challenged this order before the Honorable High Court by filing writ petition, Your Lordship.
No, what order was passed? What order was challenged in the writ petition? No order was challenged.
13th March 2024. During they have preferred appeal, and during pendency they have preferred again writ petition.
No, the appeal was allowed.
No, no, no.
No, appeal is pending. That is our point of challenging.
Appeal is pending. How order of annulment was passed?
Lordship, kindly come. It is annexed, Lordship.
I'm grateful.
No, no. Annulment process.
All of us cannot speak together. Let her complete, then we'll hear both of you.
Lordship,
Whichever suits
appeal-
you are supporting and whichever suits Mr. Chatterjee is supporting.
Lordship, appeal is annexed here at page 54, 56. 54
No,
to
Ms. Tiwari, we want to see that order which was challenging, that 13th of March 2024 order.
Yes, Your Lordship, I am showing. Order ta dekha, annulment of patta. Annulment patta. P3, Lordship, page 49. Eta.
Yes.
That is the order.
Yes.
On appellant state applicant.
But Patta was annulled while the appeal was pending. This order is also palpably bad. Why shouldn't the 226 court interfere? This is absolutely without jurisdiction. Keeping the appeal pending,
Yes, Your
you are annulling the Patta, then what remains in the appeal?
Lordship, the
Why shouldn't 226 jurisdiction have been invoked?
Lordship, they have preferred writ petition here, Your Lordship, challenging this order.
Yes, because this is palpably without jurisdiction.
But the
Absolute
land
it's not
reforms
an absolute
tribunal
bar.
is there.
You are right. It's an alternative remedy, but that is not an absolute bar. Alternative remedy is not an absolute bar.
Yes, Your Lordship, I have understood.
Several
I have
others.
understood.
If there is palpable jurisdiction error, why should you interfere with the learned single ledger? Our point is that this, I mean, no reasons also. Just because there is urgency and he allowed. And what was left in the appeal, he kept the appeal. It is the further date for appeal.
Lordship, the purpose of
No, no.
passing
Was any
the order-
further date? There was any further date fixed for the appeal? This is
that is-
apparently is the final order. Send a copy to the what remains. Why are you saying the appeal is pending?
No, Your Lordship, appeal is pending before the DLLRO because this order has been passed by the SDO Raiganj. Annulment of Patta. Appeal is pending. Kindly come, Lordship, page 54. That is the appeal preferred challenging this order. Your Lordship, kindly come.
That is fine, but in connection with that appeal only, this order is passed.
Yes, Your Lordship.
Oh, this is
No,
the
Your
first order.
Lordship,
SDO.
this is the first order. They have prayed to cancel this order, to set aside this order passed by the SDO. Page, kindly come to page 54, Your Lordship.
Then they are very well. They are challenging in the appeal as well as in the
As well as writ petition. And that was allowed.
SDO order.
This is SDO's order. Appeal is before DLLRO, Your Lordship. Page 54, the appeal has been annexed, Your Lordship.
Right. What other ground? Yes. we have-
Lordship, this is one ground that during pendency of the appeal, they have preferred this writ petition. Second ground is the West Bengal Land Reforms Tenancy Tribunal Act 1997.
Three grounds. One is that para 12 is wrong because 49(2).
Yes.
Under this land reform.
SDO is empowered by
Second is
209.
LRTT is available.
Yes. And third is, Your Lordship,
Appeal and writ parallelly.
parallelly.
So these are the three grounds.
These are the grounds.
See whether any other ground has been attributed by the learned single judge, apart from not para 12. For that is then in fact, no, your LRTT ground is not correct, because here what they do is this is by way of an appeal. I mean, this is the writ petition. In the writ petition,
yes, Your Lordship,
they prayed the relief which they sought in the appeal. Therefore, writ court was being converted to the appellate authority.
Yes.
They have not challenged an order of the.
They have challenged the order of the subdivisional officer here as well as before the
No, that
statutory
you have
appellate
understood.
authority.
But they did not challenge any order passed by the appellate authority.
No,
By
because that is pending before the appellate authority. Appeal is pending still now. After preferring appeal, simultaneously they have challenged before the Honorable High Court.
No, if they took, if this challenge was against the appellate authority's order, then LRTT would be the appropriate forum.
Appropriate authority.
Your second ground is not correct because LRTT is not the appropriate forum. The appropriate forum is the appellate authority where they have approached already.
They have approached, but again they have preferred a writ petition here also.
No, you say that the appeal lies, the challenge lies before the LRTT, but that is not the case because appeal lies.
Lordship, it is clearly stated. Kindly kindly come to section 6 of West Bengal Land Reforms Tenancy Tribunal.
Ms. Tewari,
Yes, your Lordship.
they had challenged an order passed by the appellate authority.
May I go through once, my Lordship, with your permission? Jurisdiction, power and authority of the tribunal, subject to the other provisions of the Act, the tribunal shall, with effect from such date as may be appointed by the state government by notification in this behalf, exercise jurisdiction, power and authority in relation to A, made by an authority under a specified Act. Lordship, the SDO is also the authority in specified Act, your Lordship. Here, that's why I am.
Section 54, under Section 54 of the Land Reforms Act.
Yes, your Lordship.
Specific appeal lies against the SDO order. They have preferred an appeal under Section 54.
They have
Section
preferred
54
under Section
affords-
50.
Section
54, your
54
Lordship. Yes.
affords them to prefer an appeal against the SDO order.
Yes, your Lordship. They have
Right.
preferred appeal. Yes, your Lordship.
Therefore, there was no question of their going to the LRTT against
They
the
could
order
have
of the
challenged
SDO.
if the appellate order would have been passed.
That an authority has to be read in context of the particular
Yes, your
statute.
Lordship. I have understood.
Because if an appeal is preferred, they have to prefer that appeal first.
First.
Appellate authority is also an authority under the Land Reforms
They have
Act.
preferred appeal, but
If
simultaneously
an order
they,
was passed by the appellate authority,
they
allowing,
could have
then against
challenged.
that would be also an authority under Section 6,
Section
appellate
6.
authority.
Yes, your Lordship.
Against that, LRTT could be approached.
Could be
But here
appropriate.
Section 54 is available. Their only remedy is Section 54. They have availed that.
But
And simultaneously,
the appeal is pending, your Lordship, before
yes,
the
that
appellate
ground is
authority.
there. Let us see what.
And that ground is also here, your Lordship, that SDO is the appropriate authority under Rule 209 of the West Bengal Manual.
Yes, Mr. Chatterjee, how do you defend this? The learned writ court acted as the appellate authority.
My lord,
We are setting aside on the ground of jurisdiction. We'll keep all questions open to be decided in the appeal.
That has exactly been done by the single. Kindly say.
So why these observations on merit?
My lord, may I submit one submission, my lord? In the writ petition, my lord, I have annexed one
No,
document.
that has not precisely been done. Sorry. Please come to paragraph 21, 22, 23 of the order. Consequently, in view of the discussion, para 19, right? In view of the above discussion, instant writ petition succeeds, allowed and disposed of. Consequently, order dated, that is the SD order, is hereby set aside.
Why that this order has been passed? Kindly consider the grounds, my lord, for once.
No, cannot. Writ court cannot. Under Section 54 specifically.
Subject to kind sanction, when the order has been passed in the name of that finality, we have challenged that particular order of the SDO.
SDO order, whatever order is passed by the SDO, that's amenable to challenge under Section 54.
That has been preferred.
That is your remedy. Writ court could not simultaneously. How could you prefer two remedies? You are forum shopping.
Yes, no. Give me 1 second. Give me 1 second.
He's a salesperson in the forum shop. And he says the appeal has become infructuous in view of this order. Mr. Chatterjee, this is not done.
But kindly see for my satisfaction for once, my lord. Then the writ petition.
We are not here to satisfy you.
No, my lord, regarding their document, it is not.
We are satisfied, that is sir. You satisfy us.
My lord, yes.
Two forums are escaped, Mr. Chatterjee.
My lord, kindly appreciate one.
Appellate forum against that LRTT, against that High Court, that too in division bench.
After DLLR, I have to go. After DLLR, subject, I have to
After DLLR appeal, LRTT is available. Yes. Whoever loses, both of you, both of you are losing. LRTT, against LRTT, appeal before this court, writ petition before this court, that too in a division bench. Now settled. So how can the writ court bypass all those two forums? Impossible. I mean, even if the writ petition was available against the LRTT before a single judge, then even we could understood, yes. But here, not only bypassing forum, but bypassing the bench strength also, Mr. Chatterjee, could not be done. Let us not waste further time on this. You are satisfied? We are satisfied?
সেটাই তো বলছি অ্যাপিলটা তো ওখানে
Now you are satisfied. You have been able to satisfy you, apparently.
My lord, may I say one indulgence?
You have to say something, yes.
No, my lord, what is just now fallen from your lordship?
Not entering into the merits, not affect the merits. Appeal court will decide the appeal on its own merits.
within a specific time
Yes.
period.
Within a specific
Within a specific time.
No, my lord.
You have got sufficient, no.
No, I got the time, my lord. It's a fact. But it's my land, my lord. It is a disputed question of fact, my
Decimal,
lord.
No, no
Lordship.
time limit.
That too for the
Within a
purpose
reasonable
of
time,
public
whatever
purposes.
Yes,
For
well,
widening the public road,
Only
for
2
emergency
weeks.
services of ambulances and emergency
No,
vehicles,
SDO
your
cannot
lordship.
pass such order, my lord, without any jurisdiction.
The present appeal has been
Private respondent.
Jurisdiction
preferred
is there.
against the respondent authorities against an order by the learned single judge, whereby the learned single judge entertained a writ petition and set aside an order passed by the jurisdictional subdivisional officer under section 49 within bracket 2 of the West Bengal Land Reforms Act 1955. Push up next para. Learned counsel, what you have a designation, senior government advocate.
No, your lordship, group A, only.
Acha,
What state?
learned counsel appearing for the state stroke appellant contends that the learned single judge acted palpably without jurisdiction, comma, in view of an appeal being maintainable under section 54 of the West Bengal Land Reforms Act 1955 against any order passed under section 49 within bracket 2 of the said act. Push up next para. Secondly, comma, under section 6 of the West Bengal Land Reforms and Tenancy Tribunal Act 1997, comma, the appropriate forum for a challenge from an order passed by an authority under any of the specified acts is the Land Reforms and Tenancy Tribunal. Full stop. Since the 1955 Act is a specified act under the said statute, comma, it is contended that the writ court could not assume the jurisdiction of the tribunal. Push up next para. Thirdly, comma, it is submitted that the learned single judge recorded in paragraph number 12 of the impugned order that it appears that the order under challenge had been passed by the subdivisional officer, comma, Raiganj, comma, Uttar Dinajpur. Full stop. However, comma, it was recorded, comma, that on perusal of section 49 within bracket 2, comma, it appeared to the court that only a revenue officer is empowered to pass an order in writing regarding annulment of patta, and no explanation has been given on behalf of the state as to how and as to why, instead of a revenue officer, comma, the jurisdictional subdivisional officer passed the order under challenge. Push up next para. Learned counsel for the state places reliance on clause 209 within bracket small III triple I of the West Bengal Land and Land Reforms Manual 1991 to contend that as per the said provision, comma, the subdivisional officer has been appointed as revenue officer. A subdivisional officer, revenue officer, এগুলো caps দিয়ে দিয়ে হবে। As revenue officer for the purposes of section 49 within bracket 2, full stop, under clause small II within bracket of clause 209, comma, the revenue officer, comma, it is argued, comma, may also start an annulment case suo motu or on application. Full stop. Thus, comma, it is argued that the learned single judge proceeded on a patently erroneous premise while so observing. Full stop. Upon hearing learned counsel for the parties, comma, we find substance in the arguments of the appellants. Full stop. Next para. Under section 54 of the West Bengal Land Reforms Act, comma, 1955, comma, an appeal is maintainable against an order passed by the subdivisional officer before the appellate authority, comma, from an order under section 49 within bracket 2 of the said act. Full stop. Next para. In fact, comma, in the present case, comma, an appeal has already been preferred under the said provision by the writ petitioner stroke private respondent herein. Full stop. Hence, comma, the writ petitioner stroke private respondent could not be permitted to forum shop by preferring challenges before two parallel forums against the said order. First up, from the prayer made in the writ petition, we find justification in the argument of the appellants that the writ petition sought to challenge the very order of the SDO under section 49 within bracket 2, which is also under challenge before the appellate authority, at the behest of the writ petitioner himself. Full stop. Next that that apart, the learned single judge, sitting in writ jurisdiction under Article 226 of the Constitution, bypassed two forums of challenge, fora of challenge, by assuming jurisdiction. Full stop. Next and apart from an appeal being maintainable under an order passed under section 49 within bracket 2, a further challenge against such appellate authority's order is available before the Land Reforms and Tenancy Tribunal, against the order of the Land Reforms and Tenancy Tribunal, an application under Article 226 of the Constitution of India is maintainable, that too, TW, before a division bench of this court, by passing the impugned order, thus, the learned single judge bypassed two forums of challenge and exercised jurisdiction which this court, under the self-same provision, that is under Article 226 of the Constitution, could exercise only sitting in division bench. Thus, there was a confusion of forum in passing the impugned order, which itself tantamounts to a jurisdictional error. Next even otherwise, learned counsel for the appellants has rightly argued that in view of clause 209 within bracket Roman III of the West Bengal Land and Land Reforms Manual 1991, it is the subdivisional officer who has been appointed as revenue officer for the purposes of section 49 within bracket 2, and the said subdivisional officer may start an annulment case even suo motu, apart from on an application. Thus, in the present case, the said ground as cited in paragraph number 12 of the impugned order to the effect that the SDO does not have jurisdiction, is completely dehodes the law. In view of the above, we do not find the impugned order to be tenable in the eye of law. Accordingly, FMA 1231 of 2025 is allowed on contest, thereby setting aside the impugned order dated June 19, 2025, passed in WPA 10834 of 2025, without any order as to costs. Consequentially, can 1 of 2025 also stands disposed of. Next it is, however, made clear that this court has not entered into the merits of the challenge against the order of the SDO now pending in the appeal under section 54 of the West Bengal Land Reforms Act 1955 at the behest of the writ petitioner / private respondent. The appellate authority shall decide the said appeal independently of any observations made herein and in accordance with law, without being unduly influenced by any observations insofar as the merits of the said appeal is concerned. It is expected that in view of some amount of delay already occasioned due to pendency of the litigations before this court, the appellate authority shall decide the appeal as expeditiously as the business of the said authority permits, preferably within 4 working months from the date of communication of this order to the said authority. Thank you. যেখানে বলেছি after hearing upon hearing learned counsel for all the parties including the added respondents করে তাহলে একটা জায়গা আছে upon hearing including the added respondents কথা দিয়ে দেবেন ঠিক yes thank you. Thank you Mr. Chatterjee for knowing where to stop. Yes sir. এই এটাও নিয়ে নিন. Yes.
I appeal for the respondent.
Union of India. Who is for the appellant? এগুলো কি মেনশনিং এসছে তো সব?
But I appear for
Oh, you're there. Union is the main respondent. What is the appeal?
appeal is not against the order passed by the Honorable Justice Parthasarathi Sen.
What is the order?
In the writ petition. Only two grounds.
Your writ petition was dismissed.
Yes, brother. Two grounds. The Act provides that there is an alternative remedy. Appeal under Section 9 of the Unauthorized Act. And
Section 9 is there, yes.
yes, my lord.
Rightly so. What is the second
Right,
ground?
that is right. But I have not.
What is the second ground?
Second ground.
Did you challenge the notice issued under that act or the
Yes.
final order?
I challenge the issue. Notice.
Notice, wait. What is
Not notice, my lord. The order.
final order?
Final order I challenge.
What is the other?
On the ground that the petitioner is one of the is a license similar against some portion of land of railway.
Which had expired in 2015.
My lord, that is the question arose there, my lord. The license was granted in 2010, my lord. If your lordship filing, oh,
Page 19, your lordship.
No, the merits have not been entered into by the learned single judge.
my lord,
The merits have been entered into by the learned single judge.
not merits, my lord.
Then why are we discussing the merits? It has been decided on the ground that an appeal is maintainable under Section 9, right?
Yes, my lord. That is the
For last
learned.
We are not interfering with this. Go and file an appeal.
My lord,
Absolutely right order.
appeal was this order was passed, my lord, long back, my lord.
Pardon? Order was?
Passed in long back, my lord. Because it was passed, my lord.
So just because your time barred, your appeal is time barred, you
Yes.
invoke the writ jurisdiction. That is all the more a reason it is no, it should not be entertained. To bypass a time bar, you cannot do indirectly what you cannot do
Not
directly.
that, my lord. Your lordship kindly see the first time placing the license.
No, we won't enter into the merits. It has been dismissed only on the ground of you had argued before the learned single judge that you have also challenged the notice.
Yeah.
The learned single judge observed that in the challenge Section 9 appeal, you can also take that point. Perfectly fine order. No interference.
But my lord,
No,
what
you have
happened in this matter?
5 minutes hearing for this matter is more than enough.
No, that
You know that better than us.
your lordship.
You know that better than us. 5 minutes is sufficient, like a day.
My lord,
You'd have got half a minute if you are not so senior.
Lord, only I am only placing the
And an intra-court appeal will differ with that view.
only,
On merits, we will not allow you to, we'll record that in an order. That learned counsel sought to argue on the merits. We stopped learned counsel for this ground. We are putting it in an order. And your all questions will be, have you preferred a Section 9 appeal?
no, my lord. Say, I have not filed. What happened in this matter?
So
my
you
lord?
have liberty to file that appeal?
I sense the petitioner is enjoying the
There was a
land
bookstore.
plot since
These are on the merits of the matter.
1977.
These are all on the merits of the matter. Learned, the present appeal has been preferred against an order whereby a writ petition preferred by the appellant against an order passed under sections 4 and 5 of the public premises within bracket eviction of unauthorized occupants bracket closed act comma 1971 full stop. Learned counsel for the appellant submits that the learned single judge committed an error of law in dismissing the writ petition only on the ground of availability of alternative remedy as the said availability is not an absolute bar uh, in exercise of jurisdiction under Article 226 of the Constitution of India. Full stop. Next para, learned counsel also seeks to argue on the merits of the challenge to the order passed by the estate officer under the said act. Full stop. However, comma, the court does not permit such submission on merits of the matter, comma, since it would prejudge a final adjudication of the proceedings at this prejudge a final adjudication of the proceedings at this premature stage. Whose next parallel and counsel appearing for the Union of India controverts the submissions of the appellant and contends that the learned single judge was justified in dismissing the writ petition on the ground of maintainability, comma, since a remedy which is equally efficacious, comma, is available to the appellant by way of a challenge under Section 9 of the 1971 Act. For some next para, upon a consideration, upon a perusal of the impugned order, comma, we find that the same elaborately dealt with the facets of the challenge. Full stop. It was argued on behalf of the appellant that since a challenge to the initial notice, comma, which initiated the eviction proceeding under Section 5 within bracket 1 of the 1971 Act was also under challenge, comma, a writ petition was maintainable. Full stop. Next para. However, comma, the learned single judge observed that the said objection stroke ground may also be taken in an appeal preferred against the final order passed by the appropriate authority under Section 5 of the 1971 Act. Full stop. We completely agree with such observations of the learned single judge. Full stop. Next para. Although it is a self-imposed restriction, comma, it is now well settled that if an equally efficacious alternative remedy is available, comma, this court does not generally interfere under Article 226 of the Constitution of India unless the appellant stroke writ petitioner exhausts all other remedies available in law. Full stop. Next para. Even otherwise, comma, the writ court is handicapped insofar as disputed and contested questions of fact are concerned, which might be involved in the appeal under Section 9 of the 1971 Act, which is available to be preferred by the writ petitioner against the final order under Section 5 of the 1971 Act. Full stop. Next para. Thus, comma, we do not find any scope of interference with the impugned order. Full stop. Accordingly, MAT 1326 of 2025 is dismissed on contest without any orders to cost, comma, thereby affirming the impugned order dated July 4, 2025, passed in WPA 21016 of 2023 with Can 1 of 2025. Full stop. Next para. The pending connected applications are also disposed of. Full stop. Next para. Consequentially, comma, the issues involved being identical, comma, FMA 1448 of 2025 and FMA 1452 of 2025, comma, preferred against the same order. Preferred against the same order, my lord, are also dismissed along with the connected applications in connection with all the appeals. So, sub next para, it is made clear that nothing in this order or the order impugned before us shall preclude the appellant in each of the appeals from preferring a challenge to the order passed under Section 5 of the 1971 Act, comma, subject to limitation and in accordance with law, comma, if the appellants are otherwise entitled to so prefer. For sub next para, if such appeals are preferred, comma, and if the same are entertained upon crossing the hurdle of limitation, comma, it will be open to the appellants to take all questions taken in the writ petitions, comma, including the challenge to the initial notice, which was the genesis of the eviction proceeding before the appropriate authority under the 1971 Act. We have covered whatever you are going to submit.
Deeply all right.
Thank you. Next.
Item number 36.
May it please your lordship,
Yes,
I appear for the affidavit. May I file the affidavit of service?
Yes. Right.
Lord, the appeal lies, my lord, from an order confirm.
The main principal respondent is the state.
Yes, my lord, the principal respondent is the state. The appeal from an order
Yes.
confirming the cancellation of a lease deed which was given in my favor in 1967 due to a default on my part in depositing 50% of the remaining salami amount that was required to be deposited. My lord, this is, my lord, in substance the order. Now, Lord, two things I would like to indicate from the order itself, if your lordship kindly comes to the order impugned.
Yes.
Lord, internal page 11 of the order impugned.
Yes.
Yes. My lord, the fifth line from the top. Now, the Honorable my lord, single judge has observed that in view of existence of a default clause in the contract, the failure to deposit the amount within the stipulated period resulted in automatic cancellation of the allotment. So, my lord, the unequivocal finding is that the cancellation happens automatically as soon as I do not default in payment of, my lord, the consideration towards, my lord, the salami. Now, my lord would see this and, my lord, contrast that with, my lord, page 86, my lord, of my stay application.
That is a clause.
No, that is not the clause. But that is the exercise of the right of Sir Baro. Lord would see this letter has been issued in the year 2018 on, my lord, the 10th of May. And, my lord, this right of cancellation is exercised by the state in 2018. My lord would see the last line. My lord, the type copy is also there.
No, this is sufficient.
Yes.
That's
Now, therefore, I, on behalf of the governor of the state of West Bengal, am directed to say that the government of the state of West Bengal has been pleased to cancel the offer of allotment in terms of clause D read with such and such notification of 1967. So, my lord, my first most respectful submission before your lordship would be that there was no automatic cancellation of my allotment in the year 1967 due to my default. It was, in fact, an overt exercise of a contractual right by the state government 45 years down the line.
From the 1985 letter when we issued.
Yes. Then your lordship would come back, my lord, to the impugned order.
But what was your status in the interregnum?
Yes, my lord, the status, I wanted to show that also before your lordship. In the interregnum, what had happened was, my lord, the state government had written to me. I'll show those correspondences.
There are correspondences?
Yes, there are correspondences. There is a proceeding where I apply for mutation. During the pendency of the mutation proceedings, they issue for the first time what I showed to your lordship, this letter of cancellation in 2018. I challenged that before this honorable court, my lord, in a first round of a litigation. In that first round of litigation, my lord, honorable single judge, my lord, directs that my lord, case be considered in accordance with law. After that, my lord, consideration is given. After that consideration, again the order of cancellation is confirmed. My lord, that results in the second writ petition, from which I am in appeal before your lordship.
But that doesn't answer a question. What was your status in the meantime?
Yes, my lord. My status in the property was that I was on the property. The documents on record from the state, my lord, show that I have been asked to clear, my lord, the vacant property which has been allotted to me because of, my lord, the growth that had happened there. Or whatever, my lord, because the plot was lying vacant, my lord, naturally, my lord, nature takes over.
It was given for a particular purpose, industrial purpose.
This is, my lord, the Salt Lake allotments of, my lord, the late 60s that happened, my lord, post, my lord.
This was for residential purpose?
Yes, yes.
Achha, please show us the clause, Mr. Bhattacharya, before proceeding further.
Yes, my lord.
The
Well, I wanted to show your lordship the
Under which-
original terms of allotment first.
Yes,
Yes,
yes.
that is what I want.
That has been continuing in different forms, maybe.
Yes, yes, yes.
So that D and F probably.
Yes,
would
yes,
be
DNF, absolutely, my lord. Your lordship would take page 52. 53, my lord, I apologize.
There are paginations of all fonts and. Yes.
Well, 4 rounds of litigation, my lord, pagination, my lord.
Each round has a set of
Each
litigation.
round has
Yes.
my lord, page 53, my lord.
53, please.
Yes,
Yes.
my lord, would kindly see clause, my lord, D first and foremost.
Yes, yes, yes.
The remaining 50% of the premium of salami will be paid within 2 months from the date of receipt of the information that the land is ready for delivery of possession. And my lord, clause F, on failure to make payment of the installment referred to in clause D above within the prescribed period, the earnest money mentioned in clause B will be liable to be forfeited and the allotment order cancelled and the government be at liberty to offer the plot to another party. Now, my lord, admittedly, they have, my lord, given me the notice to take possession on March 3rd, 1970. That is on page 60, my lord, of the stay application.
The 3rd March?
1970, 30th March 1970. But I was called upon.
So you have to pay this remaining 50% within 2 months from
March
that date.
30th, 1970, my lord, I had to deposit the money within May 30th, 1970, my lord, and I am in default thereafter.
But what is your interpretation? Irrespective of their subsequent cancellation, may be superfluous, Mr. Bhattacharya.
Yes.
If the clause says that it's liable to be forfeited, you may at best have a play of words on liable to be forfeited. Because it may be you say that liable to be forfeited, liability to be forfeited, that does not mean it will stand forfeited.
Correct.
So there may be a play of words on that, that liable means you have to exercise that option of forfeiture.
And my lord, my most respectful submission before your lordship is the state chose not to exercise such right of forfeiture for the next 45 days. 45 years. Because 45 days, my lord, it won't be a problem.
Yes.
And offer to another party. So this offer was.
Yes. And my lord would kindly note clause F. It says it is liable to be forfeited.
That is what is told you.
Yes. And the second part, that the state can offer it to a third party. That was also not done.
No, unless it is forfeited.
Yes, yes, certainly. Certainly. But my lord,
that is a corollary.
Yes, that is a corollary.
If you read the sentences, will be liable to be forfeited and the allotment order cancelled.
Yes.
So it's liable to be forfeited and allotment order is liable to be cancelled.
Yes.
Liable to is different from shall stand.
Stands cancelled. Now, Lord would kindly turn.
You have been possessing that land from thereafter.
Yes, that is what I wanted to show to your lordship. Lord, page 62.
Probably there wouldn't be any dispute on that.
No.
Because otherwise this order.
No requirement of cancellation then. Yes. Lord, page 62. Lord, this is again the state's letter. This has been issued, my lord, in the year 1985. So, my lord, this is well after May 1970.
Yes. What is saying that?
Down the line, yes. My lord would see. It is to bring to your kind notice that your above mentioned plot of land has virtually turned into a jungle overgrown with wild plants and weeds, serving as a haven for snakes and insects. It may be realized that the condition of the plot is posing a threat to the public health and security, especially to the neighboring plot holders who have already built their dwelling houses on their respective plots and started living there. The block committee representing the local inhabitants have already lodged their complaints to this office and requested for immediate remedial measures. In the circumstances, it is requested that adequate steps may please be taken for clearing your said plot at the earliest convenience for the interest and welfare of all concerned. So, this is just to show to your lordship that it is not in dispute that I was in possession.
Do you plead waiver by the state?
What?
Do you plead waiver by the state?
Yes, Lord, I am pleading waiver. And my lord, I am also taking a plea additionally.
Yes.
Which dwells, my lord, from the realm of contract. Lord, here, what is apparent, my lord, from the conduct of both the parties, that time is not of the essence. Lordship knows if time is not of the essence, what is the fallout of that?
You're ready with that salami?
But I am ready with that salami, and my lord, I have to be, my lord, absolutely fair before your lordship. Your lordship will put me to terms.
Interest.
Yeah, whatever, my lord, whatever your lordship deems fit, I am
Interest
leaving.
from that date.
Yes, my lord, as your lordship. That
Agreeable to that.
yes, that is my lord.
Ajay, let us see the order in
Yes.
the
Lord, I may request my learned friend to place the entire order.
Yes, yes, I
It's a
will.
very
No,
perfect
even if
order.
it doesn't, you will place it.
Yes, yes.
He's placing piecemeal.
He has not placed at all. He has just started his. Yes.
Now, my lord, para 17 then.
Oh, yes. You're right.
Yes. No, my lord, I just wanted to show the part
No,
of the
no.
judgment and then the.
Yes, yes, prefer that.
After lapse of 45 years, Mr. Such and Such approached the authorities for the first time with a request to accept the balance amount of the salami. A person who remains indolent and fails to assert his rights for such an inordinate period cannot invoke the equitable jurisdiction of this court. Equity aids the vigilant, not those who sleep over their rights. Therefore, there is neither any infirmity nor perversity in the decision of respondents in refusing to accept the remaining portion of the salami after such an extensive delay. I find no illegality, irrationality, or unreasonableness in the said decision warranting interference under Article 226 of the Constitution of India. I concur with the submissions made by Mr. Such and Such that the act of granting a hearing to Mr. Such and Such and directing him to produce relevant documents relating to the land in his possession cannot be construed as conduct indicative of an intention on the part of the authorities not to treat time as the essence of the contract. So again, I join issue. Such contract does not lead to a construction that the stipulated timeline was not binding upon the parties. If the timeline was binding, my lord, in my most respectful submission, exercise of that right of the state had to be done in May 1970.
Was the other correspondence also between you?
Yes.
You have annexed it.
Yes, yes, I have annexed it. Notably, no, my lord, again, this is also, my lord, relevant. The authority has accepted the unpaid portion of the salami or premium in appropriate cases up to 25 years from the allottees. However, this was a policy decision of the state. Standing here today before your lordship, I do not want to take the argument of an eye for an eye. But my most respectful submission would be
no negative equality, Mr.
Yeah, there is none. But there has to be an iota or an inkling of a justification as to the distinction between 25 and 45 years if the case that is being made out before the court is exercise of a right of cancellation automatically.
So not eye for an eye, but iota for iota.
Iota for an iota.
Very well. So 25-50, I mean, it's... so
25-45, yes.
That probably is not so German.
Yes.
Because you cannot claim a negative equality on that premise. Yes.
No, but
parity cannot be claimed on that.
But I'm not claiming parity. But what I'm beseeching your lordship, this is purely a question of equity.
And also probably you may argue that by doing that in other cases, the state has made it clear that that clause is not so mandatory as it.
Absolutely.
Very well.
So the scope was there before and it is a residential plot of land, which is at the end of the day going to be allotted to another person who will use it for residential purposes. Now, my lord, I am only beseeching your lordship because, my lord, I can be put to terms. I do not want to take an unfair bargain from the state. I can be put to terms and it can be given to me.
Right. So let us hear.
But I have a few judgments which I wanted to show you.
Not so few, one or two. Very
well.
This is the most relevant ones.
Yes, my lord. The first one, my lord, I was placing is, my lord, Terry Oates. This is 2004 2 Supreme Court cases 130. Okay. 30. So, diye the copy. Okay.
Tell him the next judgment you will be citing so that he's prepared.
Yes, yes.
Any particular paragraph?
Yes, my lord, I am just indicating the paragraph. My lord would kindly take it from para 43 onwards. Now, this is, my lord, squarely on the proposition that resumption of the land should be a last resort. Because my lord, the English principle of proportionality has been considered here. That is why I was citing this. Huh? But I'm placing from 43. In terms of the provisions of the Act, the respondents are entitled to 1. Resumption of the land, 2. Resumption of the building, and 3. Forfeiture of the entire amount paid or deposited.
But this was different.
Yes.
Here there is no forfeiture clause in the agreement. In your case,
A resumption of the land would
that is the only sanction given in the contract.
Yes.
In this context, Supreme Court holds that yes, resumption and forfeiture both were available. So resumption should be the last resort. In your case, cancellation is the only remedy.
But the conduct shows that cancellation was not the only option, and it says it is liable to be cancelled.
No, that's on a different thing, because here forfeiture was also available. Anyway, let us proceed.
Yes. The situation thus, in our opinion, warrants application of the doctrine of proportionality. The said doctrine originated as far as back as in the 19th century in Russia.
Justice Sinha means Justice SB Sinha.
Yes, yes.
Skip over 2 or 3 paragraphs and come to the point.
Yes. But para 49 then.
Yes. That also same.
Yes. Very well.
We'll read it. Just give us 2 minutes. Yes. Yes, very well.
But then 54 and 55.
Yes, yes.
It says conclusion. Keeping in view the aforementioned principles in mind, would it be proper for us to take a view as has been suggested by Mr. Such and Such? The answer to the said question must be rendered in the negative if the competing interests can be balanced. The appellants had sought to show their bona fides in making their payments before the High Court. They had also shown their willingness to make the payments on the difference of amount of interest. They, pursuant to the order of this court, not only paid the entire amount due, but also paid ground rent up to such and such, and further paid 10% penalty on the forfeited amount of entire consideration amounting to such and such. The land in question, for all intent and purport, has been transferred in favor of the appellants. They were merely to pay balance amount of 75% of the consideration amount in installments. Similarly, in those facts and circumstances, the Honorable and there is no malafide on my part. Even as I'm standing today before your Lordship, I am willing to be put to terms. What puts me to terms,
Good. What else? Judgment?
Yes. And just one judgment on the issue of waiver. This is waiver. Well, just one judgment. I apologize. This is 2023 SCC Online Calcutta 238. Kobita Sinha versus State of West Bengal. Kobita Shah. SCC Online Calcutta 238. Yeah. It's to be
Yes.
Yeah. But the sum and substance of the submission is recorded in paragraph 5. And the holding starts from paragraph 14. The court's view, that is the paragraph heading on top. If we scrutinize the material on record, we shall find that the latest mutation certificate dated such and such directed the mutated lessees to complete the construction within 6 months from the date of issuance of the said certificate. Not here, in this case, the issue was that the construction has to be concluded within that specified period, failing which there is a default resulting in resumption. It is true that prior to issuance of the mutation certificate, there were serious allegations that neither the original lessee nor the subsequent lessees took any positive steps to construct any residential building on the demise premises, and for such failure, the lessees were directed to submit show cause, explanation, etc. But ultimately, the concerned Department of Urban Development mutated the names of the legal heirs of the original lessees and subsequent lessees. But here also, our mutation application was pending. That is when this entire thing transpired. Since this is on condition that they should construct the residential building within 6 months from 23rd of May 2017. This goes to show that the Urban Development Department has condoned or waived the delay already caused by the lessees or their predecessors in constructing the residential building on the demise premises. So, in my most respectful submission, that letter of 1985, the fact that no
cancellation had been issued till 2018. That also tantamounts, my lord, in my most respectful submission, the waiver of the right to cancel.
Here they were given, the mutated lessees were given opportunity by an order such and such to complete the construction within 6 months.
Yes, my lord.
So a lease of life was given to that.
Yes.
In your case, no letter was written to you extending the time for putting in the salami, but
Correct.
basically the facts are similar.
And there's an issue of breach. There's a breach of a contractual obligation. Now, my lord, I am on the principle as to what happens when that breach is not acted upon by the state.
So what was held?
Yes.
Proposition?
Yes.
What is the proposition of law?
Yes. My lord, para 15 lordship takes. The laches, if any, on the part of the original lessee or subsequent lessees for constructing any residential building on the demised land have been erased out as soon as the concerned department gave the mutated lessees an opportunity to remedy or make up the failure or default, as the case may be, in constructing the residential building by issuing the mutation certificate dated such and such. Had they been able to construct the residential building on the demised premises within the stipulated period of 6 months from May 23rd, 2017, there would not have been further question raised on the side of the department. Therefore, the issue of failure for making construction on the demised land can be considered in the light of the condition enumerated in the mutation certificate dated such and such. For the purposes of proper understanding, the mutation certificate is reproduced. Now, para 17, 16. From the contents of the said notice, it transpires that failure of the original lessee or the subsequent lessees in making construction on the demised lands has not been given importance in the said mutation order, and the names of the present lessees in relation to the demised premises have been mutated on the condition that they should complete the construction of the residential building within 6 months from the date of issuance of mutation orders. From the records, it transpires that for the purpose of construction of the residential buildings, proposed building plan was submitted before the Bidhannagar Municipal Corporation on or about 21st of August 2017, and the matter was brought to the notice of the concerned department by issuing a letter dated 23rd of August 2017.
Yes, Mr. Bhattacharya, more or less seen that.
Yes, more or less. Well, this is what I am on.
Fair. So let us hear the other side. Yes.
Oh, the side folder.
My lord, first, may I place the order?
Yes.
Order. My lord, page 146.
We are following the internal pages, so you can carry on.
So, my lord, the tenability and propriety of the order passed by the land
Don't go by this speed. We'll never finish.
By the land manager.
Just read the relevant paragraphs, not the entire narrative.
May I place the entire judgment, my lord? Thereafter, my lord, I
don't. In a nutshell, what is your argument? Please.
My lord.
And the relevant paragraphs for that argument, please.
Page 2. Before addressing the concerned issues, para 2, raised in the writ petition, I would be prudent to outline the key facts that have led to the filing of the present petition, which as follows. Way back in 1967, a letter of allotment, your lordship kindly see, the letter of allotment was issued. No lease, nothing. Your lordship, then letter of allotment was issued under memo number such and such of this said plot for granting a lease for a tenure of 1999 years in favor of Bhagwat Chandra Chaudhary, the petitioner's grandfather, who is since deceased. The letter of offer of allotment stipulated that the offer was made on the condition that the plot would be leased for 999 years upon payment of premium of salami charges at the average of rupees 2,750 per katha, subject to, it is at that point of time that rate was there, subject to adjustment of the final measurement of the plot. The condition is this: in Salt Lake plots, first allotment letter is issued to the parties concerned, and there are certain terms and conditions. He has to pay within 30 days, he has to pay the first amount, that is the 50% of the salami, and then if he agrees with the terms and condition of that, then next process started. This is the thing. Your Lordship, kindly see, the allottee was required to deposit 50% of the salami at earnest money with the Reserve Bank of India. There are certain conditions that salami amount one has to pay before the Reserve Bank of India only, not by check, not by cash, only by TR Form 7, and submit the challan showing the deposit along with the formal application within the stipulated period. C. A clause D and F of the letter further stipulated that the allottee was required to deposit the remaining 50% of the salami within 2 months. This is very important. 2 months from the date of receipt of information that the land was made ready for possession. The land was made ready for possession. In the event, failure to make payment within the stipulated period of 60 days from the date of receipt of such information, the earnest money would be forfeited, the allotment order would be cancelled, and the government would be at liberty to offer the land to other parties. Your Lordship, kindly come to page, my lord, the original allotment letter.
Page 53.
Page 53.
We have seen those clauses.
Page 53 once.
Page 54 contains another clause which may surprise you.
My lord, may I?
No, let us surprise you. Please
May
come to page 54 once.
54.
J. You have written letters to them asking them to clear the jungle, admitting
Yes,
their
J.
possession.
Yes.
Please read J.
I'm-
Please read J.
J. Physical possession of the plot will be handed over.
No, will not be.
Will not be handed over before the premium or salami has been paid in full.
But
In
you
this-
handed over possession?
No,
on 50%.
never.
And you asked them to clear the jungle, though they are not in possession.
I have not. Who wrote the letter? The letter written by not my department.
Oh.
This is written by the administrator of the Salt Lake municipality. They themselves, they are the authority to look after the health
So you say
hazard
that
things.
you never handed over possession to them?
No, we cannot, because he has paid the part salami.
Yes,
And since by 1967,
Yes.
the another part, that is, your lordship kindly come to page that which has been assessed, page 60.
Yes.
60, the bold one. 60. May I read, my lord?
Yes.
I am directed to say that plot number 412 is in block number BD in sector 1 in township, which was allotted to you, is now ready for delivery of possession. Is now ready for delivery of possession. That means measurement has been made.
Yes.
We can deliver it. So you have to put the rest amount of the salami.
Yes.
Then on actual measurement of the plot has been found that it is 2 katas, 30 sotoks and 3, my lord, square feet. An additional amount of 3,595 as calculated on the margin in the left side, it has been given. Then your lordship kindly come to pay, is therefore payable by you towards salami for the said plot. Please deposit the said additional amount within 60 days from the date of the letter with the Reserve Bank of India in the usual manner and submit the receipt of the. Then what happened? The person concerned, in whose name the allotment letter was issued, he died. He died, my lord. He died, your lordship, kindly come to page 61. He died on 23rd of May 2070. And your lordship, once
23rd or 3rd?
23rd.
This is 0 probably. 3rd of May.
Oh, 3rd. I think it is not legible.
Achha.
3rd of May, I think, 1970.
Right.
He died. Now, your lordship, kindly come to
on the last.
My lord, may I
before the time for paying the salami was Expired, he died.
He died.
Hmm.
He died. And my lord, the last given address. So we have only one address in the department that is given in the salami letter, the persons concerned. So they did not inform the department for long 20 years that his father died. So department, my lord, sent letters after letters to the address given given in the my lord original allottees address. And thereafter, after 20 years, his son Rajiv Lochan Chaudhary wrote a letter all on a sudden and said, yes, we please give mutation to the land. How one could give mutation to the land until and unless your lordship kindly sees another thing. Another thing, your lordship kindly come to the page 53 once again. Page 53 last. If on failure of making payment of the installment in clause D above within the prescribed period, the earnest money in clause B will be forfeited and allotment order cancelled, and government will be at liberty to offer the plot to other plot. Then G, the plot of land will be used exclusively for residential purpose. That is not important, my lord. Your lordship then come to, my lord, K, the money deposited under clause B and D towards premium salami will be adjusted amongst the total premium of salami calculated on the basis of actual measurement of the plot. And if any further amount is found to be still due for payment of final calculation, the amount premium of salami, it will be paid within 2 months from the date of receipt of that. Any amount paid in excess, that is not important. In case if you pay the entire amount,
We'll continue after the recess.
Of salami,
We'll continue after the recess, Mr. Continue. Yes, second.
I was placing page number 53.
Right. 54 actually.
No, 54.
Yes.
Paragraph N.
Hmm.
After full payment of all the dues, you will get lease drawn up, executed, and register. This is very important. All expenditure thereof, therefore, will be borne by you. First phase of salami. Then within 60 days, the next part of the salami. Then possession will be handed over. Then, as per J, then lease deed will be executed by the for 999 years between the lessee and the government.
Right.
For the Salt Lake property. Since first part of the salami has been paid and the remaining part of the salami has not been paid after 45 years of paying the first salami, so there is no question of handing over the plot, or there is no question of handing over the executing any lease deed. So there is no lease deed, nothing has been executed. Thereafter, your lordship kindly come to page 59. Allotment of land in the Salt Lake property. So, as per the clause, so one letter of allotment, the land has been allotted to you, but no possession, nothing has been granted. That is this letter 59, and then, my lord, then page 60, the calculation, what is the remaining salami would be, that has been given. Then, your lordship, kindly come to page 63. Page 63. The eldest, one of the son by or elder son, my lord, I think elder son, Rajiv Lochon Sharma, the son of the deceased Aloti,
Chaudhary, yeah.
my lord, wrote a letter after 45 years. Allotment letter was issued in the year 1967. First part of the salami has been deposited in the year 1967, and then thereafter, first letter wrote, first communication written by the son of the petitioner after 45 years in the year on 27/11/15. What is the letter? Your lordship, kindly may I read the last few lines of the first paragraph. Then your department further claim a sum of rupees 3695 dated 31st of March 1970 for the second installment. At the moment, I was unable. At that moment, I was unable to pay the said amount due to sudden demise of my father. When he is writing this letter after 45 years, what is the excuse? Because of my father's death, I could not pay this much of meager amount to the department. This is sheer laches on the part of they sit tight for 45 years and then wrote a letter. And then, my lord, all on a sudden, your lordship kindly come to page 43.
43.
64.
We are there.
64, page 64.
64.
They all on a sudden deposited a sum of rupees 10,000 without having any permission, nothing, by e-challan. By e-challan to the dependent for the purpose for residential and processing fees. What processing fees? For processing fees for mutation. Who asked them to? Deposit? Nobody. They themselves deposited. And how they have deposited? By e-challan. And your lordship, then again, your lordship, kindly come to page 53. How the amount has to be deposited, salami amount, through TR form to the Reserve Bank. They have done nothing. Simply they have, and then after depositing the amount to the department, in the cash counter, in the department.
This is different, mutation processing fee. So this is not,
It is a
they
processing
don't
fee.
also claim that this is salary.
They asked me, yes, muted my name in place of my father. What for the mutation? The lease deed has not been executed. So there is no question for mutation. So then the department asked her, come to the department with all your original documents. They came and they did not produce any original document because they have nothing. Then the department, my lord, cancel their mutation, cancel their, my lord, allotment in the year 1984. So now your lordship kindly come to the
in the year 2018.
2018. 2018. 2018. 2018.
So why did you wait for these 3 years?
Well, we have given them hearing, my lord. And then your lordship kindly come to the impugn order once again.
But you have given hearing for the purpose of mutation.
We have given hearing. They said, yes, we have deposited 10,000 rupees. We want to inquire from them what for they have deposited 10,000 rupees and why they are asking for mutation. What for? What are the original documents they have? For this thing, we have asked them to appear before the land manager and appear before the hearing. They could not produce any single document. Your lordship kindly come to page 148 of the impugned order. That is internal page 3, para F.
Yes.
Nearly 20 years thereafter. It is wrongly stated. It would be 45 years.
45.
Subsequently, it has been mentioned 45 years. Rajiv Lochon Choudhury, in short, Mr. Rajiv, son of the allottee, the late Bhagavat Chandra Choudhury, who is also since deceased, submitted a representation on 26th of November 2015 that I have shown to your lordship just now, to the land manager, urban development department, expressing his intention to deposit the balance amount of premium or salami to the said plot. However, no response was received from the. After 45 years, all on it, he woke up as Rip Van Winkle and then go to the department and wrote a letter. Yes, I want to deposit.
Rip Van Winkle was larger time.
Mr. Rajiv subsequently deposited 10,000 rupees, just what I mentioned,
yes,
with the urban development through e-challan towards the mutation process fees for the said plot of land in the name of the legal heirs of the allottee of the late Bhagavat Chandra Choudhury. H. By a communication dated 24th of August 2016, the competent authority, Urban Development Department, Government of West Bengal, informed Mr. Rajiv Lochon Choudhury that his application for issuance of mutation order in respect of the said plot was being processed and that a hearing would be given. This is simple inquiry. What for he has applied for mutation? What document does he have, does he possess, and all sorts of things with the original documents. A record revealed, thereafter, Mr. Rajiv submitted representation before various authorities requesting regularization of the allotment of the plot upon payment of remaining balance of salami. He further requested the necessary follow-up action to be taken, including the execution and registration of the lease deed, the mutation of the plot of land in favor of the legal heirs of the allottee. J. A letter from the manager, Bidhan Nagar, dated 14th of June 2017 indicates that Mr. Rajiv Lochon Choudhury was requested to submit the original documents pertaining to the plot for further processing and possession position of mutation. In respect of the latter, certain documents were duly submitted. In 2017, Mr. Rajiv Lochon Chaudhary passed away. This is also, yes, my lord. In 2017, the son also passed away. First father passed away, then son also passed away. This is the grandson, filed this writ application. The present petitioner, being the son and widow of Rajiv, then stepped into the shoes and submitted a representation dated 28th of August 2017 to the Secretary, Urban Development Department, Municipal Affairs Department, in short, UD branch, Salt Lake, Calcutta, requesting execution of the lease deed in their favor and mutation of the land in their name, along with the undertaking to pay all the outstanding dues to the state. By an order issued by the land manager, which was communicated to the petitioner under a memo dated such and such, on 10th of May 2018, the petitioner was informed that due to failure of the allottee, the late Mr. Bhagavat Chandra Chaudhary, the deposit to deposit the balance amount of salami within the stipulated time, the Honorable Governor of the State of West Bengal had been pleased to cancel the offer of allotment of the plot in terms of clause D, read with clause F thereof. Assailing the aforementioned order, the present petitioner filed a writ petition being number 8991 of 2018, which was disposed of by a coordinate bench. By an order dated 6th of July 2018, the bench directed the land manager to consider the petitioner's application afresh after affording an opportunity of hearing to the petitioner and all other relevant officials involved in this dispute, and to dispose of the application within the time specified therein. Pursuant thereto, the order under challenge in present writ petition was issued by the land manager, refusing to entertain the petitioner's prayer for the execution of the lease and mutation on the ground that the allottee had failed to deposit 50% of the salami amount within the stipulated time stipulated in the letter of offer of allotment. Aggraved thereby, the present writ petition has been, this is the second round of writ petition. As directed, the petitioner, respondent number 3 and 4 have filed their affidavit in opposition. Then 4, the crux of the defense taken in the affidavit in opposition is that since Mr. Bhagavat Chandra Chaudhary failed to deposit 50% of the salami within the period specified in the letter of offer of allotment, the offer was cancelled long after 45 years from the cancellation of the cancellation of the allotment. The petitioner's father approached the authorities seeking permission to pay the remaining part of the salami. However, the authorities concerned deemed this request to be untenable and therefore it was not accepted. Mr. Bihani, learned advocate representing the petitioner, contended that although the letter of offer of allotment specified a time frame for the deposit of 50% of the salami, the respondent did not treat the time period as being the essence of contract. He argued that upon acceptance of the earnest money from Mr. Bhagavat Chaudhary, possession of the plot was effectively handed over. This is their argument, handed over to the petitioner. This he submitted is substantiated by a communication from the administrator. This administrator is the municipal authorities administrator. They look after the health hazard this thing, and they ask the letter, so you cut off the bushes grown up there so that the mosquito cannot grow there. Directing the petitioner to clear wild vegetation from the plot. Furthermore, Mr. Bihani submitted that the subsequent conduct of the respondent, such as affording the petitioner an opportunity of hearing in connection with the mutation of land and requesting documents from Rajiv Lochon Chaudhary, clearly indicates that the respondent did not treat the offer as having been cancelled, and still there is a novation of contract. Then 6, inviting my attention to 3 memorandums dated such and such. Subsequently, these memorandums were issued by the government. This is not applicable. That has been mentioned here. And then 7, in rebuttal, Mr.
No, 6,
Bandyopadhyay.
it says that by the memorandum dated 8th July 1988, time for depositing 50% was extended. What about this?
This is not for the, this is for the leaseholders. Those who have already enjoying the lease, this is for the leaseholder, not the allottees.
Who are already enjoying lease, they must have paid that 50% as per your argument.
This is related to the 25-year exemption that has been given.
This is for the leaseholder, those who are holding the lease between the government and the person concerned.
But as per
But
your
here no
argument,
lease has been
as per
executed.
your argument, Mr. Karan, no lease could be executed if the total salary was not paid.
Not paid.
So how could leaseholders be leaseholders without payment of 50% of salary?
That's why these circulars which was issued subsequently, the cause of action arise in the year
No,
1967.
that is not our question. Mr. Karan, a specific question is, you argue that without 50% payment of the entire salary, including the balance 50%, no lease can be executed.
Yes, Manu.
Now, in the same breath, you are arguing that these memoranda related to leaseholders who had not paid 50% of the salary.
No.
Aren't these
That
contradictory?
is my argument. That's my
No,
argument.
not your argument. The second part is borne out from the records.
Yes, Malad, may I read, Malad?
You say they are leaseholders. How
Malad.
could they be leaseholders in the first place without 50% of salary?
May I?
Then there could be leases granted without 50% payment.
No.
You are
This
saying
is
these
not-
subsequent
This
memoranda
is
where
not my submission. This is the submission of the rival parties. This is the submission
no,
of the.
your submission is that these are leaseholders. We ask you a question that this, what about this memorandum extending the time for depositing 50% for some people, 50% of salami for further years? You
Yes,
say
my lord,
these
my
were
lord.
regarding leaseholders.
My lord, I shall elaborately, my lord, the circular is not with me at present, my lord. I shall paste the circulars and then, my lord, argue on that point, my lord. My lord, 7, in rebuttal, Mr. Bandyopadhyay, senior standing counsel for the state, submitted that the letter of offer of allotment did not contain any provision pertaining permitting even the state to accept the remaining 50% of the salary beyond the date specified therein. According to him, upon the expiration of the stipulated date, the allotment stood automatically cancelled. He further contended that although the petitioner had submitted an application for mutation and were accordingly summoned for a hearing and asked to produce relevant documents, their prayer for mutation was ultimately rejected. He argued that the mere grant of a hearing prior to rejection of the application cannot be construed as an acknowledgement by the state of any continuing right on the part of the petitioner to deposit the balance salami after the lapse of 45 years. He also emphasized that the fact that in few isolated cases, certain allottees were permitted to deposit the balance amount of salami does not create any vested right in favor of the petitioners to compel the state to accept the same and regularize the allotment after such an inordinate delay. Heard the learned advocates representing the parties peruse the materials on record placed before me. As previously noted, clause D of the letter of offer of allotment stipulated that the remaining 50% of the premium or salami was to be paid within 2 months from the date on which the allottee received information that the land was ready for delivery of possession. Clause F says, which operated as a default provision to clause D, provided that in the event of failure to making a payment within the prescribed period, the earnest money referred to in clause B would be forfeited and government would be at liberty to offer the plot to other person. 10, it is undisputed that 31st of March 1970, the original allottee, Mr. Bhagavat Chandra Choudhury, was informed that the land was ready for delivery of possession. However, Mr. Choudhury failed to deposit the remaining 50% of the premium or salary. Notably, the term of the contract did not contain any provision authorizing the state to accept payment of the balance premium or salami beyond the stipulated period. Referring the decision of Binod Kumar Supra, Mr. Bihani reminded the court of the well-established principle of law that judicial review of administrative action is premised on the grounds of illegality, irregularity, and unreasonableness, particularly Westbury unreasonableness. He submitted that in the present case there is manifest unreasonableness in the administrative action of the authorities in refusing to accept the remaining 50% of the premium or salami from the petitioners. Accordingly, he argued that the court should exercise its power of judicial review to address the injustice caused to the petitioner. Then 12. There is a catena of decisions of the Supreme Court which ruled that the matter involving contracts entered into between a government agency and private individual, the scope of judicial interference is limited. The government must be afforded a reasonable degree of freedom in matters of contract. It lies within the exclusive domain of the government to prescribe terms and conditions of such contracts. However, such conditions are amenable to judicial review if they fail to meet the test of reasonableness and fairness in action. In the context of the administrative decision pertaining to contractual matters, the power of judicial review may be exercised only upon a clear finding that the process adopted or the decision taken by the authorities was malafide and or so arbitrary, irrational, and unreasonable that no reasonable person acting in accordance with law would have arrived at such decision. The purpose of judicial reviews is not to assess the wisdom or soundness of a decision, but rather to ensure that the decision was made lawfully and in accordance with the principles of natural justice. Undeniably, the jurisdiction of the High Court under Article 226 of the Constitution of India is extraordinary, equitable, and discretionary in nature. However, the exercise of such discretion must be guided by judicial principle and not by arbitrariness. While a party may seek relief on equitable grounds, it is a well-settled principle that equity cannot be claimed as a matter of right when the claim is otherwise founded on legal ground alone. A party involved the equitable jurisdiction of the court must approach with clean hand and be free from any blameworthy conduct. Before exercising the equitable discretion in favor of the party, the court is well within the authority to scrutinize the conduct of the party. Needless to say, the right and liability of the parties to a contract must be determined based on the terms and conditions expressly agreed upon in the contract. A party of the contract is bound by those terms and conditions at a later stage unilaterally impose any new term or condition that was not part of the original offer. 16. In present case, there was no provision in the letter of offer of allotment empowering the state to accept the remaining 50% of premium or salami beyond the stipulated period. The original allottee having agreed to the condition requiring him to deposit the said amount within the prescribed time, failed to comply with the obligation. In view of the exercise of a default clause in the contract, the failure to deposit an amount within the stipulated period resulted in automatic cancellation of the allotment. After a lapse of 45 years, Mr. Rajiv approached the authorities for the first time with a request to accept the balance amount of salami. A person who remained indolent and failed to assert his right for such an ordinate period cannot invoke the equitable jurisdiction of the court. Equity aids aids the vigilant, not those who sleep over their rights. Therefore, there is neither any infirmity nor perversity in the decision of the respondent in refusing to accept the remaining portion of the salami after such an extensive delay. I find no illegality, irrationality, and unreasonableness in the said decision warranting interference under Article 226 of the Constitution of India. I concur with the submission made by Mr. Bandopadhyay that the act of granting a hearing to Rajiv and directing him to produce relevant documents relating to the land in his possession cannot be construed as conduct indicative of an intention on the part of the authorities not to treat time as the essence of the contract. Such conduct does not lead to a construction that the stipulated timeline was not binding upon the parties. Notably, the authorities had accepted the unpaid portion of the salami or premium. Notably, the authority has accepted the unpaid portion of the salami or premium in appropriate cases upon up to 25 years of the allotee. However, this was a policy decision of the state. I find no justification to persuade me to hold that this policy was flawed on any ground of malafide, arbitrariness, or that is failed to meet the test of reasonableness. Such a policy decision does not confer any vested right upon the petitioner to compel the state to accept the remaining portion of the salami even after 45 years, or to allow the petitioner to resuscitate to cancel contract. In view thereof, I am of the considered opinion that the petitioner have failed to establish any ground that would warrant the court's interference with the decision of the respondent in not regularizing the allotment in favor of the petitioner upon the acceptance of the remaining 50% of the salami after 50 or 45 or 50 years. Considerably, the writ petition is thus dismissed. Your Lordship, kindly see the things. The letter, first letter written by Mr. Rajiv Lochon Choudhury. He says, I cannot pay the salami, that very meager amount, 3,600 and odd, as my father died. His father died in the year 1970, and he waited thereafter for 45 years to say this, that I cannot pay this meager amount because my father had died in the year 1970. This is the excuse he has given to the department. Your Lordship, if it is a case that Rajiv Lochon all through approached the department in the year 1970, even he did not inform the department that his father had died in the year 1970. This is sheer negligence on the part of the, my lord, part of the allottee's legal heirs. He should have immediately, but he did not. What he did, after 45 years, he wrote a letter to the department that we could not deposit. Please allow me to deposit. This cannot be. Your Lordship, kindly visualize the Salt Lake property is such a valuable land. My lord, this runs for crores, my lord, nowadays. And the property is held up by a person by only paying 2,750 rupees since 1967 to 1984.
Held up?
Not held up, my lord. The authority could not take because the decision, because, my lord, because he has paid a meager amount of salami.
If he was not in possession, no lease deed was given, why didn't you offer it to someone else for this long period?
No, we cannot.
Why can't
until
you?
and unless we cancel the allotment.
So therefore, cancellation is not automatic.
The cancellation is my lord automatic because he did not pay the amount.
Cancellation was automatic, then it befell them whenever they did not pay. Then why did you wait for 45 years for allotting it to others?
It is not me for waiting for 45 years. It is they.
If cancellation was
for
automatic,
45 years.
if cancellation was automatic,
Yes,
then
my
why
lord.
didn't you take steps to give it to other persons? It was automatic.
We could have, but your lordship sees the government department, how the government department functions, my lord.
How does the government department function?
My lord, they naturally did not take away
It's a natural right of the government.
That's a person's right. Whatever they are, my lord, there.
How can you say they are holding up? That's a Freudian slip.
My lord.
How can you say they are holding up the property? That's a Freudian slip if they are not in possession.
They are not holding up.
You say they are not given possession ever.
No, we have not given possession to them ever. We have not given possession to them ever. It was the government land. It was remain with the government. Only a part of salami. It is like, my lord, I want to purchase a land from somebody else, Mr. B. I agreed to, my lord, signed a agreement where it has stated that within such and such period, you have to execute the sale deed and you have to pay the remaining amount, and then the registration will be done. It is like that.
The learned judge says that the 25 years extension was given to other allottees, not leaseholders.
No, they were submitting. They were submitting that you have done some cases. You have done after 25 years. You have allowed someone to deposit. That's why the argument was there. They did not place any document whatsoever there at that time of argument. They simply said that you have given to after somebody after 25 years.
Holds notably the authority has accepted the unpaid portion of the salami or premium in appropriate cases up to 25 years from the allottees. If you took gave 25 years to other allottees, how could you give that if cancellation was automatic?
The cancellation
in a cancelled allotment, can you give 25 years extension for further deposit of salary?
I don't know, my lord, what happened to those cases, my lord. I have to then inquire into department, my lord, what are those cases and what actually happened, my lord. This is the passing comment, my lord, made by the petitioner, my lord, before the
learned judge.
My lord, that has been recorded by my learned judge, my lord, deciding.
Learned judge does not say they have their submission. Notably, the authority, it's a finding, has accepted unpaid portion of salary. That's a finding of the learned judge. And also that argument was recorded in the learned judge's impugned order.
It is their stand also. Your lordship could find that on page 1 or page 8, internal page 8 of the order, para 7 at the bottom of the page.
Internal page 8.
Yes. When we asked him the question, and he said that those are given to lessees.
Yes.
When he was reading this, we asked him that question.
Yes. Internal page 8, 7th paragraph, the last 4 lines.
Internal page
yes,
8.
yes. We asked you this, you said that those were given to lessees.
Yes.
No. Page 8, last paragraph.
Internal page 8. The 7th paragraph, the last 4 lines from the bottom.
Oh, yes.
He also emphasized, would see.
Yes, your counsel.
Yes.
He also emphasized that in few isolated cases, certain allottees were permitted to deposit balance amount, but that does not create any vested right. It does not create any vested right, Mr. Karan. We agree with that. Because some allottees were given, it's your policy or whatever. But it shows at the same time that cancellation is not automatic. If it was automatic, in a dead allotment, you could not give this exemption of 25 years to pay the balance salary.
Once again, your lordship kindly read the my lord letter 53.
No, it's your action we are speaking of, Mr. Karan, not the letter. You interpreted, you proceeded on the premise that clause is not mandatory. By giving extension to some people at least, even if one person is given extension for payment of balance salary, by virtue of that, you admit that the cancellation was not automatic upon non-payment of that 50%. Because if cancellation was automatic, for those people also it would be automatic. Would be no scope of giving extension.
My lord, may I say this? May I say this, my lord? My lord, the each and every plot is different. The case of each and every plot, their fact scenario are different. I don't know under what circumstances this has been given and to those plots, my lord, after 25 years.
There were different laws for different persons in Salt Lake allotments.
No, no, no.
Certain allottees, your argument is that certain allottees were permitted to deposit the balance amount of salami. You admitted that in few isolated cases, you equate these people with them, but say that does not create any vested right in favor of petitions to compel the state to accept.
In that event, my lord, I have to take instruction. I can, my lord.
No question of further instruction. Your argument stands before the learned single judge.
Yes, my lord.
How can you result from that? So if in a few isolated cases, certain allottees were permitted to deposit balance amount, Mr. Karan, definitely that does not create a right in their favor.
My lord,
But that shows that cancellation was not automatic. And in your agreement, you read out the clause, Mr. Karan, and you also read out that portion, liable to be cancelled.
Yes,
and in your arguments also, you said that has to be cancelled by a further act. That's why. Now, if it has to be cancelled, now then, unless you cancel, the right subsists.
My lord, earlier, my lord, word, my lord, that the salami amount would be forfeited, my lord. If it is not paid, the earlier salary which has been paid, that would be forfeited.
Yes.
If the first part of the salary is being forfeited, then what remains?
The rest remains the right to assert their rights on that agreement. Please come to page 53 once.
53, your lordship, kindly.
On failure to make payment of the installment referred to in clause D above within the prescribed period, the earnest money mentioned in clause B will be liable to be forfeited, not will stand forfeited. There's a huge difference between the two.
Yes,
liable to be forfeited and the allotment order cancelled. That means the earnest money stands liable to be forfeited and the allotment order stands liable to be cancelled. And the government will be at liberty to offer the plot to another party. Now, you have not offered the plot to another party for so long. You have not cancelled the allotment. Your cancellation comes also after 45 years.
My lord, I shall come up with a judgment, my lord, which says, my lord.
There is a question of future tense. We are hearing it finally.
No, my lord,
no question. We will not give you time to come up with further judgment.
Opportunity, my lord, since
they
have referred two judgments, my lord. I have.
You answered those judgments. No.
In my favor, my
lord. 1 second. No, you cannot argue that. You know what is the contention in the appeal. They have argued judgments. They have cited judgments. You deal with those judgments.
Judgment is not applicable because that is related.
So you argue on those judgments. That does not give you a right to take another adjournment for coming ready with other judgments. No. You come ready, prepared on. You should come prepared on your own arguments.
No, my argument is that my argument would be, my lord, that
you know what is in contention in the appeal.
Yes, my lord.
Yes.
That after
you don't have a matter of right to come take another adjournment for coming ready with the judgments just because they have cited judgments.
Prayer before your lordship.
No further day. No question. We have
prayer.
heard it conclusively. No. Just complete your arguments. Yes.
My lord.
On what proposition? Tell us.
In few cases, after 25 years, my lord, your lordship just says, it has been stated in the writ of decision that the person concerned was allowed to.
What is the proposition on which you want to say that?
Allowed to deposit the.
Yes, don't repeat that.
These are all stray cases, my lord. That cannot, my lord.
That cannot what?
A precedent. That cannot be taken as a precedent. So that in this case also,
Mr. Karan,
each case is individual case and each.
If you want to complete your sentence, you complete your sentence, but that does not give you any edge because we are asking you a question. You have to answer that.
Yes,
at the end of your sentence, we'll still ask you the question and you'll still have to answer that.
Yes,
so you can complete your sentence and delay, but we'll ask you the question still and you will still have to answer it. Our question is very specific. You completely misunderstood it. Our question is, yes, you may be right in submitting that in certain stray cases, even if laxity was given, relaxation was given regarding the time period for salami, that does not create any right in their favor.
Yes,
let us agree with you on that. We are not on that at all. But the very fact that in certain cases you gave relaxation by extending the time period for payment of the balance salami shows by your action that cancellation was not automatic. You had to cancel and you did not cancel for 45 years. Now, how can you blame them? The relationship, dual relationship stood until you cancelled.
My lord, my lord, your lordship kindly come to page.
It's not a question of their vested right.
My lord,
The relationship remains.
Understood, my lord. Your lordship kindly come to page, my lord. Page 70. Page 60. One second. Your lordship kindly come to page 60.
Yes, page 60.
This is my notice. I have given this notice asking them to pay the remaining amount of salami.
Who
that is
denies
rupees
that?
about-
Absolutely. Yes.
They did not pay it. It is their duty to pay the department. My
If
duty
they
is
don't
to ask
pay, then
them-
what happens? As per your clause, what happens? Let us put it like to a school
My lord,
student.
it
What
will-
happens then?
It will, according to me, my lord.
No, according to the agreement, what happens?
According to the agreement, it will not only cancel automatically, but my lord, we have to give them a hearing, and then we have to give some hearing to them.
We're
and
not even
thereafter-
speaking of hearing. We are speaking that it is not automatically cancelled, but you have to cancel.
Yes, I have to cancel.
You have not
cancelled.
cancelled
We
for.
cancelled it.
You cancel it after 45 years.
We cancel it after 45 years. It's a fact. We cancel it after 45 years. Your lordship, kindly see the conduct of the petitioners.
Whatever
What
their
they have
conduct,
done,
if you did
they-
not cancel
they
the.
only paying 2,750 rupees. They blocked the land. They blocked the land. They blocked the valuable land for so many years without taking any step.
The more you speak, the more you clinch the case against your client. They have blocked the property, then they were in possession.
They are not in possession. We have never ever.
How did they block? Notionally.
Notionally.
What do you mean by notionally?
Yes, my lord.
Notion. What is the meaning of notionally?
My lord, may I put it like this?
No, you may not. What is the meaning of notionally? How can someone block a property if he is not in possession? Tell us. We fail to understand. He casts some magic spell over the property.
My lord, this is a government land. We cannot.
Not government land.
My lord, we cannot throw somebody away without taking any legal step.
You have to throw somebody away if he's there in possession. Therefore, he's in possession, you are admitting.
We have allotted them. They are the allottees. They have paid 50% salami for that. So until and unless we
Karan,
officially cancel,
even if we want to throw you away, we want to throw you away. Notionally. But we can't. Do you know why? Because you are here in court. If you are not in court, there was no question of throwing you away. Because you are not there. Away means you are here. You thrice said they are blocking the property. They are in possession of the property. You cannot throw them away. Then they are in possession.
specifically I had mentioned throwing the clause of the allotment letter, clause G, that until and unless they paid the full amount of salami, that is part 2 and part
They are not entitled to a lease deed.
they not entitled to
Consequences.
even possession of the property.
Consequences, you can cancel this allotment.
Yes.
You have cancelled in after 45 years. Till you cancelled, then they had the right to make good the balance salami. Because the jurial relationship, by your conduct, you have shown that clause is directory. The time period for payment of salami, you have two conducts of yours. One, regarding them, you have not cancelled as yet. Two, you have given an extension to other persons for 25 years. So therefore, you have by your conduct, Mr. Karan, showed that this is a directory clause. The time limit is directory. Time is not the essence. Time is not the essence. If time is not the essence, then their non-payment till your cancellation they cannot be thrown out like that, as you said.
No, my lord, I put it in the another way.
Yes.
They cannot ask for mutation without paying the total salami amount and claiming the property as
We'll direct them to pay within a month, give them mutation and give them possession. We agree. We agree with you. We are disposing of the matter. They'll put it within 2 months. And if they fail to pay within 2 months, we won't give them. Otherwise, give them mutation, give them possession. Possession is already with them, execute the lease deed.
But
you agree with that? They cannot. We agree. They cannot, without payment of the balance salary, they cannot enter into, they cannot have a lease deed and mutation. Therefore, they'll have to pay the entire salary balance.
Clause I am submitting, this is the clause has been, this has been written here.
We agree with you, the clause. They have to pay.
Your lordship, kindly see their conduct. Your lordship, kindly see their conduct. They waited for 45 years doing nothing. They have sitting tight. They sit tight over the matter. And then all on a sudden, after 45 years, they wrote a letter to the department and yes, give me mutation. I want to pay the salami. For their such conduct, my lord, the department has rightly done the cancelling the, my lord, allotment letter, my lord.
You feel so. It's your opinion.
Before your lordship pronounces, my lord, there is a factual inconsistency. It's my duty to point out, my lord. That is why I am pointing it out. Otherwise, I did not want to.
Yes,
reply.
yes.
My learned, my lord, seniors just submitted, my lord, that the administrator, that is the person who wrote the letter in the year 1985,
jungle letter,
is of a different department.
Not their person.
But
Yes.
that is absolutely incorrect. I'm showing the website of the Urban Development Department. Is the first officer name.
No need. No.
That is all.
You cannot look into something.
That is all.
But what about this being irrigation and waterways department? That agreement? The agreement was entered into by the Deputy Secretary Irrigation and Waterways Department.
But perhaps not that. Remember the agreement of the year 67, your lordship?
No, your agreement, 53.
Yes, that is of the year 67. But the agreement is with that department, but it has been executed by the governor. On behalf of the governor, by the Deputy Secretary to that department. Perhaps, my lord, the land allotment scheme has changed and it, but I do not, my lord, want to speculate. But it is the Urban Development Department which has cancelled my letter of allotment.
Initially, it was agriculture department. Then it irrigation earlier. Then urban development. It goes to urban development.
Urban Development has cancelled the. That is on page 86.
Now the entire property is being managed by the urban development.
Yes. The present appeal arises at the behest of the writ petitioners, against the dismissal of the said writ petition by the learned single judge. Push up next para. The case, in a nutshell, is that the grandfather of the present, the predecessor in interest of the present appellants, namely one Bhagavat Chandra Chaudhary, was given a letter of offer of allotment by the government of West Bengal through the then Irrigation and Waterways Department, under the pen of the Deputy Secretary, Irrigation and Waterways Department, Government of West Bengal, and by order of the Governor of the State of West Bengal on, what was the date? September 29.
The letter of September 28, 1967.
September 28, 1967. First up, next para. In as per the clauses of the said agreement, the plot in question was put up for lease for a period of 999 years on payment of a premium or salami charged at the average rate as stipulated therein, out of which 50% of the salami was to be deposited as earnest money with the Reserve Bank of India, Calcutta, by a challan in TR form number 7 and submit to the government the receipted challan along with the formal application in duplicate, as per the modalities as prescribed therein. Full stop, next para. The remaining 50%, as per clause small d within bracket of the said offer letter, of the premium or salami was payable within 2 months from the date of receipt of the information that the land is ready for delivery of possession. Full stop, next para. The subsequent clauses, in particular clause small f within bracket of the said allotment letter made it abundantly clear that on failure to make payment of the installment referred to in clause small d within bracket within the prescribed period, comma, তারপর double inverted এর মধ্যে the earnest money mentioned in clause small b within bracket will be liable to be forfeited, the italics এ, and the আবার italics allotment order cancelled, italics stop, এমনি continue, and the government will be at liberty to offer the plot to another party, full stop. Next para, conspicuously, comma, in clause small j within bracket thereof, comma, it was stipulated that physical possession of the plot would not be handed over before the premium or salami was paid in full, full stop. Next para, clause small n thereof provided that after full payment of all the dues, the applicant would get the lease drawn up, comma, executed and registered, full stop. Next para, the petitioner's case is that due to the demise of the original allotee, that is Bhagavat Chandra Chaudhuri, within the stipulated period for payment of the advance of the balance salami, comma, his son, comma, Rajiv Lochan, comma, was not in a position to pay the balance salami, full stop. However, comma, Rajiv Lochan approached the respondent authorities after about 45 years, comma, in the year 2015, comma, whereas Bhagavat had died in the year 1970, comma, for the purpose of depositing the balance salami and seeking regularization of the lease to be granted in favor of the said Bhagavat, full stop. Next para, upon such approach being made, comma, and an application being made for mutation of the property in the name of Rajiv Lochan, comma, the respondent authorities gave a hearing to Rajiv Lochan, comma, asking Rajiv Lochan to bring the relevant documents in respect of the property, full stop. Next para, in the letters in question, comma, issued by the authorities, comma, it was indicated that the application for issuance of mutation order of Rajiv Lochan in respect of the concerned plot of land was being processed, and that a hearing would be given in the chamber of the competent authority, comma, Urban Development Department, bracket UDD, comma, Government of West Bengal, on September 2, 2016. Full stop. Next para, by a subsequent letter from the land manager, comma, Bidhannagar, dated June 14, 2017, comma, it was evident that the said authority requested Rajiv Lochan further to submit original documents pertaining to the plot, তারপর double inverted, for further processing and the possession of mutation, double inverted close, full stop. Next para, learned counsel for the petitioner appellants argue that by virtue of the said letters, as well as a letter issued by the administrator, comma, Bidhannagar, comma, who is the first officer of the UDD, dated August 31, 1985, comma, asking the predecessor in interest of the appellants to clear the jungle which has grown over the plot in question, comma, the respondents admitted that all along, comma, the possession was with the predecessor in interest of the appellants, full stop. Next para, it is submitted that in terms of the relevant clauses of the allotment letter, comma, in particular clause small f thereof, comma, In the event balance salami of 50% was not paid within the 2 months as stipulated in clause small d within bracket, comma, the allottee suffered the liability of the earnest money being forfeited and the allotment order cancelled. Full stop. However, comma, by its very nature, comma, clause small f did not contemplate an automatic cancellation of the allotment order in the event such payment was not made in due time. Full stop. Next para. Moreover, comma, by the conduct of the respondent authorities in not insisting upon the earnest money but having handed over possession of the property to the appellant, comma, rather in contravention of clause small j within bracket, which contemplated that physical possession would be given only after salami was paid in full, comma, the respondent authorities had waived their rights to cancel the allotment for delay in payment of the balance salami. Full stop. Even otherwise, comma, it is submitted that the respondent authorities, comma, by their very conduct of not taking any steps for cancellation of the allotment order, comma, forfeiture of the earnest money, or offering the plot to another party, comma, acceded to the interpretation of clause small d, comma, so far as it related to 2 months being the stipulated time for payment of balance salami, comma, being a directory provision and time being not the essence of the contract. For sub next para, it is further submitted that during arguments before the writ court, comma, the learned counsel for the respondent's authorities himself had submitted that in respect of some of the plots in Salt Lake, comma, the time for payment of balance salami was extended for a period of 25 years. Full stop. By such conduct, comma, even if no specific right on the ground of parity accrued in favor of the writ petitioners stroke appellants, comma, the respondent authorities proceeded on the premise that time was not the essence of the contract and the stipulated time period for payment of balance consideration, balance salami was relaxable. Full stop. Next para. Thus, comma, however, comma, the learned single judge, comma, it is argued, comma, reversed the position by observing that the appellants have lost their right by not paying the balance salami to a lease deed being executed in favor of the appellants, comma, whereas the jural relationship between the parties has subsisted so long by non-cancellation of the allotment order and non-forfeiture of the earnest money by the respondent authorities themselves. Full stop. It is pointed out by learned counsel for the appellants that it is the respondent authorities who sat tight over the matter, and only after an offer being made by the immediate predecessor in interest of the present appellants, comma, who also died in the meantime, comma, for regularization of the allotment and lease by payment of the balance salami, comma, the authorities woke up from their deep slumber and all on a sudden issued a cancellation letter, comma, more than 45 years after the allotment offer being made. Full stop. Next para. Learned counsel for the appellants cites Terry ওর নামটা এখানে দেখে দিয়ে দেবেন, reported at 2004 2 SCC 130 to argue on the doctrine of proportionality. Full stop. Next para. It is submitted by learned counsel that a situation where the respondent authorities are entitled to either resumption of the land or building or forfeiture of the entire amount paid or deposited comma, having regard to the extreme hardship which may be faced by the parties, comma, the provision of resumption shall not ordinarily be resorted to by application of the doctrine of proportionality. Full stop. Next para. Learned counsel for the appellant further cites a coordinate bench judgment of this court in Kavita Shah versus State of West Bengal, reported at 2023 SCC Online Cal 238, comma, where the division bench was considering a similar circumstance as the present one, where there was a stipulated time limit for making of construction on the property in question. First up, despite the writ petitioners therein having failed to complete the construction, comma, the learned division bench took into consideration of the difficulties in obtaining permissions and making such construction, and granted the relief of grant of mutation in favor of the appellant, writ petitioner stroke appellant therein. First up, next para, it was observed by the division bench that the time period stipulated for constructing the building was not mandatory. Full stop. Next para, learned counsel appearing for the appellants further draws the attention of the court to correspondences between the parties in the interregnum to show that the juror relationship was still alive, comma, both in respect of mutation as well as grant of lease. For sub next para, learned counsel for the respondent authorities vehemently opposes the contentions of the writ petitioner, stroke appellants, and argues that clause small f of the allotment order categorically mentioned that in the event the payment of balance salami was not made within the stipulated period of 2 months, comma, which expired long back, comma, in May 1970, comma, the earnest money was not only liable to be forfeited, but the allotment order was to stand cancelled and the government would be at liberty to offer the plot to any other party. First up, it is vehemently argued that unless the balance salami was paid by the allottee, comma, no possession could be handed over to the allottee, comma, nor could any lease deed be entered into with the allottee. First up, next para, it is submitted that unless a lease deed is entered into, comma, no rights accrue automatically in favor of the allottee, comma, particularly in view of non-payment of the balance salami as per terms of the allotment letter. Full stop. Next para, learned counsel for the respondents further submits that although in certain cases certain extensions might have been given for payment of balance salami, comma, those allottees might have been leaseholders. Full stop. In any event, comma, learned counsel submits that since the particulars of those other cases are not before the court, comma, it cannot be verified whether the said allottees to whom extension was given stood on a parallel footing, on an equal footing with the present appellants. Full stop. Next para. Furthermore, comma, it is argued that mere grant of such extension to some isolated persons in stray instances does not confer any right on the present appellants to have a similar benefit. Full stop. Next para, learned counsel for the respondents also submits that the communication made to the allottee, original allottee, for removal of the jungle and overgrowth of wild plants from the suit plot was given by some other authority. Full stop. That apart, comma, it is submitted, it is reiterated that mere issuance of such letters do not show that possession was ever handed over to the allottee. Full stop. Next para. Sorry. Learned counsel further argues that in view of the original allottee and thereafter his successors having waited for 45 long years even to offer payment of the balance salami, comma, the contractual period of 2 months from the date of information of the land being ready for delivery of possession has long elapsed and no legal right remains with the allottees to have a lease deed executed in their favor. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find, comma, with utmost respect, comma, that the inaction on the part of the parties has been turned on its head in the impugned judgment. Full stop. Next para. From the provision of clause small d, comma, read with small f of the allotment letter of 1967, comma, we find that undoubtedly, comma, the remaining 50% of the premium or salami was payable within 2 months from the date of receipt of the information that the land is ready for delivery of possession, comma, however, comma, non-payment of the same within such period did not entail automatic cancellation of the allotment order. Full stop. The language used in clause small f, comma, the default clause, comma, is that on failure to make such payment within the prescribed period, comma, the earnest money will be, the power double inverted, liable to be forfeited and the allotment order cancelled, double inverted clause, and that the government would be at liberty to offer the plot to another party. Full stop. The use of the expressions double inverted liable to be double inverted clause and at liberty to double inverted মধ্যে indicate that the cancellation and forfeiture would not be automatic but would require a further step to be taken by the government in that regard by specifically forfeiting the earnest money by a positive action and also cancelling the allotment order. Full stop. Next para. In the present case, comma, the jural relationship on the strength of the allotment order was sustained by the inaction on the part of the respondent authorities to actively forfeit the earnest money and stroke or cancel the allotment order. Full stop. There is also nothing on record to show that the plot in question was ever offered to another party. Full stop. Next para. Thus, comma, in the absence of any specific action taken by the government to the end of cancelling the allotment order, comma, the said order has still sustained. Full stop. The government, the respondents, comma, by their very action in the interregnum of giving a hearing to the appellant for the purpose of mutation, comma, asking for documents, comma, and specifically giving out that the mutation application made by the appellants were in consideration and were being processed, comma, even the government proceeded on the notion that the allotment was still subsisting, comma, despite the non-payment of the balance 50% of salami by the appellants. Full stop. Next para. Thus, comma, it is not the appellant's inaction in not paying the 50% balance salami, but the inaction on the part of the respondent authorities in not cancelling the allotment order for the long period of almost of more than 4 decades, comma, which is germane. Full stop. Next para. In view of our above observations, comma, we find that the government was not entitled to cancel the allotment order once the appellants have asserted their right of paying the balance salami in terms of clause small d, comma, the time limit stipulated in which appears from the surrounding circumstances to be directory and not mandatory. Full stop. Next para. Even the language in which clause small d is couched, that is the remaining 50% double inverted মধ্যে will be payable, double inverted clause, comma, without any negative covenant indicating that unless the said amount was paid, comma, the allotment would stand cancelled, comma, shows the directory nature of the same. Full stop. Next para also, comma, the action of the government in extending the time for payment of balance salary to other allottees, comma, as admitted by counsel for the respondents herein in the writ court, comma, clearly shows that even the respondent authorities proceeded on the basis that the time limit stipulated in clause small d was directory and time was not the essence of the contract. Full stop. It is not a correct proposition of law that automatically, comma, by grant of certain extensions to isolated persons, comma, a right would accrue in favor of the appellants to get a similar relief. Full stop. However, comma, such grant of relief is only germane for the purpose of indicating the interpretation of clause small d and its directory nature by the respondents themselves. Full stop. Next para. Uh, Sauce for the goose is sauce also for the gander, comma, semicolon. If such relief could be given to some persons, comma, it is obvious that the relief was not granted in respect of dead allotment orders. Full stop. Unless the allotment orders in those cases were alive, comma, there could not be any scope or possibility of grant of extension of payment of the time to pay the balance salary. Full stop. Next para. Going by such logic, comma, the allotment order in favor of the predecessor interest of the present appellants was also alive and was not terminated at any point of time. Full stop. Next para. Following the principle laid down in TERI, TERI space OAT, TERI oat supra, comma, the doctrine of proportionality is to be considered in the present case. Full stop. Since the bona fides of the appellants are not in doubt, as learned counsel, comma, on instruction, comma, submits for the appellants that the appellants are prepared to pay the entire balance salary and be subject to whatever terms the court puts them to for the purpose of execution of a valid deed of lease in favor of the appellants. Full stop. Next para. In the case of Kobita Saha Supra, however, comma, the facts were somewhat different. First of the coordinate bench took into consideration the difficulties in making up a construction and the permissions required therefore, comma, giving relaxation for the time for completion of the construction on the basis of such difficulties and impediments. Full stop. However, comma, such benefit is not available to the present appellants, comma, since similar impediments do not visit the payment of balance consideration of salami. Full stop. Even otherwise, comma, no satisfactory reason for such non-payment has been given by the appellants, comma, although the same loses relevance in view of the clause itself and the time stipulated therein not being mandatory, comma, as held above. Full stop. Next para. Be that as it may, comma, in view of the above observations, comma, we are of the opinion that the appellants are entitled, comma, upon payment of the entire balance salami along with interest at the rate of 6% per month from the month of June 1970 till the date of payment, comma, for a registered lease deed to be executed in favor of the appellants pursuant to the allotment offer dated September 28, 1967, comma, which is annexed at page 53 of the stay application filed in connection with the present appeal. Full stop. Next para. Accordingly, accordingly, MAT 1183 of 2025 is allowed on contest, comma, thereby setting aside the impugned judgment dated April 28, 2025, passed in WPA 13049 of 2019, and directing the appellants to pay the balance salami in terms of the allotment order dated September 28, 1967, along with interest at the rate of 6% per annum, calculated from June 1970 till the date of payment of such balance salary, comma, positively within 4 months.
Makes
It would be huge.
Yes.
Within 4 working months from date, full stop. In the event such payment is made within the stipulated period, comma, the respondent authorities shall, comma, in terms of the allotment offer indicated above, comma, execute a registered lease deed in terms of the said allotment offer in favor of the appellants, comma, who are the heirs of the original allottee, namely Bhagavat Chaudhary. Full stop. Next para, no address to cost. Can 1 of 2025 is consequentially disposed of as well.
I'm grateful
My
to
lord, may I
Lordship.
pray for the stay of the order for a month? My lord?
After the above judgment is passed, comma, learned counsel for the respondents authorities seeks a stay of operation of the above judgment for a month from date. Full stop. However, commas,
Your lordship, yes, my lord, for a month.
for a month from date, full stop. However, comma, since we have already granted 4 working months time to the appellants to make the payment, comma, such stay would be redundant in any event. Full stop. Accordingly, such prayer for stay is refused. Thank you.
Grateful to your Lordship.
Next.
Matter cannot be hard, but on 18th September order kindly peruse. That is the crucial date, my lord. The order is to be looked into by my lord. Whether the award passed by is valid one in the teeth of the order or order was vacated.
Without that record, it cannot.
That is, my lord, crucial thing. Because then we will come under the section 24.
Ask my lord 17A, my lord, that is 11A, my lord, that is violated. After that, the new act will come. We have complied the order in every, according to our activity in opposition.
File has not been traced out. We put it after the way. What can be done? We'll seek a report from the Registrar General.
Required. Otherwise, my lord, whatever document I have annexed, I have a doubt.
But
Because
this is the
that
report
day,
of the Registrar.
Justice Sogota Mojumdar was not even elevated. The report says that on a particular day, Judge Sogota Mojumdar. I have a doubt. On that day, she was not elevated.
You have got copies of that order?
One, the slip, information slip. That indicates there is no doubt, according to me. Order which was passed, that is there before my lord. But when it was vacated, that is not.
Dispose of matter is very difficult to trace out.
Probably in the Khidirpur, it has been
Don't know
reached.
where. Very difficult. Physically, they have to do it.
But kindly make an endeavor so that this is the crucial point here.
From the report.
That is the only point, my lord.
No, not the only point. 2 points are there.
Only point.
One of the points.
Maybe. From the report of the Assistant Registrar dated December 22, 2025, comma, it is seen that the records of the original file being WP 9114 within bracket W of 1998 has not yet been traced out. Full stop. However, comma, tracing out the said file is of vital importance, comma, in view of the challenge raised in the present proceeding, comma, as recorded in the order dated September 18, 2025. Full stop. Next para. Accordingly, the matter is adjourned till January 19, 2026, when it will be listed under the same heading. Full stop. Next para. The এটা কি রেজিস্টার অ্যাডমিনিস্ট্রেশন এখন কি এলওএম যে এলো Registrar Administration within bracket L and OM shall monitor the search for the file of WP 9114 within bracket W of 1998 and furnish a report in that regard by the next returnable date. First of it is expected that the original file shall be traced out in the meantime. First of if so traced out, comma, the same shall be placed with the records of the present appeal as and when so traced out. Let us come back to this.
One request has come from my Didi to make it hard in part.
No. Very hard in part. Yes.
Malayan Appellant.
Yes. Railways were.
Railways answering.
Yes. On the their prayer it was adjourned. Are you appearing for the railways? The ladies are probably appearing, but they're in hiding. Yes. You are not for the railways.
Your Lordship, I'm appearing for only for Union of India. Mr. Brajesh Jha is appearing on behalf of the Union of India. He's in courtroom number 446. Kindly give a short pass over.
Mr. Brajesh Jha is appearing for the railways.
Your Lordship.
Railways who is appearing?
It is Mr. Jha who will responding before the learner singer.
1 to 4. Let us see who are 1 to 4.
Actually, 1, 2, 3, 4. Kindly sees the impugned judgment.
Yes, they are the
He
railways.
represented. Yes.
Mr. Jha is, yes, they were representing. They asked for time on the last occasion.
Your
মানে
Lordship,
দেয়া
short pass over.
মানে শর্ট পাস ওভার আজকে মানে তারপরে করতে হবে।
Short pass over then.
মানে আফটার গেছেন তাহলে
The matter was adjourned on November 18, 2025 on the prayer of the respondent numbers 1 to 4, comma, including the railways. First up, however, comma, even today passover is asked for. First up, let the matter stand adjourned till after the upcoming Christmas vacation and be listed in the monthly list of January 2026. First up, however, comma, it is made clear that in the event the respondent numbers 1 to 4 seek an adjournment, seek a further adjournment, or are unrepresented on the next date when the matter is called on for hearing, comma, the matter may be heard ex parte in the absence of the said respondents. Please intimate Mr. Jha of this.
Item number 39.
Yes, Mr. Chattopadhyay, what is the matter? Your writ was dismissed.
Yes.
You have given a copy to the other side. Just file a affidavit of service. Yes. Missing. Have you served checkup first? He's not sure whether you have served at all. Probably not served.
But let me, if your lordship kindly allow me, I'm sending my junior, actually my clerk.
It's a waste of time if you have not served.
No, my clerk.
You start and finish immediately. The section 5 has to be allowed first.
Yes,
How long will it take to hear the section 5, Mr. Chattopadhyay?
12 days.
12 days, even less time will be required. But you have to only serve and come back.
As your lordship.
12 days, 1 second per day. So, therefore.
No, lordship, don't calculate in such a fashion.
No, we'll not dismiss. We'll allow that. That's what.
Great. But the service is not there.
We'll calculate longer. But
no.
Or shorter.
I'm not, actually, I calculated shorter, but department calculated added another 4 days.
No, 12 seconds in hearing the matter.
No, 12 seconds.
Per day of delay, 1 second of hearing. That is what we are meaning.
Okay.
The appellant shall serve copies of Can 1 of 2025 and Can 2 of 2025, as well as a copy of the memorandum of appeal on the respondents, indicating that the matter shall be listed for hearing under the same heading on in the monthly list of January 2026. Mr. Chattopadhyay serve everything, lock, stock, barrel, will take up the section 5 and maybe immediately thereafter take up the main matter. You are just putting on. So therefore serve everything. Give the names, Mr. Chattopadhyay, in the previous. Ask it. Yes. Yes, Mr. Banerjee.
This will take multiples of 12 seconds.
Section 5.
1 day delay condoned earlier.
No, earlier condoned.
Condoned earlier.
In this matter, my lord,
I have failed in my writ petition. I am, my lord, I
beg
wanna.
Why do you want to study? You are the respondent.
no, I beg to represent 1, 2,
So why be so dramatic about that?
1 to 5, lordship.
So what?
No, there are
You're happy with up to 5.
lordship, no, because Panchayat Samiti used an affidavit.
So we can appoint Mr. Adok. He's sitting and smiling there.
Committee
He's on
used
also on the
affidavit.
we can direct him to appear for the rest.
Gram Panchayat used affidavit in the lower court.
Use affidavit.
They used affidavit, and my learned friend responded there too.
Who is the advocate on record?
Panchayat Samiti, my lord, kindly seize, my lord, the impugned order. Impugned judgment.
You are for the Panchayat Samiti?
Yeah.
He is with you?
No, he is.
Assisting. Won't do.
But they've been
Give proxy for the others also, 6 onwards. 6 to 9.
কোথায় এত ছটফট করিস আসতে
Was the advocate on record for 6 to 9?
Yes, I think I've been served him, Mr. Ki Haq. I'm told that he has been served, but I don't find anything beside his name. I don't find his name appearing in the letter of service. It's addressed to the respondent. It has got someone's signature, but I can't vouch for it. ওনাকে করেছিস কোনো চিঠি দিয়ে?
তখন মুখার্জি তো 1000 টাকা দেয়। এদিকে যারা বসে আছে তারা বেশিরভাগই তো সব স্টেটের ভাই এই ম্যাটারে ও
লম্বা অ্যাফিডেভিট ইউজ করেছো
তখন
কি রে বল সেটা এত আস্তে আস্তে করছিস কেন?
Panchayat has some role to play in the matter.
No, Panchayat was given the allegedly given that land over which I have already applied for long-term settlement. That long-term settlement application was processed by the state. There are documents galore to show that they have reached an advanced stage. Suddenly, I find that on that place, the Panchayat is saying that we have been given that land.
Panchayat is saying they have been given the land.
Yes, they have put up a board and then
they are required to
inter-departmental transfer.
এটা কি আব্দুল হামিদ মোল্লা?
Their affidavit, Pradhan's affidavit is page 260.
Who is the just check the back sheet of the affidavit. Who is the advocate? There,
Abdul Hamid Molla is the advocate on record.
Where does he sit?
He sits at Bar Association, room number 12. Even his mobile number is available. এনাকে কি ইয়ে করেছিলি?
You are passing it, giving a short pass over. Call him and see.
Yes, yes.
Just call him. Mr. Gal, do you know this person?
Shomiti.
You know this person must be on the state panel. Panchayat Samiti and all.
Panchayat Samiti also used affidavit, page 242.
So do you know this person who appeared for the Panchayat Samiti? Any of you know him?
Hamid. I have one Hamid over here. I don't know whether same Hamid.
Hamid over where?
I can show.
Common affidavit of 7 and 8. Shabadipoti and Panchayat Samiti, Gram Pradhan.
Does it look to have the qualifications to appear for Shabadipoti and Panchayat?
No,
just check that out.
No, Mr. Hamid.
Certain qualifications.
I have one Hamid in my mobile.
There's so many Hamids. Come on.
So I don't know. So and no separate lawyer for Panchayat Samiti and Gram Panchayat. Separate.
Yes, but without the Panchayat Samiti, we are at a loss what to do. I mean, if we hear out the matter, Panchayat Samiti is affected directly.
Yes, and he used a reply to the Panchayat Samiti's affidavit.
Yes, they use an affidavit and
no, but so far Pradhan's affidavit is
otherwise their rights will go if he means directly affected more than you in a different way. State in an indirect way. Panchayat Samiti is directly affected. Check up will just make it not today then, Mr.
Yes, not today would put me in a predicament tomorrow.
Not this month then.
Not perhaps on this year.
We'll say none appears for the
not this year then.
Yes. Not this month, not this year.
Absolutely right. So we'll say that because of Panchayat Samiti not being represented, we'll ask you to give another notice to him.
Yes, but there was an undertaking given by the state on the earlier occasion that should be extended. The land in question is just beside my rice mill. It is being used, my lord, for the purpose of my work, for dumping fly ash. Now, my lord, insofar as the state is concerned, if it has already granted and if it takes steps in the meantime.
No, you are granted what?
I had applied for long-term settlement of that adjoining land.
Under any open advertisement or?
No, the long-term settlement is under the West Bengal land reforms rules itself.
Achha.
There's a provision that you can apply. What are the criteria you can give? If you show that you're in possession of a land for over a period of time, then you will be granted long-term settlement of the land by the state after taking a salami and after taking annual rent from
You say that was given to them? State says Panchayat.
I have applied, that was processed, it went up before the appropriate authority. Appropriate authority found that the ADSR had made a wrong recording, came back. And thereafter I was communicated that it is under process. Suddenly, no cancellation or no cancellation is required. At least a prior notice, something to the intimation that that's no longer on, is not there. Suddenly we find that the Panchayat is purporting to say that it wants to take possession in order to make certain constructions in aid of an alleged waste management project, which is not yet been installed. Now, while we had filed the writ petition, there were interim orders during the pendency of the entire writ petition. The writ we have lost. As a result, the orders stand dissolved. They started to make certain covert attempts. Then, my lord, we came up in appeal. On the previous occasion, my lords were pleased to condone the delay. And because the state was not forthcoming or upcoming with instructions, my lords were pleased, my lord, to record an undertaking of the state. They had sought adjournment. My lords had recorded an undertaking that nothing will be done pursuant to the tender. Tender means the tender by which the Panchayat is now trying to put up things. Now that stands still today. If in the meantime they alter.
This is not at least in respect of essential commodities or something like that. For land, you can wait for some time, Mr. Gali.
Yes, so if they can just wait.
Either we restrain you from taking any further steps for a limited period, or you extend that undertaking.
Undertaking till just the day of reopening, then we can come back.
Take instruction if somebody is
Milord, it's a waste management facility is being constructed. From the affidavit of the Panchayat, Gram Panchayat.
Has been constructed.
No.
From the affidavit of the Gram.
They say it has been constructed.
80% of the construction has been made, Milord, when the Honorable
Panchayat itself is not available.
So that was on record before the Honorable Single Bench also.
So
suppressing that fact, Milord, there was
nothing suppressed.
Learned Single Bench.
Nothing suppressed.
Because on oath they said that 80% of the construction on the date of, Milord, affirming the affidavit, they said.
No.
Now, Milord, their challenge, Milord, in the writ petition is something else.
May I?
Milord, challenge your lordship.
Either we hear it now or we wait for the Panchayat Samiti. Piecemeal hearing is not done.
May it be, Milord, day after tomorrow, lordship?
Yeah.
Last day.
Last working day.
If you prefer that, we have no problem. We have to work even then.
As because, Milord,
the last working day is what
Milord,
we'll be taking up these matters only on the second half, appellate side matters.
Now, when is the second half? I'm not sure.
Hearing matter, we would keep on the last. Consciously, we won't put it on the last. If otherwise it's appearing by default, it's all right.
No, I was suggesting if immediately after reopening it.
Yes, it will appear in the monthly list is on the
list is on the 6th.
On the 5th.
5th. If it can come in the monthly list, my lord.
Friday we reopen. Next Monday is the monthly list.
If it can come then, and by that time, if they just protect me until that matter.
None appears for the respondent numbers 6 to 9, comma, who have used affidavits in opposition in the matter and have a vital interest in the outcome of the same. For sub next para, accordingly, to give a last chance to the said respondents to be represented before this court, comma, the matter is adjourned and shall next be listed in the monthly list of January 2026. Full stop, a notice along with a server copy of this order be served on the learned advocate on record appearing for the said respondents by the learned advocate on record for the appellant. In the meantime, and a receipt in that regard shall be filed on the returnable date. Please give a notice. Acha, the undertaking we are not recording then. Acha, very well. We find.
I leave it to the wisdom of the Honorable Court, Lordship.
Most unwise. We find from the records that lastly on November 18, 2025, comma, an undertaking had been given by the state that no steps shall be taken in terms of the tender in respect of the disputed property, comma, which was impugned in the writ petition. Full stop, next para. However, on query, learned counsel for the learned senior government advocate submits that there is no specific instruction to continue such undertaking as of today. It is obvious that in the event further steps are taken in terms of the impugned tender, in the meantime, the appeal will be rendered infructuous. Accordingly, we restrain the respondents from taking any further steps in terms of the tender which was impugned in the writ petition, from which the present appeal arises, till January 31, 2026, or until further order, whichever is earlier.
Qua the subject property, because there might be other properties also.
Qua the subject property.
Obliged, Your Lordship. Thank
In this matter, while I am appearing on the appeal, I am praying for not this week.
Why?
But some papers is necessary. Kindly, it is urgent for January.
Are you enjoying an interim order?
No,
no scope.
No scope. I am not praying. No scope. No.
On the prayer of the appellants, the matter is urgent till after the upcoming Christmas vacation.
Yes.
Monthly. Give your name, please. Your name and whoever is appearing with you. Sadhak, you also give your whoever is your list.
Item number 40.
But I am for the writ petition appellant.
Yes.
Sorry.
First name of the appellant was not telling. Appellant number 2. The first name of the appellant number 2 furnished in the cost title of the memo of appeal does not tally with the certified copy of the impugned order. You are requested to take steps. What is the first name of the respondent?
Yes, Surojit Shil.
Surojit is apparently not telling with
the.
Yes. First name of the appellant number 2. Let us see the certified copy, not telling you the certified copy. Certified copy to clear.
No, Surojit S-U-R-O-G-I-T.
First name of the
S-U-R-O-G-I-T. কি আছে?
আপনি মেমোটা দেখুন, মেমোটা এটা স্টে দেখছেন।
তো মেমোটাই তো দেখুন।
First name of the father of the.
Yes, that is yes.
Yes,
no.
Yes, Mr. Chaturvedi, move the matter.
No, actually, Your Lordship, in the memo of appeal.
Yes.
The appellant, the spelling of the appellant number 2 is the
RO.
Yes.
It was mentioned RA. So you have corrected that. No difficulty. Move it. Notice has been given to the outset. Check up that again. Same junior, same fate. He has to be more careful, and you have to train him. Otherwise, how can you know? Your junior, your responsible.
I can't understand how before filing the appeal, copy should be served. I think
may not understand.
I think government Peter has not taken this.
Your thought won't do, Mr. Chaturvedi. Your chamber, your responsibility, not his.
That's true. I'm sorry, man. I'm very
sorry. The appellants are directed to serve.
I'm sorry.
No difficulty. The appellants are directed to serve copies of the stay application as well as the memorandum of appeal on the respondents, indicating that the matter shall be listed in the monthly list of January 2026.
Sorry, but again, I'm sorry.
No, we are sorry because you come prepared and we can't take up the matter. But
sorry,
these matters can be disposed of if you give notice.
Yes.
Well, I'm appealing for the petition. Well, I'm praying for after vacation.
Refused. Move the matter. What is the matter? Your put off seeking adjournments is over.
On the earlier occasion, well,
no, not earlier days. You have asked sufficient adjournments. Now you have to start matters. Yes.
Adjournment was out for not at our instance.
What is the matter?
Well, the impugned order. Well,
not in this matter. In general, in profession, your quota of seeking adjournments is over. Now you have to start arguing.
Yes.
Yes. What is the matter? What have you challenged?
Yes, well, the impugned order is the order.
What is your full name?
Well, Vishwarup Chatterjee.
Yes, Mr. Chatterjee, please start.
My lord, I have come before your lordship challenging the impugned order dated 8th September 2025, passed by the my lord justice.
Name is not important. What is the matter about?
Yes, so the impugn order has been passed without giving the opportunity to the petitioner to file an exception against the report which has been filed by the state
By
respondent.
itself, that is not an illegality unless you sought specifically for.
Yes, and there is a specific allegation. The allegation is that we have suppressed a material facts in the writ petition, my lord. The suppression is not at all taken place at our instance, my lord, because the writ petition has been filed in seeking, my lord, the consideration of the applications filed by the petitioner before the state respondent, my lord. That was not considered.
Representation for what?
Representation for granting minor lease.
Minor lease. Let us place the impugn order. Let us see the impugn order first. This report referred to in para 2 and another report at para 3. So both the respondent state and the respondent of 4 authority filed reports.
Yes.
So those reports must have been served on you.
Not served, my lord.
Not served at all.
Not served at all.
Have you pleaded it anywhere in your stay application? Let us see. Or in your grounds. Oh, you have stated in the first ground.
Yes, my lord.
That no report was ever served on you.
And 25,000 cost has been imposed upon the petitioner.
Let us see the rest of the variable. On the basis of those reports, the order has been passed.
Yes.
That there was suppression. Yes, Mr. Kali, why shouldn't you set it aside and remand? Asking you, not because of his age, but he has argued well. That is the only point.
Milord,
that those are the basis of the findings apparently.
As because, my lord, Honorable single bench was of the view that whatever was the contents of the report, that is one agreement, deed of lease.
Whatever it may
which,
be.
my lord, incidentally, he was a signatory to that.
He had to have a copy of that. If you have any document to show that, yes, there were, you had.
Certainly not.
No, not so. Then no, definitely. No. Because court makes caustic remarks.
Paragraph 22, if your lordship may
22.
Yes.
Yes, 22 is where we are.
Astonished as to what prompted the writ petitioner to suppress such factum of execution registered deed lease
as passed
29th May 2014.
And these were revealed by your report only.
Yes, this agreement, as because this deed of lease was a lease which was entered into between the state and the petitioner.
Well, we completely agree with you. Maybe these have some German bearing if suppressed, but they had to have an opportunity of giving a rejoinder. There may be several reasons why. The present writ petition has been.
Milord, may I serve that report, Milord, here and now to my lord?
No, not here and now. We'll direct you, Mr. Galib. It's better to serve with a receipt. Because that will be formal, and tomorrow Mr. Chatterjee will not be there. There will be some other counsel. He'll be denying that a copy has been served. So it's not about counsel. You keep a receipt because you may change tomorrow. He may change tomorrow. Some other counsel may be there who may deny. So keep it filed by getting a receipt. Miss De Dhaval is in court.
Yes.
Mr. Bishwarup Chatterjee, appearing with his senior Miss De within bracket Dhaval, submits that the present appeal has been preferred on a short conspectus of the matter. For next para, the learned writ court, the learned single judge, while dismissing the writ petition of the present appellant by way of the impugned order, made caustic remarks as to suppression of material facts in respect of purported documents which were furnished before the writ court by the respondent number 7 authority and respondent number 4 authority by reports prepared by the said authorities. For next para, it is categorically alleged in the memorandum of appeal and submitted by learned counsel Mr. Chatterjee that no copies of such reports were ever handed over to the writ petitioner stroke present appellant. Full stop. Next para. It is further submitted that the learned single judge himself was pleased to direct previously that the respondent state and the respondent number 4 authority would submit their report within 2 weeks from July 31, 2025, and exception, comma, if any, comma, would be filed within 1 week thereafter. Full stop. However, comma, in view of no copies of the said reports having been ever served on the writ petitioner stroke appellant, comma, the opportunity of filing exception thereto became illusory. Full stop. Next para. Since the learned single judge relied almost solely on the annexures and contents of the said reports to castigate the appellant and dismiss the writ petition on the ground of suppression, comma, we are of the opinion, comma, upon hearing learned counsel for the parties before us, comma, that an opportunity of controverting the contents of the reports and their annexures was necessarily to be given to the appellant prior to disposal of the writ petition. Push up. Next para. In such view of the matter, MAT 1596 of 2025 is allowed on contest, comma, thereby setting aside the impugned order dated September 8, 2025, passed in WPA 20934 of 2024, and remanding the matter to the learned single judge for the purpose of re-adjudicating the writ petition, comma, upon ensuring that copies of the reports and other materials relied on by the respondents are served in advance to the writ petitioner stroke appellant, and an opportunity of filing rejoinder thereto, comma, at least for a fortnight from such service, comma, be given to the writ petitioner before disposing of the writ petition afresh on merits. Full stop. Next para. It is made clear that the merits of the matter have not been entered into by us, and the learned writ court will be at liberty to decide the matter afresh, comma, without prejudice by the observations made in the impugned order dated September 8, 2025, comma, upon giving such opportunity as well as opportunity of hearing to both parties. Full stop. Next para. No address to cost. তার আগে একটা জিনিস, can 1 of 2025 also stands disposed of accordingly. No address to cost. Urgency. Thank you. Once you have opened the khata, then continue. Yes. Yes.
I appear for the appellate.
Yes, Mr. Ghosh.
I made a mistake in the trial court, the restoration application. Mr. Ghalib was there, and 7 judgments were cited, and I thought I was through, but it was dismissed. So I don't.
Restoration was dismissed.
Restoration was dismissed. So
it's appeal against that.
Appeal against that. So
Yeah.
only.
Yes.
It's a simple matter, but I don't want to fall again. I need to consider the judgments a bit more. If your lordship takes it up after the vacation, there's no interim order anymore. Only my money is lying with them. They returned it. It was an allotment of a land to build a petrochemical complex. And they cancelled it. They returned my money. I returned the money to him, thinking that in 2007. So that would be the only issue. 20 crores we have spent already on that. And the 10 crores was returned to me. But in my confidence, I've returned it back. But then the writ petition got dismissed during COVID.
Second wave.
Second wave, 2021. So I was only, since there are so many decisions there, I just wanted to
don't take a risk.
Don't take another second chance. And some of your lordship's judgments also have been reading that the quality,
that will
the quality
but
of
the other judgments would be more risky. Then we are putting it on the monthly list of January. Then we are reopening on 2nd. We'll put it on 5th. Mr. Ghalib, no difficulty.
Can it be after the 10th? I'm sorry.
Why can't
if your lordship,
prayer, whatever you choose.
Then
we'll put it on the on 12th of January, the week after that.
Holiday, I think.
Oh, 12th January is a holiday.
17th then, or 13th, or whichever date.
So we'll keep it on
17th.
17th is a holiday, Saturday.
The Monday, your lordship takes it up on Mondays, I'm told.
17th of January is a Saturday.
Oh, I'm sorry. Then
Saturday.
Which is the next week after 10th.
The first
11th.
reopening week is 5th.
18th.
Second is a Friday, we are forgetting that. 5th is the next Monday. Second Monday is 12th.
After 10th is
Any day.
12th.
আমার 12 তারিখের পরে যেদিন 19th then.
19th then you agree? On the prayer of learned senior counsel appearing for the appellants, let the matter stand adjourned till January 19, 2026, when it will be next listed under the same heading. Thank you.
Obliged.
Thank you.
Item number 45.
My lord, we are here, my lord.
Yes, Mr. Adhikari.
My lord,
this is that matter you had mentioned on the last occasion. So it's now taken up.
it is the pleasure of
Yes, yes.
that your lordship.
Acha, Mr. Adhikari, there are two defects. You have to, we'll give you liberty, you can do it during the course of the day.
My lord, in the course of the day.
Two defects we are just telling you. One is, there is no preamble. No preamble at all. Not expected from your chamber, sir.
My lord, it is not my chamber, but as a counsel, my lord.
Acha, very well. You just see the memorandum straightway with memorandum appeal before the.
It has been
before the ground.
Second brief, my lord, that it has come to.
There is nothing, no memorandum. You have to put in an additional sheet probably.
My lord, that I think that I will.
Mr. Adhikari, okay, but you do have to do it during the course of the day then.
Yes, my lord, in the course of the day, my lord. He is very competent, my lord.
That we can see.
My lord, he will do today in the course of the day.
And the other, the memo of appeal needs to be classified in words. You have stated MAT number. Memorandum of appeal from original order. You have to state that. Memorandum of appeal from original order. Please supply some memo in other appeal. Yes. Any of you please help him, give him a copy of another memo so that he gets a clue. Please take another memo and do it. We can take it up right now, but can you do it today?
Yes,
you have to do it.
Do it.
We are giving the leave. Leave is granted to the learned advocate and record to rectify the defects pointed out by the additional stamp reporter by carrying out the necessary corrections to the memorandum of appeal during the course of the day. Subject to such liberty, the matter is taken up for hearing. Yes. Yes, Mr. Adhikari.
My lord, this is such a case, my lord, that there is, my lord, abuse of the process of law here.
Mr. Day and company, please take your seats. Mr. Adhikari is appearing, so it will take some time.
My lord, what happens, my lord?
Yes.
I was the successful bidder.
Yes.
My lord, in the year, far back in the year 2017. And my lord, that by spending rupees 2 crores, 20 lakhs and 3,000, my lord, I got there is sand mining lease in Subarnarekha, my lord, river. My lord, here it happens, my lord, all knows.
Mining yes. Please continue, Mr. Adhikari.
My lord, when there is, my lord, that the question of money, then there is question of mafia. And my lord, that I have spent from taking money from different sources, and I have accumulated it. And my lord, from
accumulated what? The mafia or the money?
No, my lord, accumulated the.
You have to have either.
I am the outsider.
Oh, you are out.
Means from 117 kilometers, my lord, I am to go there and I am to do it. And my lord, it was continuing well for near about 1 year. Means 2017 to 2018.
Short a renewal.
My lord, we sought a renewal not on that sense, but we are saying that when government, my lord, is primarily responsible to be reluctant enough. And my lord, that what I have heard, my lordship, my lord, that he has rightly, my lord, in some previous case, my lord, that they after great slumber, my lord, if they will remain with a particular case, my lord, I should not go in the deep of the matter. What is the reason behind? But my lord, all knows or nobody knows.
You are sufficiently prejudiced. What is the merit of them?
My lord, what happened after doing it? My lord, a man, he has come with all his forces. He is the local man. That I have got one unregistered partnership firm, but unregistered partnership deed with you, and you are to leave it to us. I have already paid some days back 9 lakhs rupees, and I have got 87.5% of the total share. However, with all these hooliganism, my lord, that the
License was given to you personally,
my lord, under
not
the
to any
Government
participant.
Grant Act. No, under the Government Grant Act, my lord.
So that's a personal dispute between him and you.
Yes, my lord. And
Then
that
what-
has been observed by first of my lord, Honorable Justice Subra Ghosh, and my lord, that the sitting in single bench, and it was affirmed by the Honorable Division Bench, my lord, that the under the leadership of my lord, under the presiding judge, or it is balanced.
What was the
My
objection
lord,
to come up
the
that?
observation there was that the
So
there
what
is
had you
nothing-
challenged then before that court?
my lord, that we have challenged before that although there is a partnership firm, but it is an unregistered firm, it cannot be enforced, and there was no such touch with it, and only it is a hooliganism for us. We informed the BLRO concerned.
That's a private dispute, civil
That
dispute.
is the private dispute. That's the holding of both the, my lord, that the
What is
honorable
the inaction
secretary-
on the part of the state?
my lord, that the
What
state,
has the state done?
my lord, that the state admitted here in the court, but my lord, going outside to the court, my lord, that they sat tight over the issue. And my lord, that the many reasons came.
What issue? You were functioning, you said.
My lord, no.
What did they set tight on?
My lord, carrying order was not given to me, was not issued. My lord, they were, my lord, that the giving to such a deed, which is already written by, means as a unregistered one before the, means under section 8 of the Partnership Act, my lord, it must have to be registered under before the register of firms. But my lord, that
partnership has to be registered.
My lord, and my lord, that if it is not, then my lord, it will not get any validity under section 69 of the Partnership Act. My lord, that being the position, my lord, and when
State did what? They relied on that partnership to do what? What did
they relied on that very partnership deed,
to do what
even
to
after
you?
2 orders from this honorable court.
What did they do to you?
They did not issue the carrying order.
For those
For those, my lord, sand mining, my lord, that they understand, my lord, that
So what happened in the last round of litigation?
in the last round of
The
litigation, my
Banerjee
lord,
bench directed what?
my lord, that that the carrying order there is, it is a private dispute, and there is no hindrance, at least that the two continue, that very particular one means that.
Then?
And thereafter, my lord, even when we have knocked at the door of the administration, and my lord, concerned BLRO, and my lord, that then there was the ADM. Then, my lord, even then, my lord, they, my lord, did not take any action on it. They sat tight over the issue. Years together, my lord, when my means all these amount are there, and my lord, that they even that very particular property means sand leasing, my lord, at the cost of the government revenue, my lord, under the Government Grant Act, my lord, under the seal and signature of the governor, my lord, government took responsibility, and my lord, that when it is there, my lord, I can convince, my lord, all the judgments are there. The government is also as a protector to protect my interest, because that I am successful with that, and I am successful doing, and there is nothing at all, no embargo. It's a private dispute, even if there.
What is the prayer before the writ court now?
My lord, the prayer before the writ court, my lord, that the order when they were, my lord, we filed an application on the basis of the division bench and single benches order. My lord, before the
application for what?
Application for,
Seeking
my lord, for issuing carrying order.
Carrying orders.
Then, my lord, that if the carrying order will not be issued to me, then it is not such. Then, my lord, 2000 up to 2022, it is there. My lord, in the year, if your lordship will kindly take pen to go through the page number 150.
121.
121, my lord. Very sorry, my lord. My lord, in the meantime, my lord, that very particular gentleman, private respondent, proceeded before the, my lord, London lower court.
Civil court.
Civil court. Civil court, my lord, that was dismissed.
Filed a suit for what?
Suit for, that means that for a declaration that that this is a valid such and such, and for injunction, but everything was going to hell.
Suit was dismissed.
Yes. Suit was dismissed.
On contest, on merits?
On merit, no means dismissed for default. They did not turn up.
This is a default.
Default, and they have not hired, my lord, since, and therefore that it was observation of both the courts.
You have served them also here, must be parties here also.
My lord. Yes, my lord.
Who is appearing for them?
My lord.
You are appearing for the private. No restoration filed to that suit?
No, actually, lordships, what they order they had.
Anyway, we will come into it. No restoration filed. We'll come to you.
For long,
We'll definitely hear
long 3 or 4 years, my lord, that they did not take up. It
Right.
means that they knew very well that there is no case at all. Then
Right.
in administrative means rather to create pressure upon the administration, they did, because that they were very influential persons. My lord, I should not say in some odd way, but I must have great respect to all persons. And also, my lord, that how it is such, they could not explain, and they did not proceed also. In these circumstances, my lord, a fraudulent letter was placed before the BLR, means concerned local authority, that it is such, and let us continue even after losing all this. My lord, that we raised the dispute that it is not my signature, and you should not take up all these things. Whatever may be, my lord, if your lordship will kindly see then what happened? Then there was before the ADM LR, my lord, the competent authority, at least that to continue the sand mining, etc. We proceeded in the year 2019. Thereafter, my lord, they kept, my lord, that this very particular file was placed in such a way, even if we knocked every door of every administrative authorities, including that, even also the higher authorities, my lord, they did not pay heed to it. Ultimately, my lord, what happened? I am giving very short versions so that, my lord, they all are waiting in the queue. Your lordship are very gracious, at least, to give me time. Therefore, my lord, that I don't like to, at least that we consume the valuable time of your lordship. It's only some particular points, if your lordship will kindly see. Then, my lord, if your lordship will kindly see, then when we submitted the letter, my lord, it is appearing in our CAN 1 application of 2025, the relevant one, where I have paid before your lordships, at least at this juncture, because that they are giving lease to somebody else, and my lord, that the immediate, my lord, step for that end, for the limited prayer, my lord, with this very narrow pedantic Kevin crippled, my lord, that the purpose I have come before your lordships, not to disturb, but my lord, to get justice. My lord, kindly, if your lordship will kindly see, then on 25/10/2019, as I have stated, that the forged letter submitted to BLRO, and my lord, that it is page 120.
Your renewal was refused on the ground. Your renewal was refused that you illegally entered into a partnership agreement.
Yes.
Against that, you challenged the writ petition. What was the finding of the learned trial judge?
Learned trial judge, there is a policy. Your lordships are well aware that
policy with the judges, or
policy of the policy is a guideline until and unless there is statutory punch. 2016 mining, my lord, that the mines and minerals concession rule 2016, 2002, my lord, it is a subordinate legislation, and my lord, that was violated, and only on the basis of it, my lord, the appellate authority, statutory appellate authority, just at the fag end, my lord, they passed the order, the authority concerned passed the order that, well, you are not entitled to get it because you were guided by the 2021 policy guideline. But, my lord, even if for the sake of it, my lord, it is also with us, the policy guideline,
yes,
my lord, did not, my lord,
apply to us.
My lord, not only that it did not apply because that in 2017, nowhere it has been stated that it will have retrospective effect. And, my lord, that when we have proceeded before the, my lord,
but you asked for the renewal after that came into force.
No, my lord, that beforehand, my lord, that we have done that, the after, my lord, we are doing anything. We are doing all the things in the meantime we cannot do.
Even the renewal was, application was filed before 2021.
Yes, my lord, that we are continuation of it. My lord, in any form, my lord, it's a technical one.
No, it's a different argument that it's a continuation. But the renewal application was filed after 2021 rules came into force.
Yes, my lord.
But you said it's a continuation of my rights.
Lord, on that. And, my lord, that was rejected, that on the policy of 2021, it can't be possible.
2022.
But apparently it was rejected only on the ground that you committed irregularities.
My lord.
Including this entering into this illegal partnership agreement and something else also.
No, my lord. Nothing come in the way. There is nothing, no stigma, nothing of any sort. That means that, well, for these reasons, a man is coming with all the persons. I have got little control over that very particular site from 110 kilometers, my lord, that is from the spot, my lord, near in one place of, my lord, such Hooghly or something, my lord, I had to go there. And, my lord, it happened in the Jhargram, my lord. It is such a place, my lord.
Therefore, my lord, what we have to say, my lord, I don't like, my lord, that we need. My lord, the first law point is, my lord, whether a particular means a partnership deed means when it is unregistered, when it is between the two, and when there is a specific dictum, and the law has been well settled by both the single bench and division bench, then, my lord, that the whether.
So you say the firm is unregistered, therefore that cannot have any material.
Material, it is private dispute, and it is the specific holding of the both the honorable courts, honorable single bench and the honorable division bench. And, my lord, what happened for the more painful, my lord, when they were sitting tight of the issue, then, my lord, that even against the divisional bench's order, then we proceeded before the, my lord, honorable high court. And honorable high court, my lord, taking the very particular responsibility that, well, you do as per the law, it has got no back of it. Therefore, 3 times I had to come here, or they had to come here in this way. My lord, law became clear that it is such. Now, the only point they raised throughout, it is the first part of it, that the partnership deed. And, my lord, the partnership deed, admittedly, my lord, it is already on record, that partnership deed has got no value if it is not registered. We may be unregistered party. It cannot be means such, but
it cannot be registered. But the farm has to be registered.
Farm has to be. That has not been done. That is like there are 58 to 59. It is such that it cannot be. But the government has given it how it can be when we have got the is under the Government Grant Act.
But
non-registration and governor is there.
Non-registration of the firm debars certain rights under 69.
Yes.
But that does not mean that the partnership firm that the partnership is not in existence.
That we are not saying.
An unregistered firm also.
Yes, they can do.
But they cannot
when there
be
is
sued in their name and those things.
Yes, but, my lord, that whether the government will take any cognizance on that very particular partnership deed when it was not means by the means registered or not, and that has been properly, my lord, that they taken up into consideration, and they did not raise, they admitted it. This was the story, my lord. Now, if that is such, the only way comes into play, that is the policy guideline of 2021-22. My lord, law, until and unless, my lord, that your lordships are well aware, they are a series of judgment. If there is no means subordinate legislation, my lord, your lordships are well aware, my lord, that it's the 1957, my lord, that under the Act, my lord, Mines Minerals Act, my lord, subsequently it was amended, my lord. My lord, 2002, there was the mining concession rules. And, my lord, thereafter, my lord, 2016, my lord. And, my lord, even, my lord, 2022, my lord, that was the, my lord, means in that very particular, my lord, that the rules, my lord, nowhere it has been stated in which way, my lord, the government has treated it, even the supreme authority, that is the appellate authority. And, my lord, when we have knocked the door of the honorable court, my lord, before the honorable single bench as a last round, at the last round, my lord, then we have been that, well, it has been such government policies here. If your lordship will kindly take pain to go through, my lord, the impugned order, my lord. My lord, it is there, my lord.
If you are following from the memo, you can refer to the internal pages.
My lord. Oh, yes, my lord. That is, but, my lord, that
you can refer to the internal pages of the order.
Yes, my lord, maybe, my lord, that when I am here, my lord, if your lordship will kindly take pain, my lord, that there, my lord, what is there, my lord, it appears to this court, my lord, the page 136, my lord.
No, the internal page, please refer.
Page 136. Internal page 6, 136. Continuation page. Page 6. Page 6 of the. Page 6 of the.
Yes. Paginations are at the top, internal page.
My lord.
Yes, page 6.
My lord. Page 6, my lord.
Yes.
Take page 6.
In considered view.
My lord, venture, my lord, that the venture to consider the correctness of.
You are reading from which paragraph, Mr. Adhikari?
My lord, that if, my lord, that from the top, my lord, it will go, and, my lord, that if, my lord, that further, my lord, will go to the bottom portion of paragraph 17, my lord, and
if,
my lord, 5. Paragraph 15, my lord, that if your lordship
inner page 5,
inner page 5, my lord, there, my lord, then there will be a chain of story, my lord, that it will come, my lord, to your lordship's knowledge, my lord, I don't like at least to the. It further appears, paragraph 15, it further appears to this court that the respondent number 6 oblique authority.
Mr. Adhikari, could we request you to place from para 13 because that takes care of the entire consideration. Yes, please place from para 13.
My lord, it is better, my lord.
Better because otherwise you'll have to come back.
On careful consideration of the interior materials as placed before this court, it reveals that on perusal of the order dated 25/7/2022, the respondent number 6 authority, while considering the representation of the writ petitioner for extension of the term of lease, have come to a finding that they are occurred gross and willful violation of the terms and conditions as mentioned in clause 14 and 15 of the part 7 of the lease deed, as has been executed in favor of the writ petitioner, and rule 22 of the said rules of 2016. It is with me, my lord, it has been interpreted. We have already brought it to the notice of the Honorable Court also. My lord, at the instance of the writ petitioner, in view of the fact that without informing the lessor, that is the respondent's state, and its instrumentalities, the writ petitioner has entered into a partnership agreement relating to the subject matter of lease, that is excavation of sand from the leased out area of the Subarnarekha River. My lord, in practice, my lord, that the nothing from where, my lord, there is no material substance behind it, my lord, that if it is so, then it would have been recorded by the Honorable Division Bench and the, my lord, Honorable Single Bench, and thereafter Division Bench, my lord, the Honorable Justice Subrahus and Honorable Justice, my lord, the Division Bench presided over by Honorable Justice Audit Banerjee. There was clear, my lord, again it was repetition here. My lord, then paragraph 14, my lord, it further appears to this court from the order dated 25/7/2022, my lord, 25/7/2022, my lord, that the respondent number 6 authority also came to a finding that the aforementioned act of the writ petitioner attracts penal provision under Rule 50, clause 6 of the said rules of 2016. My lord, we will show, my lord, under no circumstance it is coming, but it is there set, which postulates imprisonment up to 1 year with fine up to ₹20 for contravention of the said rules of 2017-16. Even if for the sake of argument, my lord, there is such, but nowhere it has been taken. That means that if what amount with the governor when you have done, then it can be it can be cancelled. Therefore, my lord, that the pre-criteria is where, my lord, that they would have used it, they would have, my lord, forfeited my amount. Nowhere, my lord, there is any whisper that the well, for committing this offense, we are proceeding, and your entire 2 crore, 20 lakhs and 3,000 rupees are forfeited, and you are nowhere there. Even till date, my lord. My other side is also here, my lord. There is no whisper, 7 except, my lord, rejecting that the how that very particular amount, huge amount, and how this very particular, my lord, when the governor is the other side, and my lord, under the Government Grants Act, my lord, it has been between me and the government, my lord, that nowhere it is such. Therefore, my lord, that it is such an one, it is a criminal one. Even if that, my lord, nowhere it has been stated, there is no whisper, and my lord, nowhere, my lord, they have been, my lord, satisfied the earlier courts, my lord, that yes, apart from it, there may be, means it cannot be continued. Therefore, my lord, that it is such, my lord, crux of the entire rules, my lord, it is such. Therefore, even if for the sake of argument, my lord, that it's a, my lord, that it's a consequential, my lord, they would have stated to us why they kept mum, why they did not, because I cannot write down properly. I am a businessman.
Even if there is a penal provision, they could not have refused renewal.
Yes. And not only that, my lord, they have not initiated, even if under Rule 2016, my lord, means the Mines and Minerals Concession Rule, if they are depending, my lord, then, my lord, it was the duty, even if for the sake of argument, that on the basis of it, the rules say that we have already returned you entire money, or we are forfeiting it, and it's such no whisper even till death. So, my lord, then in the very particular paragraph 14, it is clear, my lord, that it is only penal provision that means upon means other proof of it, because it happens there, and the rules my lord, that because of, my lord, passing of days, my lord, the land mafia, my lord, where, my lord, that the sand mafias, they are known, my lord. We also get it, my lord, that in city, my lord, we get it, my lord, that pay 16,000, you get it. My lord, it's free of cost, they do get. And my lord, where it is such, then they will do. But my lord, whatever will do, my lord, and the mining rules are there, the concession rules are there, and my lord, there is, my lord, that the already mining act are there, nowhere there is permission. Therefore, my lord, and therefore, my lord, they kept they kept mum and did not take any action, at least to, my lord, close it that we are not entitled. Only saying that nothing is in the way, at least nothing to create hindrance, but because you are right, position is right, you can definitely you are, but only there is hindrance that 2021 policy, 2021 to 22 policy, it is only an embargo, at least to extend it, to renew it, or to means rather to compensate that for which purpose it is such. Nothing that I am saying.
Yes.
Now, my lord, if your lordship will kindly
Para
see,
15.
para 15, my lord,
Yes.
it further appears, my lord, it further appears to this court that the respondent number 6 authority also noticed, my lord, the appellate authority, that the period for which the writ petitioner could not excavate the sand from the leased out area is not owing to the inaction or non-action on the part of the respondent authorities. It is a vital point. Non-action, my lord, that if the government has not taken a solid stand, then how the people at least will come to know that, well, as per the rules you are to take, and then it is such, then all will come to know. And my lord, he is a mere a businessman. He resides, my lord, 110 kilometers, and also even, my lord, that he is also, my lord, that they are not so educated, my lord, even, my lord, that the only, my lord, that the minimum qualification is such. Maybe that means God is with all of us, and to say on this. Therefore, my lord, leased out area is not owing to the inaction. I am insisting on this very particular part. My lord, if, my lord, that there is no inaction, this was what has been, my lord, the court has come to the definite conclusion how to reject the such and such. Therefore, my lord, his lordship, my lord, has made up the mind in this way and manner, which is going contrary to the material, my lord, that the particulars of the case. And my lord, it is not, my lord, I am saying, my lord, and I have already stated, my lord, in my appeal, and my lord, appeal, and my lord also, my lord, in my this application.
Yes.
Now your lordship will kindly see, my lord, and on non-action on the part of the respondent. My lord, non-action, inaction, it is synonym. My lord, therefore, my lord, that the what positive acts? Government cannot be reluctant. Government cannot be sitting tight. Government is to explain everything. Court is to rely upon the governmental activities.
You complete the sentence, Mr. Adhikari? Complete the sentence, yes. Complete the sentence.
My lord, yes, my lord. Inaction, my lord, authority also noticed that period for which the writ petitioner could not excavate the sand from the leased out area.
No,
is
para 15.
Para 15.
Period for which could not excavate is not owing to the inaction on the part of the respondent, but on account of some civil litigation which has been invited by you.
Some civil litigation. What else is there when there is a specific finding of all the benches of the my lord, and they did not proceed before the Honorable Supreme Court, my lord. My lord, then, my lord, when after considering all these aspects, my lord, but on account of some civil litigation which has been practically invited by the writ petitioner, I may invite many things, but whether it comes within the clutches of it, that is to be. Therefore, my lord, that the law and rules, my lord, legislation and subordinate legislation, my lord, that what is my limit and where I am to do all these things.
Was there any injunction order? Why you
No, my lord, at the very beginning, my lord, that the moment after, my lord, excavation of, and my lord, after the carrying order, my lord, we are continuing. Then, my lord, he proceeded first there.
So why couldn't you excavate for a period?
Because of there, my lord, that and the government's inaction.
What inaction?
Inaction means we have already stated. That means we were not allowed at least to excavate.
Carrying orders were not being permitted.
Yes. Carrying orders. And it is a duty to protect me, because that when there is such, I have paid good amount. I will not go there at least that to have a tussle with the local. My lord, there are very many, my lord. I have also done cases also even in Calcutta port, etc. Whatever may be, my lord. Your lordships are well aware. I should not say. My lord, that when there is such, then yes, some people will have to, yes, put here. So many businesses have done in this way. Otherwise, my lord, we will do. My lord,
1010, the interim order of the civil court.
My lord, if, my lord, that if your lordships kindly take pain to go to means page 110 of the, my lord, of the application. My lord, page 110, there we have stated clearly, my lord.
Mr. Odhikari, should we complete the order and then go there?
My lord?
Should we complete the impugn order first and then?
Yes, my lord. Yes, my lord. That will be better, my lord.
That will be
That will
easier.
be-
Yes. Then you'll cite one by
Yes.
one.
My lord, therefore, my lord, but on account of some civil litigation, which has been practically invited by the repetition. I may have invited, but what is with that? How it comes, my lord, as an embargo, under which rules?
Make your arguments after please. Yes.
Then, my lord, paragraph 16, my lord, as noticed herein above, that the writ petitioner felt aggrieved. As noted herein that the writ petitioner felt aggrieved with the said order dated 25/7/22 as passed by the respondent number 6 authority, and thus preferred an appeal under Rule 51 of the said rules. Therefore, I am within the ambit of the law. Rule 51, as per the rules, I have proceeded. Under Rule 51 of the said rules of 2016, before the respondent number 4 authority.
Divisional Commission.
That is the divisional commissioner, my lord. It was under Rule 50, my lord, I have 51 I have given. Means that nobody should be condemned at her, and the Supreme Authority, they will see. My lord, there is, in this way, my lord, this legislation, subordinate legislation has been made. My lord, paragraph 17, my lord. As rightly pointed out by the learned advocate for the writ petitioner, that while disposing of the said appeal, the respondent number 4 authority, though did not make any venture to consider the correctness of the findings of the respondent number 6. My lord, here it is, my lord, that we have to put, my lord, that is some stress we will have to put. My lord, that means that the respondent number 4 authority did not make any venture to consider the correctness of the findings of the respondent number 6 authority. Therefore, my lord, that the appellate authority, my lord, that when it is a merit on, my lord, it is an appellate authority, then, my lord, it will be decided thoroughly and properly, considering all and each aspect of the matter. And my lord, Rule 51, and my lord, so many judgments, my lord, that is in support of us, my lord, that, and my lord, it is to be done as per the that subordinate, that per the Rule 51. My lord, there is, my lord, there is the self-admission of this honorable court, my lord, of the honorable court, my lord, of the honorable single bench, in its order dated 6/4/2013, 2023. However, the respondent number 4 authority practically banked upon some of the provisions of the West Bengal, my lord, West Bengal Sand Mining Policy 2021. How it comes into play? My lord, if 2021, even, my lord, there is also to some extent, my lord, that the considering all the present situation, my lord, as there was avalanche of, my lord, cases, there were, my lord, the attempts were made, at least from the legislative my lord, attempt, and, my lord, that
so you say that 2021 would not apply?
My lord.
Why?
Because, my lord, it is a policy. My lord, we have practically 2016 policy, 2016 rules, we are guided. We are guided by it. 2016 rules never, my lord, has been made obliterated by this policy guideline. It is the self-admission in the impugned order itself. No fire, my lord, your lordship, there is no whisper even. That means that the 2016, my lord, rules has been negated or has been criticized in such way. And, my lord, that it is not possible even. Because when there is already a subordinate legislation practically working in the field, my lord, then until and unless that subordinate legislation, my lord, a proposal which has got no statutory punch in the policy guideline itself, it is a administrative policy, but it cannot, my lord, go, it cannot overcome the mining concession rule, which is still holding the field, and nowhere there is any discussion on it, although it was stated upon it, my lord. 2021, which postulates that the period of lease shall not be renewed. Whether it can be, shall not be renewed and shall automatically be resumed and vested with the state government upon the expiry of the period of lease. I am saying, first of all, let the other side show that whether by this it is such, then there would have been another wing. That means then another critical question of law would have come into play. That means whether if such a policy will give a mandate, that means it will not continue under any circumstances, then how it could have...
This is subject to the 2016 provisions of...
I am grateful. I am grateful. I'm grateful, my lord. My lord, your lordships are well versed in the matter, and therefore, my lord, then I am saying that I am seeking
We have
for
become well-versed due to the trouble given by the people on your website.
trouble given by my lord, it is their
These
duty.
two people are
My lord,
continuous
he is my
troublemakers in our
beloved
country, and
Dada.
They have taught us the mining laws. They and some others.
Dada, my lord, that the water married, my lord, that even outside the my lord,
We knew nothing
always
about these mining.
he is our beloved Chundi Dada.
We are also here, so you will also teach us the
My
rest
lord,
of the law.
that means that if, my lord, therefore, my lord, that when they are saying, my lord, that I will invite them, let them so, I will bow down, that well it will so, and I will give some them judgment, etc. But I will not at this juncture, because we are just, my lord, that on the eve of means Xmas 18. In considered view of this court, such finding of the respondent number 4 authority is in consonance with the finding of the respondent number 6 authority in its order dated 25/7/22. My lord, going to it, my lord, if, my lord, that the whether it is in consonance with that, my lord, that what has been, my lord, stated in paragraph 17, my lord, that the when paragraph 17 it is there, is there any answer? It's such. My lord, therefore, admittedly, when, my lord, if, my lord, that when the factual aspect of the issues are there, then that is to be decided, or, my lord, they would not have been touched. Because, my lord, that when, otherwise, my lord, that the people there will be, my lord, that the right and fundamental right, whatever we will approve. Therefore, my lord, that is 17, my lord, it is quite contrary to paragraph 17, because that where it has been stated that while disposing of the said appeal, paragraph 17, as rightly pointed out by the learned advocate for the writ petitioner, that while disposing of the said appeal, the respondent number 4 authority did not make any venture to consider the correctness of the finding of the respondent number 6 authority in its order dated 6/4/23. However, the respondent number 4 authority practically banked upon some of the provisions of such and such. My lord, that the if we will go to paragraph, my lord, that the 18, then, my lord, here in considered view of this court, my lord, considered view, the moment I will say, my lord, and the, my lord, that if it is evolved in the, my lord, that there will be consideration of all the aspect of it. My lord, if it is paragraph 17, and, my lord, in the page, my lord, that where I have come in, and your lordship's, my lord, generosity and, my lord, sanctity and wisdom, my lord, that he invited that your lordship go, because that always time is precious, that I could have understood at least some days back. And, my lord, we are waiting for this case for more than 2 months. My lord, whatever may be, my lord. Now we are going, my lord, that at that point of time, that means that he will be ousted and another, my lord, auction will be taken up. My lord, therefore, yeah. My lord, now, my lord, paragraph 19.
Yes.
It appears to this court that the writ petitioner before the respondent number 6, as well as respondent number 4 authority, respondent number 6 as well as respondent number 4 authority, means appellate authority also, has miserably failed to make out a case for extension of the term of the lease. It further appears to this court that sitting in a judicial review, this court finds no incriminating material as against the respondent authorities. No incriminating material. And what are that it is to be given? What are the incriminating material? These are such. These are lacking. This is to be first, my lord. It is the system, my lord, because we are guided by Anglo-Saxon law, my lord. Nobody, my lord, that a man where ibi just ubi remedium, my lord, when there is a right, there is a remedy, my lord. Therefore, my lord, that when I have ventilated the right everywhere, my lord, then, my lord, there must have a remedy. I cannot be remediless, my lord. Therefore, my lord, it further appears to this court that sitting in a judicial review, this court finds no incriminating material as against the respondent authorities. More specifically, against the respondent number 4 and 6, they have been given clean sheet to substantiate that their decision-making process while passing the aforementioned 2 impugned orders have been vitiated for non-consideration of materials which are available on record. Now, my lord, if the record will be seen, then it will be cleared that the how chronologically we have stated, and, my lord, from the very first blast, my lord, that even up to the end, my lord, we have tried our level best. I have tried, my lord. We have not the door of justice.
The paragraphs, Mr. Just complete the rest of
my lord, paragraph 20, my lord. Then, my lord, that
it rather
appears to this court. It rather appears. Rather means has got some, my lord, that my lord, I am giving some insistence on this. It rather appears, my lord, that the respondent number 6 authority duly noticed the violation of the terms and conditions of the lease at the instance of the writ petitioner, which even attracts penal provision. Therefore, duly notice the violation of the terms and conditions. My lord, odi alteram partem is the basic principle of the natural justice. Whether they have stated only when we have filed, then they have declared that it is not such. Was it not their duty that, well, you are to be heard in this way and manner? When we have made it, though coming, my lord, that the 2 times, my lord, from the Honorable High Court's order, they remain sight, they sat tight over the issue, and my lord, they did not. Is it, my lord, that if a citizen, my lord, how far? Is it not their liability? They have taken the money. They are the officers concerned from the public exchequer, and my lord, when the party, my lord, that the
Just complete the 2
my lord, I'm grateful, my lord. Therefore, which even attracts the, but there also it is not means reflected that, well, that it can be, means therefore that it has rightly been done. No, because it was not done even. Only it is not. Therefore, my lord, at the time of hearing on behalf of the writ petitioner, no material could be placed showing unjustification on the part of the respondent authorities in not extending the period of lease as paid for. My lord, if, my lord, that the if, my lord, every paragraph, my lord, in my writ application be taken into consideration. And my lord, this application before your lordships will be taken up into consideration. As well as this, my lord, it will be seen that, well, this is such a place.
So on the next day, you will be placing the materials.
I am deeply obliged, my lord. And my lord, in course of the day, we are doing with the help of the other.
Do what?
My lord, in matter, my lord, in the next day, my lord, tomorrow, my lord, otherwise, my lord, I will be ousted, my lord. And my lord, they are doing all these things, my lord.
Should have done it quickly then. Tomorrow we have other matters also.
So, then, my lord, one thing, my lord, that the limited, my lord, that will stay be given, my lord, because that I am on the verge of, my lord, that the death, on the verge of
what
this
stay? Renewal has been refused.
No, they are taking, my lord, that the e-auction for this very particular plot of land. And my lord, we have given notice, my lord, let them
So
say.
Adhikari, then come prepared with written notes of arguments. Tomorrow we'll put it as to be mentioned. We cannot give you so much time before the vacation.
Yes, my lord, my lord. I will give it, my lord.
Give you 10 minutes time. We will give them a half.
My lord, my lord, my lord, my lord.
Lease was expired. How now we get?
Lease was expired, but when I am there since the very, I will give the written.
Cannot give so much time before the vacation.
Yes, my lord. Before I am grateful. Therefore, I was insisting that not to. Yes, my lord, that I will give written notes of argument within 10 weeks. They will also give, my lord, and my lord, that you will, my lord, that pass the order, my lord, so that it will be, my lord, that they at least will be saved, my lord. Otherwise, will be thrown out in this expansion, my lord. That I am otherwise I will not.
Tomorrow 10 minutes, Mr.
Only, not more than even 9 minutes, and the ultimatum is 10 minutes. Within 9 minutes, I will give, my lord, that the
counsel for the appellant submits that there is extreme urgency in the matter and commences arguments. Full stop. However, due to paucity of time, the argument cannot be concluded today. Full stop. Let the matter be listed tomorrow as specially fixed before the assigned matters. Full stop. It is we are assured by learned counsel for the appellant that he will not take more than 10 minutes in making arguments, keeping in view the exigencies, since the court is on the verge of closure for the winter vacation.
Both parties will give their written notes.
Of next para, both parties shall file
written notes.
Very brief bullet point written notes of arguments at the time of oral arguments tomorrow.
And my lord, the
bullet points, make bullet points.
Writ petition, my lord, we have annexed for your lordship.
The writ petition, the copy of the writ petition.
Copy of the writ petition, my lord, that the
copy of the writ petition handed over in court today by learned counsel for the appellant be kept on.
I am deeply obliged, my lord. I am
Thank
grateful
you.
to your lordship.